हेलो।
ಈಗ
हेलो हेलो हेलो।
ಅದ ಫೈಲ್ ಮತ್ತೊಂದು ಎತ್ತಲಕ್ ಆಗಲ್ಲ. ಇದು ಇಲ್ಲಿ ಇದು ಇದು ಬಿಚ್ ಇದು ಇಲ್ಲಿ ಮ್ಯಾಲೆ ಇಡು ಇಲ್ಲಿಡು ಎತ್ತು ಕೊಡ್ಲಕ್ ಬೋಲ್ಟಿಗೆ ಇಲ್ಲಿ ಇಡು ಇಲ್ಲೇ ಇಡು. ಎಸ್ ಇದೇನದ ಇದೇ ಹಾಕ್ಯದ
ಹಾಕಿದ್ದೀರಾ ಇಲ್ವಲ್ಲ ಅದರಲ್ಲಿ ನೋಡು 7 ನೋಡು ಟ್ಯಾಗ್ ಹಾಕ್ಬಿಟ್ಟು ನೋಡ್ಬೇಕು
ಮತ್ತೆ ಕೆಳಗೆ ಜರ ಇಲ್ಲೇ ಎಲ್ಲರೂ ಇರಿ.
ಬರ್ತದೆ ಸರ್ ಒಂದು ಪ್ರಿಂಟ್ ಕೊಟ್ಟಿವಿ
ಸರ್
ದೀಪ ಇಲ್ಲಲ್ಲ ಹಾಕಬೇಕು ಅಲ್ಲ ಹಾಕ್ಬಾರ್ದು ಎಸಿಗೆ ಯಾವಾಗ್ಲೂ ಇದು ಎಸಿಗೆ ಅಷ್ಟೇ ಸರ್ ತ್ರೀನಾ 3 ಆಫೀಸರ್ಸ್ reliefs are to be specific, annexures to be marked proper, eligible copy of annexure H1 to be found. ನೋಡಿದ್ರೆ ಬಂದ್ರೆ ಸಾಹೇಬ್
Kind submission. Matter for end of the list.
ಏನ್ ಮೇಡಮ್
Election to be scheduled on 3rd of this month, my lords. Yadgir TMC election,
ಶೆಡ್ಯೂಲ್ಡ್ ಆಲ್ರೆಡಿ
already 3rd.
ಕ್ಯಾಲೆಂಡರ್ ಇವೆಂಟ್ಸ್ ಇಸ್ ದೇರ್
Please,
Then
but
what
I
is
have
the-
challenged the electoral roll. This is the only remedy.
Correction in order, my lord, I had filed a writ petition, cost title wrongly shown, my lord. I have filed application for amendment of cost title as well as correction of order, my lord. Any date?
ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅವರ್ ಆರ್ಡರ್
Yes.
we have to, we'll do it today only.
page wise adjournment, page number 7, serial number 32 and 33.
My lord, serial number 32, my lord, I have sent letter along with the format of the affidavit. Madam ಅವ್ರ ಹತ್ರ ತಗೊಂಡು ಏನು ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಇವತ್ತು ಬಂದೆ ಇದೊಂದು ಟೈಮ್ ತಗೊಂಡು.
ಯಾವಾಗ ಫೈಲ್ ಆಗ್ಬೋದು?
ಅವತ್ತು ಹೇಳಿದೆ ಸ್ವಾಮಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ ತಾವ್ ಇರ್ಲಿ ನೋಡೋಣ ಅಂತ ಹಾಕಿದ್ರಿ.
ವೇಟಿಂಗ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದಕ್ಕೆ.
ಹೌದು ಸ್ವಾಮಿ ಅವ್ರು ಬಂದಿಲ್ಲ, ಅದು ಒಂದು ಫಾರ್ಮೆಟ್ ಮತ್ತೊಂದು ರಿಮೈಂಡರ್ ಲೆಟರ್ ಕಳಿಸಿದೀವಿ.
32 learned AGA seeks for and is granted a week's time, 3 weeks' time to file compliance affidavit. Relist on 30th October.
Please,
Page number 8, serial number 34 to 38. Page number 9, serial number 39 to 42.
serial number 40, my lord, I seek, my lord, 2 weeks time. ಅವ್ರ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರ ಟೈಮ್ ಕೇಳಿದ್ರು ಬರ್ದು ಹಾಕಕ್ಕೆ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಹೇಳಿದೀರಾ?
ಅವ್ರು ಸಿಕ್ಕಿಲ್ಲ, ಗಣೇಶ್ ಕಾಣಿಸಿಲ್ಲ, ನಾನು
ಇಲ್ಲೇ ಇರ್ತಾರಲ್ಲ. ಹೇಳ್ಬಿಡಿ 40 at the
ಹೇಳ್ತೀನಿ.
request of learned AGA, 3 weeks' time is granted to file statement of objection, objections if any by 30th, relist on 7th November.
ಪ್ಲೀಸ್.
Page number 10, serial number 43 to 46. Page number 11, serial number 47 and 47 to 49. For non-compliance of office objection. For first time, serial number 1, Sri Ganesh Naik.
Accepting submission of counsel for the petitioner, office objection at serial number 1 is overruled. Shri Naresh Kulkarni accepts notice for respond number 6, learned SCGB for 1 to 5. The petitioner claims that the land in survey number 312/3, measuring 3 acres 1 gunta, situated at Madhubala village, Shahpur Taluk, Yadgir district, was granted to the grandfather of the petitioner in LRF stroke Inam stroke 119-26-54 on 16/12/1981. Pursuant thereto, the name of the grandfather was entered into in the revenue records. On the expiry of the grandfather, the name of the petitioner was entered into in the revenue records. Shockingly, the respondent number 5, without issuance of any notice, unilaterally in the year 2021, directed the entry of the name of respondent number 6 in column number 11, so and so allowed.
For non-compliance of office objection, for second time, serial number 2, Sri Ravi B. Patil.
ನೆನ್ನೆ ಫೈಲ್ ಅದು ಫೈಲೇ ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ ಕಂಪ್ಲೇಂಟ್ ನೆನ್ನೆ ಫೈಲೇ ಕೊಟ್ಟಿಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇಟ್ ವಾಸ್ ಸೆಂಟ್ ಟು at 4 o'clock. A very small malod office objection.
Advocate to sign notary seal illalappa.
Right.
GPA copy.
GPA copy I have filed malod, Xerox copy is filed, they are seeking for a original, not necessary malod, original.
Defendant number 1A has not been made a party.
Malod, she is dead malod, she is a mother who was arrived as malod LRs of malod father.
Learned counsel for the petitioner has signed each page of WP. Hence office objection at serial number 1 stands complied with. Insofar as office objection number 3 is concerned, a photocopy of the GPA has been produced. Counsel for the petitioner seeks for and is granted 3 weeks time to produce a notarized true copy thereof. As regards office objection at serial number 4, learned counsel for the petitioner submits that defendant number 1A has expired. Our legal heirs are
Already on record.
As
They are the defendants to, malod the present petitioners malod.
defendant number 1A ಗೆ petitioners are the LRs are.
ಹೌದು. Earlier father was the party.
1A is
Ramanand malod, page number 18 malod,
plain tell you 1A
18
is
plaint malod.
Rameshwari.
Yeah, Rameshwari.
Ah.
Earlier father was the party, Ramanand. After his death malod, 1A to 1F were brought on record. Now Rameshwari is dead.
Submits counsel for the petitioner insofar as office objection at serial number 4. Counsel for the petitioner submit that the petitioners are the children of defendant number 1A. Defendant number 1A having expired, the legal heirs being already on record, defendant number 1A has not been made a party. His submission is accepted. Office objection at serial number 4 is overruled. Counsel for the petitioner is granted 3 weeks time to comply with office objection at serial number 2. Amele.
Malod, I have not sought for interim order because malod,
Interim order ilva.
6 rule 17 application, which was earlier allowed by the very same court.
Issue
Now,
notice
Manoj-
to the respondents returnable by 13th November. Counsel for the petitioner is also permitted to serve the counsel for the respondent before the trial court, as also take out hand delivery of summons.
Malod, the service of notice in respect of malod respondent number 3 to 5 may be dispensed because they are the co-defendants along with us malod.
4 defendants, if they, it's a partition suit,
It's a partition suit filed by the plaintiff.
they may have a difference.
Please, I'll serve the copy.
Non-compliance of office objection for fourth time, serial number 3, Sri S.S. Sajjan Shetty.
Yes, madam.
Your lordship, annexure H1 is a legible copy, filed in the vacations, your lordship.
H1 page. Not legible, madam. Last time ಬಂದಿತ್ತಿದು.
Yes, your lordship, I undertake.
ನಾವು
to
ಲಾರ್ಡ್
file-
legible ಅಂತ ಹೇಳಿ ನಿಮ್ಗೆ ಟೈಮ್ ಕೊಟ್ವಿ.
How, yes, your lordship, sorry,
ಇನ್ನ 4th time ನೀವು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
sorry. Due to illegal.
Counsel for the petitioner seeks for and is granted 3 weeks' time to comply with the office objection. Office objection, if not complied with by 29th October, the above petition will be liable to be dismissed for non-prosecution, released on 6th November. Ashtaladru Madi.
Yes.
For orders, serial number 4, Srimati Ratnesh Yogi Mutt,
I'm filing the, my lord,
Mantesh
report.
Patel.
I'm filing report, I have served the copies,
Oh,
Yes,
is
my
the
lord, we received the copies,
election.
my lord.
my lord.
My lord, the
voting.
Voting, referendum.
Hmm.
My lord, here, the other side, my lord, Mantesh Patil, my lord, parties, they have submitted the, my lord, they are not attending, they are intending to, the meeting has to be held within 20 to 30 kilometers.
Then we'll allow the petition, let them do whatever they want.
Yes, they are declined
But
to
my lord,
attend the
report-
meeting.
If you don't want to participate, you don't participate.
Yes, my lord, they have not
Even I
participated.
filed an applications to my lords, revive the earlier order.
That has been dismissed, Mr. Mantesh Patil.
Here.
Subsequently, I filed an application.
That will also be dismissed.
On submission.
There is an order passed by this court, which will have to be implemented. Coordinate bench has passed a detailed order.
Yes, my lord, one submission is, just I will make one submission. My lords. Now, earlier, they have produced the one video. There are a group of persons
You,
who.
we are not concerned with that. You did not participate.
My lords, not about this meeting.
This meeting, did you participate or did you not participate?
My lords, this meeting, what happened, my lords?
Did you participate or not? First, yes or no, anteli, amel bani.
Few of the persons were participated and given the representations of my lords, more than 1350 who have signed the with Aadhaar card, my lords,
Hmm.
to the deputy commissioner, and they submitted that, my lords, in view of the place which is Yadgir, and the date of the notice was given, my lords, in short duration, and there is some inconvenience for appearing them. Therefore, my lords, they requested to, my lords, hold a meeting. But there were 1350 Aadhaar cards with, my lord, with signatories, my lords, have signed and given the representation, and that is recorded. And that apart, my lords, one request is, kindly, my lords, one submission is, earlier what happened, my lords, they shown some video, therefore, there were 25 to 30 members were hesitating in the video, my lords. In fact, they have attended the meeting earlier, and I have, my lords, filed an application, and in the application, in the serial numbers which the deputy commissioner has earlier filed, my lords, they were attended and they have, my lords, participated in the meeting itself. And video also I have produced, my lords. Now, when we, my lords, obtained the video recorded from the devotees, the persons who are hesitating in the video were actually participated. Even we have inquired with the deputy commissioner also, my lords. By
Mr.
showing the-
Patil,
Huh?
this is a completely unfair submission that you are making.
My lords, why,
Completely unfair, which is not expected of a council.
my lords, even otherwise, what my submission is, my lords.
You were asked whether you want to participate or not. You said you will participate.
My lords, we
Then
are
you
not
go
aware
and you
about,
say you don't want, you are not going to
once,
participate.
I will make one submission, irrespective of
Coordinate
all
bench
this.
took so much pain to pass that order
My lords,
for all of your
I
benefit.
agree, my lords.
Yes,
I-
that
one
file-
I
submission
don't want
is-
to do it.
Appeal is also
One,
dismissed.
one submission is, my humble request is, my lords,
Consent order ಮೇಲೆ appeal ಬೇರೆ ಹಾಕಿದ್ರ.
Appeal ಹಾಕಿದ್ದಾರೆ.
all consent order, my lords, we are not aware about the order of the, my lords, subsequently the
ಏನಪ್ಪ ಮಾಡ್ತೀರಾ
participation
ನೀವು?
made by those persons, my lords. What we want to bring to the notice of your lordship.
We understand they did not participate. You are a council.
My lords, I agree, I am not.
File an appeal on a consent order.
My lords, I am not on that ground, appeal is filed, my lords. Subsequently, when we, my lords, inquired with the deputy commissioner,
Change the venue, they have filed the appeal.
the persons who are hesitating, in fact, participated. It's not the, my lords, that.
Not concerned with that. Did you participate in this meeting or not?
And we
That whole
some of
meeting
the
is
persons-
gone.
Not some of the persons were participated in the meeting and they have submitted the
We'll take
representations.
whatever is the vote count now to be the one which is final.
My request is, my humble request is, my lords, kindly see the report.
The,
I may be given, my lords, one day accommodation to file the.
We can't
objections
give
to
you
the
in
report.
1 day's time.
the report clearly speaks, my lord, they are interested persons, they are interested with the property of the mutt. It
Those
has
persons
come,
were
my
not-
lord.
The
They are the
ಏನಪ್ಪ
surrounding- The
ಬಂತು?
surrounding villagers of that mutt, my lord, reporter ಬರ್ದಿದ್ದಾರೆ.
What is the vote count ಎಲ್ಲಿದೆ?
My lord, vote count ಇಲ್ಲಿದೆ, page number 4 ಅಲ್ಲಿ.
Para 3, my lords.
ಪೇಜ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಶಿವಕುಮಾರ ಸ್ವಾಮೀಜಿ ಹುಣಸಿಗೆ ಇವರ ಪರ 1166 ಮತ ಜನ, ಇವ್ರ ಪರವಾಗಿ ಒಬ್ರು ಇಲ್ಲ, 0-0.
Lords, kindly
ಅವ್ರ
see page
ಅಬ್ಜೆಕ್ಷನ್
number
ಹಾಕಿ
three.
ಹೋಗಿದ್ದಾರೆ.
Kindly see the page number 3 of the report.
Yes.
ಸಭೆಯ ಪ್ರಾರಂಭದಲ್ಲಿ, page number 3.
Page number 3.
ಸಭೆಯ ಪ್ರಾರಂಭದಲ್ಲಿ ಅಂತ ಇದೆ, ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ.
ಅಭಿಪ್ರಾಯ ಸಲ್ಲಿಸಿ
ಅದೆಲ್ಲ ಸ್ವಾಮಿ ಇದು ಫಸ್ಟ್ ಪೇಜ್ ಆಫ್ ದಿ ರಿಪೋರ್ಟ್ ಪೇಜ್ ನಂಬರ್ 3.
Ink page 2.
page
Fir-
number.
first page
Last
ಅಲ್ಲಿ
page.
ಅದು page 2 ಅದು.
Yes,
The,
my lord.
the complete report
ಸಭೆಯ
has to print, my lord,
ಪ್ರಾರಂಭದಲ್ಲಿ-
then the meaning,
ಏನ್ ಹೇಳ್ತಾರೆ
ಅದಿಷ್ಟೇ ಓದೋದಲ್ಲ.
ಕೇಳಿ ಅವರು.
Lord, ಸಭೆಯ ಪ್ರಾರಂಭದಲ್ಲಿ ಆಡಿಟೋರಿಯಂನಲ್ಲಿ ಹಾಜರಾತಿ ಪುಸ್ತಕದಂತೆ ಹಾಜರಿದ್ದ ಡಾಕ್ಟರ್ ಕರಿಬಸವರಾಜೇಂದ್ರ ಮಹಾಸ್ವಾಮಿಗಳು ಉರುಕುಂಡ ಮಠದ ಭಕ್ತಾದಿಗಳ ಪರ ಶ್ರೀ ಎಂ ಶ್ರೀನಿವಾಸ ರೆಡ್ಡಿ ಮಾತನಾಡಿ, ಶ್ರೀ ನಾರದಗಡ್ಡೆ ಮಠವು ರಾಯಚೂರು ಜಿಲ್ಲೆ ಕೇಂದ್ರದಿಂದ 30 ಕಿಲೋಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಸ್ಥಾಪಿತವಾಗಿರುತ್ತದೆ. ಸದರಿ ಮಠಕ್ಕೆ ರಾಯಚೂರು ತಾಲೂಕಿನ ಗ್ರಾಮಗಳಾದ ಬುರ್ವಿಯಾಡ್, ಸರ್ಜಾಪುರ್, ಹತ್ತೂರ್, ಯಾಪಲ್ದಿನ್ನಿ, ಗಜರಾಳ್, ಡಿ ರಾಂಪುರ, ವಡ್ಡಲಪಲ್ಲಿ, ಅಪ್ಪನದೊಡ್ಡಿ, ರಾಳದೊಡ್ಡಿ, ಚಂದ್ರಬಂಡ, ಅರಸೀಗೇರ, ನಾಗನದೊಡ್ಡಿ ಇನ್ನಿತರ ಗ್ರಾಮಗಳು, ಅದೇ ರೀತಿಯಾಗಿ ತೆಲಂಗಾಣ ಗ್ರಾಮಗಳಾದ ನೆಟ್ಟಂಪಾಡು, ನಾಗರದೊಡ್ಡಿ, ದ್ಯಾಗದೊಡ್ಡಿ, ಉಪ್ಪೇರು, ಗಾರಲಬಾಡು, ಮುಸಲೆಯಪಲ್ಲಿ, ಗೋನಗುಂಡ, ಪೊರವೆಲ್ಲು, ಇನ್ನೂ ಹಲವಾರು ಗ್ರಾಮಗಳ ಜನರು ಈ ಎಲ್ಲಾ ಮಠದ ಪೂಜಾ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಮತ್ತು ರಥೋತ್ಸವಕ್ಕೆ ಭಾಗವಹಿಸುತ್ತಾರೆ. ಶ್ರೀಮಠವು ಸುಮಾರು 300 ವರ್ಷಗಳ ಹಿಂದೆ ಮಠದ ಮೂಲಸ್ಥರಾದ ವೈರಾಗ್ಯ ಶ್ರೀ ಚನ್ನಬಸವ ಮಹಾಸ್ವಾಮಿಗಳು ಸದರಿ ಸ್ಥಳದಲ್ಲಿ ತಪಸ್ಸು ಮಾಡಿ ಜೀವ ಸಮಾಧಿಯಾಗಿರುತ್ತಾರೆ ಮತ್ತು ನಾರದರು ಇಲ್ಲಿ ತಪಸ್ಸು ಮಾಡಿರುವುದಕ್ಕೆ ಈ ಕ್ಷೇತ್ರಕ್ಕೆ ನಾರದಗಡ್ಡೆ ಎಂದು ನಾಮಕರಣ ಮಾಡಿದ್ದು ಇತಿಹಾಸದಿಂದ ಎಲ್ಲಾ ಭಕ್ತರಿಗೆ ತಿಳಿದ ವಿಷಯ. ಮೇಲ್ಕಂಡ ಗ್ರಾಮಸ್ಥರು ತಲೆತಲಾಂತರದಿಂದಲೂ ಶ್ರೀಮಠದ ಭಕ್ತರಾಗಿದ್ದು ಸೇವೆಯನ್ನ ಮಾಡುತ್ತಾ ಬಂದಿರುತ್ತೇವೆ. ಸದರಿ ಮಠದಲ್ಲಿ ಶ್ರೀ ವೈರಾಗ್ಯ ಚನ್ನಬಸವ ಮಹಾಸ್ವಾಮಿಗಳು ಜೀವ ಸಮಾಧಿಯಾದ ಅವನಾದ ಗುರುತಾಗಿ ಕಾರ್ತಿಕ ಶುದ್ಧ ಶಬ್ದ ದಿನದಂದು ಮಠದಲ್ಲಿ ಪೂಜಾ ಮತ್ತು ಅಭಿಷೇಕ್ ನಾವು ಮತ್ತು ಸುತ್ತಮುತ್ತಲಿನ ಹಳ್ಳಿಗಳ ಭಕ್ತರು ಈಗಿನ ವರೆಗೂ ಆಚರಿಸುತ್ತಾ ಬಂದಿರುತ್ತೇವೆ. ಇಂತಹ ಇತಿಹಾಸವುಳ್ಳ ಮಠವನ್ನು ಯಾರು ಅಮಾಯಕ ವ್ಯಕ್ತಿಗೆ ಆದ ಶ್ರೀ ಶಿವಕುಮಾರ ಸ್ವಾಮಿ ಕೊಡೆಕಲ್ ಹುಣಸಗಿ ಇವರು ನಾನು ಈ ಮಠಕ್ಕೆ ಪೀಠಾಧಿಪತಿ ಎಂದು ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸುತ್ತಾನೆ. ಇವರ ಮೇಲೆ ಈಗಾಗಲೇ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠಕ್ಕೆ ಇವರ ಅಕ್ರಮಗಳ ಕುರಿತು ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯರಾದ ತಾವು ಮಠದ ಸುತ್ತಮುತ್ತಲಿನ ಭಕ್ತರಾದ ನಾವು ಮಠದ ಆಸ್ತಿ ನಿರ್ವಹಣೆ ಕುರಿತು ಸಭೆ ಮಾಡಲು ಈ ಮಠದಿಂದ 20 ಕಿಲೋಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಈ ಸಭೆಯನ್ನು ಆಯೋಜಿಸಿದರೆ ಸದರಿ ವಿಷಯದ ಸಭೆಗೆ ಎಲ್ಲರೂ ಹಾಜರಾಗಲು ಅನುಕೂಲವಾಗುತ್ತದೆ ಎಂದು ಅಭಿಪ್ರಾಯವನ್ನು ಸಲ್ಲಿಸಿ, ಪ್ರಸ್ತುತ ದೂರದ ಯಾದಗಿರಿಯಲ್ಲಿ ಸಭೆಯನ್ನು ಆಯೋಜಿಸಿರುವುದರಿಂದ ನಾವೆಲ್ಲರೂ ಸಭೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದ ಈ ವಿಷಯವನ್ನು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಲು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಹೊರ ಹೋಗುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ಶ್ರೀ ಕರಿಬಸವರಾಜೇಂದ್ರ ಮಹಾಸ್ವಾಮಿಗಳು ಉರುಕುಂಡ ಮಠ ಸ್ವಾಮೀಜಿಯವರು ಮನವಿಯನ್ನು ತಮ್ಮ ಭಕ್ತರ ಮುಖೇನ ಸಲ್ಲಿಸಿ ತಮ್ಮ ಅನಾರೋಗ್ಯದ ಪರಿಸ್ಥಿತಿಯಿಂದ ಸದರಿ ಸಭೆಗೆ ಹಾಜರಾಗಲು ಸಾಧ್ಯವಾಗುತ್ತಿಲ್ಲ ಲಿಖಿತವಾಗಿ ಸಲ್ಲಿಸುತ್ತಾ ಸದರಿ ಅರ್ಜಿಯಲ್ಲಿ ಅಂಶಗಳ ಕುರಿತು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಮುಖಾಂತರ ಸಲ್ಲಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಅಭಿಪ್ರಾಯ ಸಲ್ಲಿಸಲು ಬಂದಂತಹ ಭಕ್ತಾದಿಗಳ ಪೈಕಿ ಗೋಪಿಶೆಟ್ಟಿ, ಈಶ್ವರಪ್ಪ, ರಾಂಪುರ್ ರೋಡ್ ಮತ್ತು ಮಾರಮ್ಮ ಗುಡಿ ಹತ್ತಿರ ರಾಯಚೂರು ಇವರ ಮನವಿ ಸಲ್ಲಿಸಿ ಶ್ರೀ ನಾರದಗಡ್ಡೆ ಮಠವು ಶ್ರೀ ಕರಿಬಸವರಾಜೇಂದ್ರ ಮಠ ಉರುವಕೊಂಡ ಇದರ ನೇತೃತ್ವದಲ್ಲಿ ನಡೆಯುತ್ತಿದ್ದು ವಿನಾಕಾರಣ ತೊಂದರೆಯನ್ನು ನೀಡುತ್ತಿದ್ದು ಶ್ರೀ ಶಿವಕುಮಾರ ಸ್ವಾಮೀಜಿಯವರ ದೂರನ್ನು ವಜಾ ಮಾಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಈ ಮಧ್ಯೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಸದರ ಭಕ್ತಾದಿಗಳನ್ನು ಈ ಒಂದು ಸಭೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಿಂದ ಜರುಗುತ್ತಿರುವುದರಿಂದ ಸಭೆಯಲ್ಲಿ ಭಾಗವಹಿಸಲು ಕೇಳಿಕೊಂಡರು. ಆದರೆ ಭಕ್ತಾದಿಗಳು ಅದಕ್ಕೆ ಒಪ್ಪದೆ ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಸಭೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದ ಸಭೆಯನ್ನು ಬಹಿಷ್ಕರಿಸಿ ಹೋದರು. ಮುಂದುವರೆದ ಸದರಿ ಸಭೆಯಲ್ಲಿ ಹಾಜರಿದ್ದ ಹಾಜರಿ ಪುಸ್ತಕದಂತೆ ಶ್ರೀ ಮರಿಯಪ್ಪ ಚೆಟ್ಟೇರ್ಕರ್ ಮತ್ತು ಇತರರು ತಾಲೂಕಿನ ಗ್ರಾಮದ ನಿವಾಸಿಗಳು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ದೇಶಕ್ಕೆ ಸ್ವಾತಂತ್ರ್ಯ ಬಂದ ನಂತರ ಸಂವಿಧಾನದ ಆಶಯದಂತೆ ಹಲವಾರು ಕಾನೂನುಗಳು ಜಾರಿಯಾಗಿದ್ದು ಇದರಲ್ಲಿ ಪ್ರಮುಖವಾಗಿ ಇನಾಮ್ ರದ್ದತಿ ಕಾಯ್ದೆ 1954, ಇನಾಮ್ ರದ್ದತಿ, ಧಾರ್ಮಿಕ ಮತ್ತು ಚಾರಿಟೇಬಲ್ ಕಾಯ್ದೆ 1956 ಜಾರಿ ಮಾಡಿದೆ. ಆದರೂ ರಾಜ್ಯದಲ್ಲಿ ಮಠಗಳು ದೇವಸ್ಥಾನದ ಹೆಸರಲ್ಲಿ ಸಾವಿರಾರು
Patil, this story is not of any use. There is an order passed by a coordinate bench which was required to be followed by.
implemented.
You challenged it, that challenge has been rejected. Thereafter, if your client feels that despite the order passed by this court, they can overreach the orders of this court,
That's one.
good luck to them.
Not one submission I make not. Your lordships also aware that at that time when the matter was taken up for hearing, the place which was which was suggested, and in fact, Malords, it is 25 to 30 kilometers, the place was given. Subsequently, when the order was passed, Malords, we came
Your
to know that
submission is contradictory for a simple reason that you would say that Telangana inda barak ready idare.
ಇಲ್ಲ
ಇಲ್ಲಿ
ತೆಲಂಗಾಣ
20 kilometers ಗೆ.
ನೋ Malords,
ಇಲ್ಲಿಂದ
ತೆಲಂಗಾಣ
ಅಲ್ಲಿ 60 kilometers
ಅದು
ಹೋಗಕ್ಕಾಗಲ್ಲ.
ಮಠ ಇರೋದೇ ತೆಲಂಗಾಣ ಬಾರ್ಡರ್ Malords.
You again, what is the vote? 1192
Yes, my
and
lord.
0 na?
Oh,
Bad luck.
One submission one submission may make Malords. Irrespective of all this, because of the Yadgiri and earlier they filed an objections. My request is Malords, ultimately the rights has to be decided.
Your request
as
is
per the
contrary
merit.
to the orders passed by a coordinate bench of this court. which can-
Coordinate bench Malords, at their only request Malords, it is Mutt premises is the place which is chosen, and subsequently they objected for that place. And Malords, we requested for 25 to 30 kilometers, and your lordships also aware about the
Objection ಕೊಡಿ.
My
ಇಲ್ಲ ಇದೆ. Order sheet. When was the coordinate benches order?
35/2024, my lords.
30?
5/2024.
Hmm.
And the
What is Annexure E, madam?
Please. D. Sorry. D, my lord, it is the order passed by the commissioner, my lord, against the deputy commissioner. He was nowhere concerned to this, my lord. He has filed appeal before the commissioner, Annexure D. It was dismissed. Against that, they have filed the appeal before the secretary. Secretary, my lord, has appointed the administrator. Annexure E. Annexure A is the order passed by the my lord, deputy commissioner, which was inquiry was conducted. Annexure B.
So you were running the MUT prior to this.
Yes, my lords. Last may kindly see, to assist the court, may I read it that
Where
order?
is the statement as regards you were running the MUT?
My lord, Annexure B is
Page?
page number 19, my lords. Where I have filed the when who has filed the appeal, my lord, he is nowhere, he has not a party before the
So
proceeding.
where is the statement that you are running the MUT? Where is the
Statement,
finding?
my lords. It, para 20, page 20 ಅಲ್ಲಿ para 3 ಇಂದ sir.
Page
Sadri-
20 ಅಲ್ಲಿ para 3.
The order passed by the deputy commissioner.
The page 20 is the Commissioner for Religious and Charitable Endowments.
Annexure B, my lords, if it is page nation is different, my lord. Annexure B is the
Annexure B,
proceedings of the
page
deputy commissioner.
23.
Proceedings of the deputy commissioner.
Page 23.
Please, ma, sorry. Para 3 of the second page, inner page, second man.
Yes.
ಸದರಿ ಮಠ ಆಸ್ತಿಯನ್ನು ತಮ್ಮ ಸ್ವಾಧೀನ ಕೋರಿ ಮಣಿಪುರ ಚನ್ನಬಸವ ಮಹಾಸ್ವಾಮಿಗಳು ಕೊಟ್ರಯ್ಯ ಸ್ವಾಮಿ ದಿ ಗುರು ಆಫ್ ದಿಸ್ ಪ್ರೆಸೆಂಟ್ ಪಿಟಿಷನರ್ ನಾರದಗಡ್ಡೆ ಮಠ ರಾಯಚೂರು ಇವರು ಉಲ್ಲೇಖ 3ರಂತೆ ಮಾನ್ಯ ಧಾರ್ಮಿಕ ದತ್ತಿ ಆಯುಕ್ತರು ಇವರಿಗೆ 16/8/11 29/3/12 ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿ ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ದತ್ತಿ ಮತ್ತು ಧರ್ಮ ಅಧಿನಿಯಮದ 97 ಜಾರಿಗೆ ಬಂದಿದ್ದು ಮಠಗಳು ಸದರಿ ಕಾಯ್ದೆಗೆ ಒಳಪಡುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸಂಪ್ರದಾಯಬದ್ಧವಾಗಿ ಪೀಠಾಧಿಕಾರಿಯಾಗಿರುವ ತಮ್ಮ ಮಠವನ್ನು ಮತ್ತು ಅದರ ಆಸ್ತಿಯನ್ನು ಹಸ್ತಾಂತರಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಉಲ್ಲೇಖ 4ರಂತೆ ಮಾನ್ಯ ಆಯುಕ್ತರು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ರಾಯಚೂರು ಅವರಿಗೆ ನಿರ್ದೇಶನ ನೀಡುತ್ತಾ ಪ್ರಸ್ತುತ ಇಲಾಖೆಯು ಆಡಳಿತ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಕಾಯ್ದೆ ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆಗಳು ಮತ್ತು ಧರ್ಮದಾಯ ದತ್ತಿಗಳ ಅಧಿನಿಯಮ 97 ಕಾಯ್ದೆ ಕಲಂ 131 ಪ್ರಕಾರ ಮಠಗಳು ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ನಾರದಗಡ್ಡೆ ಮಠಕ್ಕೆ ಶ್ರೀ ಮಣಿ ಚನ್ನಬಸವ ಮಹಾಸ್ವಾಮಿಗಳು ಪೀಠಾಧಿಕಾರಿಗೊಂದು ನೇಮಕವಾಗಿರುವುದರಿಂದ ಮತ್ತು 14/87 ಆದೇಶ ಸದರಿ ಮಠವನ್ನು ಪೀಠಾಧಿಕಾರಿ ನೇಮಕವಾದ ನಂತರ ಮಠದ ಆಡಳಿತವನ್ನು ಹಿಂದಿರುಗಿಸಬೇಕಾಗಿರುವುದರಿಂದ ಸದರಿ ಮಠದ ಉತ್ತರಾಧಿಕಾರಿಯನ್ನು ಕಾನೂನಿನಡಿಯಲ್ಲಿ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಹೈದರಾಬಾದ್ ಎಂಡೋಮೆಂಟ್ ರೆಗ್ಯುಲೇಷನ್ ನಿಯಮ ಅನ್ವಯ ಸದರಿ ಮಠವನ್ನು ನಿಯಮಾನುಸಾರ ಪೀಠಾಧಿಕಾರಿ ಹಿಂದಿರಿಸಲು ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ನಾರದಗಡ್ಡೆ ಆಡಳಿತವನ್ನು ಪೀಠಾಧಿಕಾರಿಗೆ ಹಸ್ತಾಂತರಿಸುವ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರ ನಾರದ ಮಠದ ಶ್ರೀ ಚನ್ನಬಸವ ಮಹಾಸ್ವಾಮಿಗಳು ಕೊಟ್ರಯ್ಯ ಸ್ವಾಮಿ ಇವರ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿ ಸ್ಪಷ್ಟ ಅಭಿಪ್ರಾಯ ನೀಡಲು ತಹಸೀಲ್ದಾರ್ ರಾಯಚೂರಿವರೆಗೆ ಈ ಕಚೇರಿಯ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ 23/5/12ರಂತೆ ಕೋರಲಾಗಿದ್ದು, ಅದರಂತೆ ತಹಸೀಲ್ದಾರ್ ರಾಯಚೂರು ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ 13/9/12ರಂದು ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಅದರಲ್ಲಿ ನಮೂದಿಸಿರುವಂತೆ ಲಿಂಗೈಕ್ಯ ಚನ್ನಬಸವ ಸ್ವಾಮಿಗಳು ಬಸವರಾಜ ಸ್ವಾಮಿ ಇವಾಗಿನ ಚನ್ನಬಸವ ಸ್ವಾಮಿ ಕೊಟ್ರೆಯ ಸ್ವಾಮಿಗಳಿಗೆ 11/6/92 ಮೃತ್ಯುಪತ್ರ ಮತ್ತು ಪವಾರ ಪಟಾರಣೆ ಪತ್ರ ಕೊಟ್ಟದ್ದು ಇರುತ್ತದೆ. ಮತ್ತು ಈಗಿನ ಚನ್ನಬಸವ ಸ್ವಾಮಿಗಳು ಪೀಠಾಧಿಕಾರದ ಆಹ್ವಾನ ಪತ್ರಿಕೆ, ದಿನಪತ್ರಿಕೆ, ಪಟ್ಟಾಧಿಕಾರದ ಭಾವಚಿತ್ರ ಹಾಗೂ ಮಠದ ನಿಜವಾದ ಭಕ್ತರ ಮನವಿ ಪತ್ರಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಹೊಸ ಕಾಯ್ದೆಯಿಂದ ಮಠಗಳನ್ನು ಹೊರತುಪಡಿಸಲಾಗಿರುವುದರಿಂದ ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂದು ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ನಂತರ ಪುನಃ ಈ ಕಚೇರಿಯ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ ದಿನಾಂಕ 21/2/13ರಂದು ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು ರಾಯಚೂರಿವರೆಗೆ ಪತ್ರ ಕಳುಹಿಸುತ್ತಾ, ಮಾನ್ಯ ಆಯುಕ್ತರು ಧಾರ್ಮಿಕ ದತ್ತಿ ಬೆಂಗಳೂರಿವರ ನಾರದಗಡ್ಡೆ ಮಠದ ಆಡಳಿತವನ್ನು ಪೀಠಾಧಿಕಾರಿಗೆ ಹಸ್ತಾಂತರಿಸಲು ಸೂಕ್ತ ಕ್ರಮ ಜರುಗಿಸಲು ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಂಡು ವರದಿಯನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು ರಾಯಚೂರಿವರು ಪತ್ರ ಸಂಖ್ಯೆ ಸೋ 35/13ರಂದು ವರದಿ ಮತ್ತು ಅಭಿಪ್ರಾಯ ಸಲ್ಲಿಸಿದ್ದು, ಅದರ ಪ್ರಕಾರ ನಾರದಗಡ್ಡೆ ಮಠವು ಉರುವಕೊಂಡ ಮಠಕ್ಕೆ ಸೇರಿದ ಉಪಮಠವೆಂದು ಯಾವುದೇ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. ಉರುವಕೊಂಡ ಮಠದವರು ಯಾರೂ ನಾರದಗಡ್ಡೆ ಮಠ ಇಂದಿನವರೆಗೂ ತಮ್ಮ ಅಧೀನದಲ್ಲಿರುವ ಮಠವೆಂದು ಯಾವುದೇ ಹಕ್ಕನ್ನು ಮಂಡಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಮುತ್ಸದ್ದಿಯಾಗಿ ನೇಮಕಗೊಂಡ ಶ್ರೀ ಕರಿಬಸವ ಸ್ವಾಮಿ ಆಗಲಿ ಅಥವಾ ಇವರಿಂದ ನೇಮಕಗೊಂಡ ಶ್ರೀ ಚನ್ನಬಸವ ಸ್ವಾಮಿ ಆಗಲಿ ಕೇವಲ ನಾರದಗಡ್ಡೆ ಮಠದ ವ್ಯವಸ್ಥಾಪಕರಾಗಿರ್ತಾರೆ.
Dispute between both of you. Where is it saying that you are running it?
ಫರ್ದರ್ ಮೇಲೆ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಇದರಲ್ಲಿ.
ಅದೇಳಿ ಅಷ್ಟೇ.
ಇದು ನೆಕ್ಸ್ಟ್ ಬಾರದಲ್ಲಿ ಇನ್ನರ್ ಪೇಜ್ 4ದಲ್ಲಿ ಲಾಸ್ಟ್ ಉಲ್ಲೇಖ 5 ಮತ್ತು 6 ಮನವಿ ಪತ್ರ ಪರಿಶೀಲಿಸದೆ ವೆರಿಫೈಯಿಂಗ್ ಆಲ್ ದಿಸ್. ಉಲ್ಲೇಖ 5 ಮತ್ತು
Yes.
ಉಲ್ಲೇಖ 5 ಮತ್ತು 6 ಮನವಿ ಪತ್ರಗಳನ್ನು ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ನಾರದಗಡ್ಡೆ ಮಠಕ್ಕೆ ಮಣಿಪುರ ಚನ್ನಬಸವ ಸ್ವಾಮಿ, ಶಿವಕುಮಾರ ಸ್ವಾಮಿ, ಲಿಂಗಯ್ಯ ಸ್ವಾಮಿಯವರನ್ನು ಉತ್ತರಾಧಿಕಾರಿಗಳೆಂದು 1/4/13ರಂದು ನಿಧನರಾಗಿರುವ ಅಂದಿನ ನಾರದಗಡ್ಡೆ ಮಠಾಧಿಪತಿ ಮಣಿಪುರ ಚನ್ನಬಸವ ಸ್ವಾಮಿ ಕೊಟ್ರೆಯ ಸ್ವಾಮಿಗಳು ತಾವು ನಿಧನರಾಗುವ ಪೂರ್ವದಲ್ಲಿ ಅಂದರೆ 13/9/11ರಂದು ಉತ್ತರಾಧಿಕಾರಿಗಳಾಗಿ ನೇಮಿಸಿ ಒಂದು ಮೃತ್ಯುಪತ್ರವನ್ನು ಬರೆದಿಟ್ಟಿರುವ ಪತ್ರದ ಛಾಯಾಪ್ರತಿಯನ್ನು ಸಲ್ಲಿಸುತ್ತಾರೆ. ಅದನ್ನು ಮೂಲ ಪ್ರತಿಯೊಂದಿಗೆ ಪರಿಶೀಲಿಸಿ ದೃಢೀಕರಿಸಲಾಗಿದೆ. ಹಾಗೂ ಅದರಲ್ಲಿರುವ ಸಹಿಯು ನಾರದಗಡ್ಡೆ ಮಠಾಧಿಪತಿ ದಿವಂಗತ ಮಣಿಪುರ ಶ್ರೀ ಚನ್ನಬಸವ ಸ್ವಾಮಿ ಕೊಟ್ರೆಯ ಸ್ವಾಮಿಯವರ ಸಹಿ ಎಂಬುದನ್ನು ದಾಖಲೆಗಳೊಂದಿಗೆ ಪರಿಶೀಲಿಸಿ ದೃಢೀಕರಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಮಣಿಪುರ ಚನ್ನಬಸವ ಸ್ವಾಮಿ, ಶಿವಕುಮಾರ ಸ್ವಾಮಿ ತಂದೆ ಲಿಂಗಯ್ಯ ಸ್ವಾಮಿಯವರು ದಿನಾಂಕ 6/4/13ರಂದು ಶ್ರೀ ಮಣಿಪುರ ಗುರು ಮಹಾಂತ ಸ್ವಾಮಿಗಳು ವಿರಕ್ತ ಮಠ ನರೋಣ ಇವರ ದಿವ್ಯ ಸಾನ್ನಿಧ್ಯದಲ್ಲಿ ಹಾಗೂ ಹರಗುರು ಚರಮೂರ್ತಿಗಳ ಸಮಕ್ಷಮದಲ್ಲಿ ಲಿಂಗೈಕ್ಯ ಶ್ರೀ ಚನ್ನಬಸವ ಸ್ವಾಮಿಗಳ ನಾರದಗಡ್ಡೆ ಪೀಠಾಧಿಪತಿಗಳು ಇವರ ಸಂಕಲ್ಪದಂತೆ ನಾರದಗಡ್ಡೆ ಸಂಸ್ಥಾನ ಮಠದ ಪಟ್ಟಾಧಿಕಾರವನ್ನು ಭಕ್ತರ ಸಮಕ್ಷಮ ಜರುಗಿಸಿದ ಬಗ್ಗೆ ಒಂದು ಛಾಯಾಪ್ರತಿಯನ್ನು ಹಾಗೂ ಪಟ್ಟಾಧಿಕಾರಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತೆಗೆದಿರುವ 10 ಫೋಟೋಗಳನ್ನು ಕೂಡ ಮಣಿಪುರ ಚನ್ನಬಸವ ಸ್ವಾಮಿ, ಶಿವಕುಮಾರ ಸ್ವಾಮಿ ಇವರು ಉಲ್ಲೇಖ 5ರಂತೆ ಸಲ್ಲಿಸಿರ್ತಾರೆ. ಅದರ ಉಲ್ಲೇಖ 6ರಲ್ಲಿ ಶ್ರೀ ಸಿದ್ಧಲಿಂಗಯ್ಯ ಸ್ವಾಮಿಯವರು ನಾರದಗಡ್ಡೆ ಮಠ ಉರವಕೊಂಡ ಮಠ ಶಾಖಾ ಮಠವಾಗಿದ್ದು ತಾವೇ ನಾರದಗಡ್ಡೆ ಮಠಕ್ಕೆ ಉತ್ತರಾಧಿಕಾರಿ ಎಂದು ತೋರಿಸಲು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಪಟ್ಟಾಧಿಕಾರ ಕಾರ್ಯಕ್ರಮದ ದಿನಾಂಕವನ್ನು ಭಕ್ತರು ಹಾಗೂ ಜಗದ್ಗುರು ನಿರ್ಧರಿಸತಕ್ಕದ್ದು ಮತ್ತು ಆ ದಿನದಂದು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕಾರ್ಯಕ್ಕೆ ಹಾಜರಾಗಿ ತಮಗೆ ಪಟ್ಟಾಧಿಕಾರ ವಹಿಸಿಕೊಡತಕ್ಕದ್ದು ತಾವೇ ಆಯುಕ್ತರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಇದಲ್ಲದೆ ಶ್ರೀ ಜಗದ್ಗುರು ಚನ್ನಬಸವ ರಾಜೇಂದ್ರ ಮಹಾಸ್ವಾಮಿಗಳು ಮಠಾಧಿಪತಿ ಗವಿಮಠ ಸಂಸ್ಥಾನ ಉರವಕೊಂಡ ಅನಂತಪುರ ಇವರು ಡಾಕ್ಟರ್ ಸಿದ್ಧಲಿಂಗಯ್ಯ ಸ್ವಾಮಿಗಳು ವಿರಕ್ತ ಮಠ ಇಂಗಳೇಶ್ವರ ಇವರಿಗೆ ನೀಡಿದ್ದು ನಾರಗಡ್ಡೆ ಮಠ ಪೂರ್ವಭಾವಿ ಸಂಪುಟ ಪತ್ರವನ್ನು ರದ್ದುಗೊಳಿಸಿರುವುದರಿಂದ ಡಾಕ್ಟರ್ ಸಿದ್ಧಲಿಂಗಯ್ಯ ಸ್ವಾಮಿಗಳು ನಾರದಗಡ್ಡೆ ಮಠದ ಪೀಠಾಧಿಕಾರಿಗಳೆಂದು ತೀರ್ಮಾನವಾಗಿಲ್ಲ ಎನ್ನುವುದು ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬರುತ್ತದೆ. ಉಲ್ಲೇಖ 4ರ ಈ ಮಾನ್ಯ ಆಯುಕ್ತರ ನಿರ್ದೇಶನದಂತೆ ಉಲ್ಲೇಖ 5 ಮತ್ತು 6ರವರ ಮನವಿ ಪತ್ರ ದಾಖಲೆಗಳನ್ನು ಹಾಗೂ ಮಣಿಪುರ ಚನ್ನಬಸವ ಸ್ವಾಮಿಗಳು ಇವರ ಮಾನ್ಯ ಧಾರ್ಮಿಕ ದತ್ತಿ ಆಯುಕ್ತರಿಗೆ ಸಲ್ಲಿಸಿರುವ 7/11/13ರ ಪತ್ರದ ಮೇಲೆ ಮಾನ್ಯ ಆಯುಕ್ತರು ಈ ಪ್ರಕರಣದ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ನಾರಗಡ್ಡೆ ಮಠದ ಆಡಳಿತವನ್ನು ಶ್ರೀ ಚನ್ನಬಸವ ಸ್ವಾಮಿಗಳು, ಶಿವಕುಮಾರ ಸ್ವಾಮಿಯವರಿಗೆ ಹಸ್ತಾಂತರಿಸಿಕೊಳ್ಳಲು ತ್ವರಿತ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಕೋರಿದೆ ಮತ್ತು ಅನುಸರಣಾ ವರದಿಯನ್ನು ಕೂಡ ಸಲ್ಲಿಸುವಂತೆ ವಿನಂತಿಸಿಕೊಳ್ಳಲಾಗಿದೆ ಎಂದು ಸೂಚಿಸುತ್ತಾರೆ. ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆ ಮತ್ತು ಧರ್ಮಾದಾಯ ಅಧಿನಿಯಮ ಸೋ ಪ್ರಕಾರ ಕಾಯ್ದೆ 33ರ ಅಡಿಯಲ್ಲಿ ಸದಸ್ಯರು ಎಲ್ಲಾ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆಗಳು ಅಥವಾ ಧರ್ಮದಾಯ ಗತಿಗಳಿಗೆ ಅನ್ವಯವಾಗತಕ್ಕದ್ದು 23ರ ಪ್ರಕರಣದಲ್ಲಿ ಅಧಿಸೂಚನೆ ಹೊರತುಪಡಿಸಿ ಎಲ್ಲಾ ಧಾರ್ಮಿಕ ಸ್ವಯಂಸೇವಕರಿಗೆ ಅನ್ವಯವಾಗುತ್ತದೆ. ಪರಂತು ಇದು ಒಂದು ಮಠದ ಅಥವಾ ಮಠಕ್ಕೆ ಸೇರಿದ ಅಥವಾ ಅದು ನಿರ್ವಹಿಸಿದ ದೇವಸ್ಥಾನಕ್ಕೆ ಅನ್ವಯತಕ್ಕದಲ್ಲಿ ಎಂದು ಸ್ಪಷ್ಟವಾಗಿರುವ ಪ್ರಯುಕ್ತ ಸಹಾಯಕ ಆಯುಕ್ತರು ರಾಯಚೂರಿಯವರ ಅಭಿಪ್ರಾಯದಂತೆ ನಾರದಗಡ್ಡೆ ಮಠವನ್ನು ದೇವಸ್ಥಾನ ಎಂದು ಪರಿಗಣಿಸಲು ಕಾಯ್ದೆಯಲ್ಲಿ ಅವಕಾಶ ಇರುವುದಿಲ್ಲ. ಪೀಠಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳನ್ನು ಆಧರಿಸಿ ಮಣಿಪುರ ಚನ್ನಬಸವ ಸ್ವಾಮಿ, ಕುಮಾರ ಸ್ವಾಮಿಗಳು, ಲಿಂಗಯ್ಯ ಸ್ವಾಮಿ ಮಠ, ಕೊಡೇಕಲ್ ಗ್ರಾಮ, ಸುರಪುರ ತಾಲೂಕು ಸೋ ಅವರನ್ನು ಅಧಿಕೃತ ಪೀಠಾಧಿಕಾರಿಗಳನ್ನು ನಿಶ್ಚಯಿಸಿ ಸುಕ್ಷೇತ್ರ ನಾರದಗಡ್ಡೆ ಮಠದ ಆಡಳಿತವನ್ನು ಶ್ರೀ ಮಠಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಚರಸ್ಥಿರಾಸ್ತಿ ಹಾಲಿ ಇರುವ ಸ್ಥಿತಿಯನ್ನು ಮಣಿಪುರ ಚನ್ನಬಸವ ಸ್ವಾಮಿಗಳವರಿಗೆ ಹಸ್ತಾಂತರಿಸಲು ಆದೇಶಿಸಿದೆ. ಹಾಗೂ ಅಧಿಕೃತ ಮಠಾಧಿಕಾರಿಗಳು ಇಂದಿನಿಂದಲೇ ಜಾರಿ ಬರುವಂತೆ ಈ ಮಠಕ್ಕೆ ಧಾರ್ಮಿಕ ವಿಧಾನ ಹಂಚಿಕೊಂಡು ಹೋಗಲು ಅನುಮತಿಸಿದೆ.
2013 ಅಲ್ಲಿ ಆಯ್ತು.
Yes, madam.
From 2013 you have been running the mata.
Yes, madam. That he is a pattadikari of that matter. You will ask me kindly see reference of that proceedings, my lord, kindly see for a moment, my lord. The otherly, the Siddhalingaya Swami has filed the objection has appeared.
Hmm.
This, the respondent, my lord, who has filed the appeal before the commissioner, who was not a party before that proceedings.
Yes.
Last may kindly see the annexure C of the proceedings before the commissioner, my lord.
Hmm.
He has not approached the commissioner. Later on, my lord, this respondent, my lord, along with this Jagadur Channa Rajendra Swamigulu, is no way concerned with proceedings, along with the Sidlingaya Swami, has filed appeal before the secretary. The secretary has passed this impugned order stating that appointing the
That
administrator.
order was passed on,
Sorry,
secretary's order was passed
second
on.
14/3/2014.
2014 order.
Yes, my lords. Inner page 8 dalli, they have appointed the.
So from 2014, administrator has been,
Yes, my
There.
lord. Yes, my lord. From 2014, I am fighting for my rights, my lord, since I am the Matadipati of that mutt. In before the devotees and the earlier Swamiji, as per the will of the
what
Swamiji,
has happened to the suit now?
suit is pending.
He in stage, you know.
The issues were, in fact, both the suits were dismissed on the ground that they have raised the objection that suit is not maintainable. Anta. Then both the suits, suit and counterclaim, both are dismissed. Then appeal is filed by this respond number 4, my lords. Then in the appeal, it is restored and the counterclaim is also restored. Even there is no appeal by the other side. Then counterclaim.
What is the stage of
the
this suit?
issues were framed.
Issues.
Issues were framed.
Suit was filed in the year?
In the year 2000, I have filed my in the objections. My objection.
2000, suit.
2014
423
itself.
of
2014 itself.
2014. Who is the plaintiff?
The plaintiff is present respond number 4.
So you have chosen not to prosecute the matter at all.
But I have prosecuting the suit, madams.
You are the plaintiff.
Howdo?
Both
We are prosecuting.
Issues frame ಆದ್ಮೇಲೆ evidence ಯಾರು lead ಮಾಡ್ಬೇಕು?
Illa evidence, madams, what happened? The suit is dismissed. Because of the reason that
ನೀವೇ ನಿಮ್ suit dismiss ಆಗಿದ್ದಪ್ಪ
Illa
for non prosecution.
counterclaim, both are dismissed.
ನಿಮ್ suit dismiss ಆಯ್ತಾ?
Aye, sir. Other ಮೇಲೆ appeal.
2014 suit. 2014 suit, we are in 2024.
It was restored, madams, in the year 2023.
22.
Regular appeal number 41/22.
ಇನ್ನ evidence ಮಾಡಿಲ್ಲ.
Lords, one submission may I request, Lords. If your lordships, Lords, because both are seeking, Lords, they are claiming under the will. But first of all, Lords, Mahant cannot be appointed as per the even known, Lords, procedure under the will. Will is seriously disputed. They are claiming under the one.
You have challenged it, but you are not prosecuting the suit. You are not attending the meeting. You
23
don't want to do anything.
Lords, even their counterclaim is also there.
Forget their counterclaim. First, ನಿಮ್ದು ಹೇಳಿ.
23 the restore ಆಗಿದೆ, Swami. Now
You are
we
the
are prosecuting.
plaintiff.
23 suit is restored and now we are.
ಯಾವಾಗ issues frame ಆಗಿದ್ದು ಯಾವಾಗ
This ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು initially itself on the preliminary issue suit is dismissed. Then
we-
on
we
23,
will hand over the
27
management to the petitioner since you are not interested in doing anything.
27/7/23.
Let them manage it. If you succeed in the suit, we'll see at that time.
Just I will make one submission. Your lordships kindly see the impugned order last passed, which is
Yes.
under challenge.
Hmm.
Ubaya Pakshakar, page number 76, last page.
76.
Ah,
76 of what?
The writ petition.
Writ petition ಬರೀ
76 ಇಲ್ಲ.
ಇಲ್ವೇ ಇಲ್ಲ.
ನನ್ನ page 70. 14/3/2014 order.
What is annexure E?
Annexure,
Annexure E, inner page 8, my lords.
page 33. 37. 37 73 ಮಾಡಿದ್ರು.
Lords, ಉಭಯ ಪಕ್ಷಕಾರರ ಪರ ವಕೀಲರುಗಳ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಅದು ಲಾಸ್ಟ್ ಪೇಜ್ ಆಫ್ ದಿ ಆರ್ಡರ್.
Secretary order.
Last page.
Internal page number 8.
Internal page 8.
Impugned order, my lord, annexure E,
Date of the order. Annexure
last
E.
page.
ಈ
ಉಭಯ ಪಕ್ಷಕಾರರು
ಹ್ಮ್
ಉಭಯ ಪಕ್ಷಕಾರರ ಪರ ವಕೀಲರುಗಳ ವಾದವನ್ನು ಆಲಿಸಲಾಯಿತು ಹಾಗೂ ಅವರ ಸಲ್ಲಿಸಿರುವ ಲಿಖಿತ ವಾದವನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಕರ್ನಾಟಕ ಹಿಂದೂ ಧಾರ್ಮಿಕ ಸಂಸ್ಥೆಗಳು ಮತ್ತು ಧರ್ಮದಾಯ ದತ್ತಿಗಳ ಕಾಯ್ದೆ 1997 ಅಡಿಯಲ್ಲಿ ಮಠಗಳ ಆಡಳಿತವು ಬರುವುದಿಲ್ಲ. ಆದರೆ ಸರ್ಕಾರವು ದಿನಾಂಕ 14/8/1987, ಸ್ವಾಮಿ, ದಟ್ ಈಸ್ ರಾಂಗ್ಲಿ ಟೈಪ್ಡ್. 14/8/1987 ಅದು ಆದೇಶದನ್ವಯ ಸದರಿ ಮಠಕ್ಕೆ ಪೀಠಾಧಿಕಾರಿ ನೇಮಕವಾದ ನಂತರ ಮಠದ ಆಡಳಿತವನ್ನು ಹಿಂದಿರುಗಿಸಬೇಕಾಗಿರುತ್ತದೆ. This is the order, my lords, wherein which is passed the order under the Hyderabad endowment firstly. Wherein under the Hyderabad endowment firstly, there are the proceedings, my lords, were initiated and there was an order was passed appointing the administrator. ಪೀಠಾಧಿಕಾರಿ ನೇಮಕವಾದ ನಂತರ this dispute is from the year 1984, my lords. ನಂತರ ಮಠದ ಆಡಳಿತವನ್ನು ಹಿಂತಿರುಗಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಸದರಿ ಮಠದ ಉತ್ತರದಾಯಕವನ್ನು ಕಾನೂನಿನಡಿಯಲ್ಲಿ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಸದರಿ ಮಠವನ್ನು ನಿಯಮಾನುಸಾರ ಪೀಠಾಧಿಕಾರಿಗಳಿಗೆ ಹಿಂತಿರುಗಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದರೆ ರಾಯಚೂರು ಜಿಲ್ಲೆ ಶ್ರೀ ನಾರದಗಡ್ಡೆ ಮಠದ ಪೀಠಾಧಿಕಾರದ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಮತ್ತು 1ನೇ ಪ್ರತಿವಾದಿಯ ಬಗ್ಗೆ ವಿವಾದವಿದ್ದು ಮಠದ ಆಡಳಿತವನ್ನು ಯಾರಿಗೆ ಹಸ್ತಾಂತರಿಸಬೇಕು ಎಂಬ ಬಗ್ಗೆ ಜಿಜ್ಞಾಸೆ ಉಂಟಾಗಿದೆ. ಮಠದ ಉತ್ತರಾಧಿಕಾರತ್ವದ ವಿಚಾರವು ಸಿವಿಲ್ ಸ್ವರೂಪದಾಗಿದ್ದು ಈ ವಿವಾದವನ್ನು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪಕ್ಷಕಾರರು ಪರಿಹರಿಸಿಕೊಂಡು ಮಠದ ನೈಜ ಪೀಠಾಧಿಕಾರಿಯ ನೇಮಕಾತಿಯು ಆದ ನಂತರದಲ್ಲಿ ಸರ್ಕಾರದ ಆದೇಶದನ್ವಯ ಶ್ರೀ ನಾರದಗಡ್ಡೆ ಮಠದ ಆಡಳಿತವನ್ನು ಹಸ್ತಾಂತರಿಸುವುದು ಸೂಕ್ತವಾಗಿರುತ್ತದೆ. ಅಲ್ಲಿಯವರೆಗೆ ಮಠದ ಬೆಲೆಬಾಳುವ ಆಸ್ತಿಯನ್ನು ಸಂರಕ್ಷಿಸುವುದು ಸರ್ಕಾರದ ಜವಾಬ್ದಾರಿಯಾಗಿದ್ದು ಮಠದ ಆಡಳಿತ ನಿರ್ವಹಣೆಯ ತಹಸೀಲ್ದಾರ್ ರಾಯಚೂರು ತಾಲೂಕು ಇವರೇ ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗುವುದು ಸೂಕ್ತವಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಈ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಕೆಳಕಂಡಂತೆ ಆದೇಶ. ರಾಯಚೂರು ಜಿಲ್ಲೆ ತಾಲೂಕಿನ ರಾಯಚೂರು ನಾರದಗಡ್ಡೆ ಮಠದ ಪೀಠಾಧಿಪತಿ ಹಕ್ಕಿನ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಮತ್ತು 1ನೇ ಪ್ರತಿವಾದಿಯವರು ಸಕ್ಷಮ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಲು ಹಾಗೂ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ತೀರ್ಪಿನನ್ವಯ ನೇಮಕಗೊಳ್ಳುವ ಸ್ವಾಮಿಗಳು ಮಠದ ಆಸ್ತಿ ಹಸ್ತಾಂತರಣಕ್ಕೆ ಸರ್ಕಾರಕ್ಕೆ ಕೋರಿಕೆ ಸಲ್ಲಿಸುವ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ನೀಡಿದೆ. ಅಲ್ಲಿಯವರೆಗೆ ಮಠದ ಸಮಸ್ತ ಆಡಳಿತ ನಿರ್ವಹಣೆ ತಹಸೀಲ್ದಾರ್ ರಾಯಚೂರು ತಾಲೂಕಿಯವರು ನಿರ್ವಹಿಸಿಕೊಂಡು ಹೋಗಲು ಆದೇಶಿಸಿ ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಿದೆ. This is the order notes 14/8/1987 which is attained finality and who has executed the will what they are claiming under the rights. At that time there was a suit was pending and there were parallel proceedings under the Hyderabad endowment firstly and this order was
filed by you.
Not now.
Now it is posted for evidence.
House.
When will you lead evidence?
Within 15 days now.
On the next date,
House.
you will lead evidence.
I will lead the order.
Madam, what we'll do is we'll dispose this writ petition, directing the trial court to dispose of the suit, take into consideration the report that has been filed, because all are disputed questions of facts.
First, my request is, my lord, to implement the order passed by Deputy Commissioner, hand over the charge,
Yes,
then we'll,
From 2014, there is an administrator, not in the recent past.
the administrator, my lord, the
You are,
appointing.
you are possibly handling the mud for 1 month. Ashte.
That, my lord, that question is,
Annexure C was passed on.
this question is already decided by this court, my lord. in,
2013 my lords.
the-
2/12/2013. This order was passed on 14/3, probably 4 months. Ashte. It's in
Lord,
2014 in the administrator is there. Why
this
should the
question is
administrator?
already
be-
decided by this court, my lord, that appointment of administration will not arise, my lord. This, kindly say, already furnished the judgment, my lord. for
No,
one
this
more
is on account of Mata doesn't come under the
Yes, my
religious. That is not a
The
problem.
violates,
But the problem is both of you are fighting tooth and nail. And there's a suit which is pending. And between both of you, everybody, whoever is the followers of the Mata is,
as per proceedings, my lord, he has no concern to that property.
So
And
now-
what,
now we'll direct him,
he never produced any single document, my lord.
we'll put both of you on terms that the suit has to be disposed of expeditiously. Because until the disputed question is resolved,
Let the suit may continue, my lord. Till then, my lord, I have to.
how can it be
Alla,
from
I thought
2014 you are
that-
not there?
He is no vacancy, he is not a Swamiji of that mat, my lord.
You are also not there for last 10 years.
I am sufferer, my rights are affected, my lord.
That is
Their
why-
rights are not affected.
That is why the
Your
suit has
last
to be.
kindly see the annexure, my lord, the proceedings of the deputy commissioner, my
ಇವಾಗ
lord.
ನಿಮ್ಗೆ ಅದು ಬೇಡ ಅಂದ್ರೆ this will have to be heard, we will post it for final hearing and take it up for final hearing.
ಅದ್ರ ಏನಾಗಿದೆ
This
ಅವ್ರು
cannot be decided interlocutory matter. We'll post it for final hearing, you argue everything. Explicitly, it appears that the suit has to be decided. Probably the final finding will also be the same.
ಅಲ್ಲಿ ಲೋಕಲ್ ಸ್ಟ್ಯಾಂಡ್ ಏನಿಲ್ಲ ಅವ್ರಿಗೆ
ಇನ್ನ ಒಂದ್ 2 ವರ್ಷ ಡಿಲೇ ಆಗತ್ತೆ. ಅಷ್ಟರೊಳಗೆ ಸೂಟ್ ಬರ್ಬೋದು ಅಂತ ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ರೆ you have to choose. Now at least we can put him on terms because and we'll observe that he has been sitting on the fence and not doing anything.
We will do it not within 1
We'll
month.
put him on terms. If the first day he does not lead evidence, the suit will get dismissed for non-prosecution.
I was-
Similarly, if you don't lead evidence on the first day,
we are ready, my lord, we are.
every date it will be, both of you will have to do it. Because 10 years you are not been there.
Since he has not filed any
That
objection.
will be
to the-
decided by the trial court.
Because he has not filed any objections and are not sought any.
Aggrieved party can always file an appeal. He is an aggrieved party.
ಅಲ್ಲ ಒಂದ್ ನನಗೆ
Whether he is aggrieved or not will have to be decided. ನಿಮ್ ಚಾಯ್ಸ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಹೇಳಿ.
Final, but 2014 I am suffering my land.
ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ 2 years ಇನ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಗಿದ್ರೆ ಇನ್ನೊಂದು 2 years ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ಬದಲು ಯು ಕ್ಯಾನ್ ಡೂ ದಿಸ್ ಅಂತ. It will be in the interest of not both of you, but in the interest of the followers. Both of you are wanting to fight it out only.
Despite of
My lord.
this respondent, my lord, who was cultivating the land since more years, they are interested to continue this litigation. They want to continue that cultivation. That is their.
Any comment we make may be
My lords, in,
Before the in the proceedings, my lord, one of the devotee has expressed that the land has to be distributed.
there may be a lot
person-
of comments
Yeah,
that may
correct.
come to our mind, but we should not be making those comments. We
Once,
won't do
ಎಲ್ಲ
that.
ಲ್ಯಾಂಡ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಬೇಕಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂತಾರೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಲ್ಲಿ.
one submission, my lords, one request. In fact, my lords,
Before the
this
deputy
matter
clerk.
was taken up to the, when the, both the Swamijis were appeared before this court in the month of, my lords, April, for settlement. Then we, my lords, requested
was-
that irrespective of all the, with concern to the financial matters, because even my,
ಇದೆಲ್ಲ
even I also, my lord, suggested,
This
we will not involve
About
in any.
finance and
ಗೊತ್ತು sir,
economics only,
ಗೊತ್ತು,
nothing
ಗೊತ್ತು.
else.
There are several
Let's
mosques
we are ready
which are
for
not
the
having
look at,
single property. They were
proceedings.
not at all maintained by anyone.
will
When there is a financially,
You are the Matadipatis, so-called.
how's,
People follow your advice.
how's,
People come to you with their problems, asking for solving those problems. If you yourself are fighting like this, what moral one do you have to advise anybody?
I told my client.
ನಾವು ಸೂಟ್ ನಲ್ಲಿ ಎವ್ರಿ ಡೇ ವಿಲ್ ಅಪಿಯರ್ ಮೈ ಲಾರ್ಡ್ ವಿಲ್ ಅಡ್ಯೂಸ್ ದ ಎವಿಡೆನ್ಸ್ ಎವ್ರಿ ಡೇ ಮೈ ಲಾರ್ಡ್ ವಿ ಆರ್
ನೀವೇ
ರೆಡಿ.
ನಿಮ್ ಡಿಸ್ಪ್ಯೂಟ್ ಸಾಲ್ವ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಬೇರೆಯವ್ರ ಪ್ರಾಬ್ಲಮ್ ಹೆಂಗ್ರಿ ಸಾಲ್ವ್ ಮಾಡ್ತೀರಾ?
ಆಗಲ್ಲ. ಇದು this should not, my lords, happen when they,
It is
because
not the their Swamiji, my lord, it is the behind the some
the-
devotees who are cultivating the lands
the
of the
belief
mutt,
of the
they are
people.
they are the persons, my lords.
Allah, the persons,
the
my lords, who
problem.
believed in the,
Lead evidence. Lead evidence.
yeah,
You
my
anyway-
lords, see, in terms of 15 days, my lords, your lordships,
ಯಾವತ್ತು ಪೋಸ್ಟ್ ಆಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
just I will verify, my lords, we get the.
Now we'll ready to every day will cooperate with the proceedings, my lord.
ಶಿವಕುಮಾರ್.
ಇದು ಫಸ್ಟ್ ಒಂದು ಇಂಟೀರಿಯರ್ ಮಾಡರ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಅಂತ ಎಂದು ಆಗಿತ್ತು ಸ್ವಾಮಿ ಅವಾಗ ಒಂದು ಫಸ್ಟಿಗೆ
ಏನಂತ ಆಗಿದೆ?
2014-15 ಅಲ್ಲಿ ಅವಾಗ
ವಾಟ್ ಇಸ್ ದ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್?
ಅದೇನೋ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಅಂತ ಒಂದು ಯಾವ್ದೋ ಫಸ್ಟಿಗೆ ಒಂದು ಆಗಿತ್ತು. ಪ್ರೊಬಬಲಿ ಜಸ್ಟ್ ಐ ಆಮ್ ಬ್ರಿಂಗಿಂಗ್ ಟು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ನೋಟಿಸ್.
ಯಾವಾಗ ಆಗಿದೆ?
28(5) do not find any grounds to grant interim order ಅಂತಿದೆ. Is there interim order passed?
No, ma, there is no interior order.
Earlier I was not.
Refused ಇದೆ.
ಅಲ್ಲ we had.
Last what we saw was 28/5/2018. The dispute as so and so is a matter to be decided by civil court. Therefore, I do not find any grounds to grant an interim order. ಅಂತಿದೆ.
ಅಷ್ಟೇ ಅದು.
ಅದಾದ್ಮೇಲೆ ಏನಾದ್ರು ಇದೆಯಾ? ಇಷ್ಟೊಂದು ಆರ್ಡರ್
ಆಗಿಲ್ಲ,
ಶೀಟ್ ಇದೆ.
ಆಗಿಲ್ಲ.
You will have to guide us.
ಇಲ್ಲ ಆಗಿಲ್ಲ ಆಗಿಲ್ಲ
I am
ಆಗಿಲ್ಲ.
not, sorry, I am not gone through the order sheet earlier. Recently I was
There is no order.
from initial stage only Mantesh Patil is appearing.
Petitioner is before this court seeking for the following reliefs. While the impugned order dated 14/3/2014, the first respondent, Secretary, Revenue Department, had appointed an administrator in respect of ಯಾವ ಮಠ ಇದು?
ಶ್ರೀ ನಾರದಗಡ್ಡೆ.
ನಾರದಗಡ್ಡೆ, ಶ್ರೀ ನಾರದಗಡ್ಡೆ.
ಶ್ರೀ ನಾರದಗಡ್ಡೆ
One-
ಮಠ್.
With permission not just I will clarify. On 14/8/1987 ಏನ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ರಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನೇ ಕಂಟಿನ್ಯೂ ಮಾಡ ಅಂತ ದಿಸ್ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪಾಸ್ಡ್.
ಎಲ್ಲಿ?
ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ.
That is not now ಇದರಲ್ಲಿ. They are challenging
The
that order.
petitioner claiming that he is the Matadipati appointed on a will of the earlier Matadipati. Respondent number 5 claiming that he would be the Matadipati since the said properties and the temples come within the domain of the respondent number 5 of his mutt. The dispute between the parties has been going on for a long time, traceable to 14/8/1987,
ತಹಸೀಲ್ದಾರ್ ಕಡೆನೂ ಇವೆಲ್ಲ.
when the Commissioner for Religious and Charitable Endowments in Karnataka, wide order dated 14/8/1987, taking into interest the mutts and its properties, the properties were taken over under government supervision till a Matadipati was appointed. Subsequently, the petitioner having filed an application on the ground that he had been appointed as a Matadipati under the will on 2/12/2013, there was a direction issued by the Deputy Commissioner to transfer the property to the petitioner. Immediately thereafter, there was a challenge made by respondent number 5, who was not a party before the Deputy Commissioner, claiming that he was the aggrieved party and that the order passed by the Deputy Commissioner was not proper. This matter being taken up for consideration by the Secretary Revenue Department in the appeal on 14/3/2014, directed the Tahsildar to be an administrator of the said matter in view of the earlier order dated 14/8/1987. It is challenging said order, the petitioner is before this court. A coordinate bench of this court, wide order dated 35 2024, had passed the following order. Pursuant thereto, the meeting not being held in a proper manner, this court had passed the following order on 13/9/2024. In pursuance of the said order dated 13/9/2024, a meeting was held and a memo dated 28/9/2024 has been filed enclosing the proceedings of the meeting. The said memo is taken on record and made part of these proceedings. A perusal of the report of the meeting would indicate that the followers of the petitioner had participated in the said meeting, but however, the followers of respondent number 5 did not participate.
OS is posted on 16/10/2024, OS 4/22 of 2014,
16/10/24.
24 my lord. For evidence ಅಂತ ಇದೆ.
423 of
4/22 of 2014,
ಯಾವ ಕೋರ್ಟು?
second additional JMFC,
ರಾಯಚೂರು.
Raichur.
Claiming that the location of the meeting was not conducive for them to attend. However, the fact remains that 1,192 persons supporting the petitioner had attended the meeting and none on behalf of respondent number 5, none supporting respondent number 5 had attended the meeting. This court, wide order dated 30, the coordinate bench of this court, wide order dated 35/24, had directed the said meeting and referendum to be conducted in order to pass further orders. Today, both the councils have submitted that there is a suit in OS number 423 of 2014, which is pending before the second additional JMFC Raichur. The said suit earlier having been dismissed for non-prosecution, a counterclaim filed. The said suit filed by respondent number 5 having been dismissed for non-prosecution. The counterclaim filed by the petitioner had also been dismissed
It's not for non-prosecution. On maintainability, it is plaintiff.
on maintainability. A regular appeal having been filed, the suit has been restored and now pending consideration before the aforesaid court. Para. On the basis of the submissions which have been made by both the councils, which impinges upon the right of both the petitioner and respondent number 5, which is required to be decided after a full-blown trial, full-fledged trial, by taking into consideration the evidence led by both the parties, more so since the will has been disputed and there's a claim made that one other mutt and that the properties subject matter of ಏನ್ ಮಟ್ಟಿದು
ನಾರದಗಡ್ಡೆ ಮಠ.
ನಾರದಗಡ್ಡೆ ಮಠ್ comes within the purview of ನಿಮ್ದು ಯಾವುದು ಊರ್ವಾಡಿ ಮಠ್
ಉರ್ವಕೊಂಡ ಮಠ.
Urvakonda Mata.
Urvagonda Mutt. I have the considered opinion that this matter touching upon the faith and belief of thousands of persons, as could be seen from the persons who have attended the meeting, would have to be expeditiously decided by the trial court. The submission of Sri Mantesh Patil and counsel for respondent number 5 is that the matter being posted for evidence on 16/10/2024, evidence would be led by respondent number 5 on 16/10/2024 without seeking for any adjournment. His submission is placed on record. Needless to say, if evidence is not led by respondent number 5 on that day, the trial court would be at liberty to dismiss the suit and take up the counterclaim of the petitioner, in which event a date could be fixed by the court for the petitioner stroke defendant counterclaimant to lead his evidence. In the event of the respondent number 5 leading evidence on 16/10/2024, the matter would have to be necessarily posted for cross-examination of the said witness, which Ms. Ratna M. Shivagimat, learned counsel for the petitioner submits, would be conducted on the very date on which it is fixed for such cross-examination
Yes.
without seeking for any adjournment. Needless to say, if an adjournment is sought for, the trial court would be at liberty to close the cross-examination and proceed with the matter. The trial court is at liberty to fix the calendar of events, taking into account the pendency of matters before the trial court, by giving due priority to the present matter and ensuring that the necessary action of each of the parties for the stage which has been fixed on the date to which the matter is adjourned at is complied with by each of the parties. No adjournment is required to be granted as per the submission made by both the counsel for the petitioner and respondent number 5. Indian application hakalataane.
No, will not file any.
Both the counsels submit that they will not be filing any interlocutory application, seeking for any interlocutory orders or directions in the matter, but would go on with the trial. If yes witnesses, sir.
ಅದು ಹೇಳೋದು
ನಿಮ್ದೆಲ್ಲ ಕ್ಲೋಸ್ ಆಗ್ಬೇಕಿಲ್ಲಿ. 10 ವರ್ಷದಿಂದ ಆಟ ಆಡಿದ್ರ.
15 witnesses, no, 10 to 15 witnesses.
The submission of Sri Mantesh Patil, learned counsel for respondent number 5, that you would examine a maximum of 15 witnesses is placed on record. The submission of Ms. Ratna M. Shivagimat, that she would examine a maximum of
10 witnesses.
ನೀವ್ ಹೇಳಿ ಎಷ್ಟು ನಂಬರು, we are not restricting you. But once you say it, you are restricted by your own submission.
20 witnesses.
ನೀವು ಅವ್ರು 15 ಅಂದ್ರೆ ನಾನು ಜೋರು 20 ಅಂತ. ನಿಮ್ದು 15, 10ರಿಂದ 20 ಹೋಗ್ಬಿಟ್ಟು. You would also examine 15 witnesses is placed on record. In the event of any documents to be summoned from any state authorities, the said authorities shall produce the said documents at the earliest, as and when summoned by the trial court. ಆಮೇಲೆ
outer limit make.
outer limit.
outer limit ಆಮೇಲೆ.
They'll organize the one. ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ? ನೀವು ಸರಿಯಾಗಿ ಟೈಮ್ ಸರಿಯಾಗಿ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಸರಿ ಹೋಗುತ್ತೆ.
Will cooperate with the proceedings, my lord, will not take any.
Documents from the state government or state authorities ಆಯ್ತು. ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಏನಾದ್ರು ಬೇಕಾ?
Will file application for the certified
And
copy
in-
of this.
In case both of us filed any application for certified copies, my lords,
ಯಾವ ಸರ್ಟಿಫಿಕೇಟ್?
The period.
ಯಾವ್ದಾದ್ರು in case ಈ both of us, we are not saying that ಯಾವ್ದಾದ್ರು document in case ಯಾವ್ದಾದ್ರು.
You have 15 days. Any document to be obtained by the petitioner or respondent number 5 from any authority shall be so obtained before 16/10/2024 and no adjournment would be sought for on the ground that certified copies are yet to be furnished by the concerned authority. The concerned authority is also directed to furnish the said certified copies within the time frame. Both the parties would be entitled to furnish a copy of this order to such authority to ensure timely furnishing of the documents.
If in case, my lords, any re-examination or witnesses, if necessary,
Again,
one or
will
two
they-
times,
The court will
It will be
consider
part
on
of the
merits.
trial.
one.
Court will consider on merits. We can't impinge on the court's discretion.
The outer time.
Re-examination.
We are only putting both of you to terms.
That is the.
We are not putting the court to terms.
ಅದೇ ಅಲ್ಲ,
Court will,
in case more than 3 times or 4 times, the court cannot be.
Examination is and re-cross examination. That is.
ಅಲ್ಲ,
the
ಅದಕ್ಕೆ
court
ಮತ್ತೆ ಟೈಮ್
proceeding.
ಹೋಗ್ಬಾರ್ದು
It is the
ಅಂತ.
proceedings before the court.
ನೀವು 10 ವರ್ಷದಿಂದ ಆಟ ಆಡಿದಿರ ಮಿಸ್ಟರ್ ಮಹಾಂತೇಶ್ ಪಟೇಲ್.
ಇಲ್ಲ that,
You are at the receiving end on the back foot.
in fact, it is their
Re-exam
application,
ಸಾಕಿ
it is
ಅದಕ್ಕೊಂದು
rejected.
application ಹಾಕುದು.
What happened, my lords? They, after filing the counter claim, they moved an application for rejection of plaint, order 7 rule 11, that is
Obviously.
rejected.
Obviously.
After filing the counter claim.
Is there a restriction?
No,
At
there
any
is
stage
no
of the suit?
restriction.
Even after written statement.
ಅಲ್ಲ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ they can seek
ನೀವು
for.
ಎವಿಡೆನ್ಸ್ ಲೀಡ್ ಮಾಡಿಲ್ರಿ.
ಇಲ್ಲ, ಅದು ಡಿಸ್ಮಿಸ್ ಆದ my lords, ಪ್ರಿಲಿಮಿನರಿ ಇಶ್ಯೂ ಅಲ್ಲಿ 7-11 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ ಕೂಡಲೇ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇಫ್ ದೇ ನಾಟ್ ಫೈಲ್ಡ್ my lords ಅಪ್ಲಿಕೇಶನ್, ಅದು ಸರಿ ಹೋಗ್ತಿತ್ತು.
In terms of the above observations and directions and recordal of the submissions made by counsel for the petitioner and respondent number 5, the petition stands disposed. The registry is directed to issue certified copies if applied for at the earliest. ಇದು ರಿಪೋರ್ಟ್ ನಿಮ್ಗೆ ಬಂದಿದೆಯಲ್ಲ?
Swami,
ಈ ರಿಪೋರ್ಟ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
But sir, they are sir.
ಅಲ್ಲಿ ಆ ರಿಪೋರ್ಟ್ has been filed ಅಲ್ಲಿ ಮೇಲೆ. Both the counsel for the petitioner and respondent number 5 confirm the receipt of the memo dated 28/9/2024 along with all documents.
ಔಟರ್ ಲಿಮಿಟ್ ಫಿಕ್ಸ್ ಮಾಡಲಿಲ್ಲ.
Outer limit. ನಿಮ್ದು 20 ವಿಟ್ನೆಸ್ ಎಷ್ಟು ಲೀಡ್ ಮಾಡ್ತೀರಿ ಯಾರಿಗೂ?
All the contentions may be kept.
All needless to say, all contentions are left open and the trial court shall decide on the matter on its own merits in accordance with law.
Seal number 5, Sri Ravi B. Patil. Sri Naresh V. Kulkarni.
Lord, they have produced some additional documents. It was at the instance, his instance, my lord, last date of hearing, I was directed to produce, my lord, all the records since, my lord, 1975 to substantiate, my lord, the right over the property.
Hmm.
My lord, I have produced all the records since 1954 onwards. This property, my lord, was a subject,
ಯಾವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ?
my lord, this was
28/9.
filed on 28/9.
Yes.
My lord, this subject property was a subject matter of a grant by the order of land tribunal, my lord, on 21/8/1975. In favor of one Yesudas. Then, my lord, the property, my lord, was transferred in the name of his son. In the year 1983-84, I have produced the ROR, my lord, at page number 10.
This was granted by land tribunal.
ಹೌದು. ವಿಠಲ್ ರಾವ್ ಯಶುರಾಮ್ ಮತ್ತೆ
My lord,
ಅಶೋಕ್ ಕುಮಾರ್ ಯಶುರಾಮ್.
after remand, the Tahsildar has passed order in their favor
ಅದನ್ನ
that
ಹೇಳ್ತೀನಿ.
was challenged before the assistant commissioner held that the Waqf board name has to be entered. that was, revision was preferred before the deputy commissioner. Deputy commissioner has also passed order in our favor, my lord. Before the AC and deputy commissioner, these documents were not produced. Let the matter may be remanded and
No,
let them produce. the
I'll make one submission. My lord. He's my lord, going to the my lord, back to the my lord, original point. If my lord, he is ready to my lord, on merits. Since my lord, these were the documents which I was directed to be produced, my lord, I have produced to show that my lord, this property was never standing in the name of a Waqf.
Hmm.
My lord, since 1975, the name of my father immediately after purchase of the property was duly mutated in the revenue records in the year 2000. And then my lord, it continued in the name of my father. Thereafter, my lord, in the name of the present petition. May I take lordship to my lord, the present writ petition? I had approached this honorable court in the earlier round of litigation, my lord, where based on my lord, the
We're not
entries.
disputing these documents. These documents are not disputed.
My lord, the names differ. Mamleshwar is the name of the vendor of this petitioner.
If these documents are not disputed, then they'll have to be given effect to.
So they have to be looked into by the AC and because the, I have produced the,
New dispute ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈ
I
document.
have produced the.
You're
Gazette
not disputing the
Gazette-
documents.
Gazette
ಅಲ್ಲ?
notification wherein the name of Waqf is entered in the year 1974. I have produced along with the
Yes,
memo.
the Gazette notification are there. But apart from the Gazette notification, there is nothing that you have produced. You have never been in possession.
In the year 2007-8, name of Bob board is entered.
74 ಅಲ್ಲಿ ನಿಮ್ದು notification. From 74, there have been various other persons who have been in occupation, usage of the property. Suddenly you come up with saying notification in 2007 and 8, after 34 years, and say your name has to be entered into. Blindly it has been entered into,
My lord, this was heard by
without
the,
even giving them any notice
no, my
and
lord.
no,
Even though that was set aside and remanded back, after remand back notice is issued to them and after hearing the matter, AC and the deputy commissioner have passed order in our.
only on the basis of a notification.
Yes.
What about the land tribunal's order? There is a finding
So the
by,
land tribunal order, the
Correct.
Waqf board is not a party to said proceedings. Let them, so that order is not binding.
what
on
did
the-
you do from 74 when their name is entered? That's why we are asking you, you have not disputed it, you have not filed any proceedings from 74.
My grounds may be taken note of that as
We'll
per
take
section
note of
6.
your.
Section 6, within 1 year, they have to challenge the notification. And under 83(2), they have
If
to.
the obligation is on them to 1 year to challenge notification, in how many years do you have to challenge the ROR? ನಿಮ್ಮೇಲೇನೋ obligation ಇಲ್ವಾ? I'll wake up after 34 years.
No, that's there, but Waqf board name is entered in 2007, but subsequent to, in 2011, their name is entered. In the ROR.
74 to 2007 ಏನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ ಅಂತ. What have you done? You've not done anything. Petitioner is before this court seeking for the following reliefs. The petitioner claims that the property in survey number 39 ward of Narayanpura village Baswa Kalyan Taluk, Bidar district, was earlier standing in the name of one Yesudas, son of Gnanoba Nayak. Subsequently, proceedings have been taken up before the land tribunal, under which act? ಯಾವ act ಇದು?
The tenancy. Land tribunal, my lord.
Land tribunal under which act?
And annexure D, my lord, this is under tenancy act, my lord.
On a form 7 have been filed.
Yes, yes.
The land tribunal, while its order dated 21/8/1975, granted occupancy rights to the said Yesudas, son of Gnanoba Nayak. And his name came to be entered into in the revenue records. Vittal Rao Yaro,
His son.
on the expiry of Yesudas, his son sons, Vittal Rao and Ashok, succeeded to his properties, and their names came to be entered into in the revenue records in the year 1983-84. The land having been renumbered as survey number 44 during the lifetime of their father Yesudas. The property came to be partitioned amongst the said Vittal Rao and Ashok, which came to be entered into the revenue records on 28/5/1984, with each of them getting a share of 11 acres, 16 guntas in the said properties. Mamaleshwar Yaro,
Son of Vittal Rao.
son of
Vittal Rao. Page number 14. my lord.
Vittal Rao having expired. His son Mamaleshwar is said to have succeeded to his property, who sold the aforesaid 11 acres, 6 guntas in favor of one Annappa on 13/10/1998, who subsequently sold the property to the petitioner in the year 2000. The name of the petitioner being entered into in the revenue records in the year 2000, 2001, continued to be on the records till the year 2007-8, when unilaterally respond number 4 directed the entry of the name of respond number 3 directed the entry of the name of respond number 4 in the revenue records on the basis of a gazette notification indicating that the aforesaid land is a Waqf land. Pursuant thereto, the petitioner challenged the said order passed by the third respondent in WP number 202788 of 2017, considering that no opportunity had been granted to the no opportunity had been made available to the petitioner before the entry of the name of respond number 4 was made. The matter was remitted to respond number 3 for fresh consideration. Respond number 3, after issuance of notice and hearing the parties, directed the restoration of the name of the petitioner in the revenue records, while it is order dated 29/4/2022. In terms whereof the name of the petitioner was restored and entered into in the revenue records on 2/6/2022. The fourth respondent preferred an appeal before the second respondent as Assistant Commissioner, challenging the order of the Tahsildar on 29/4/2022. After hearing both the parties, the second respondent, Assistant Commissioner, directed the petitioner to approach the Waqf Board under Section 6 of the Waqf Act 1995, while it's order dated 13/10/2023. The petitioner challenged the said order before the first respondent Deputy Commissioner in revision petition number 140 of 23/24, filed under subsection 3 of Section 136 of the Karnataka Land Revenue Act. The Deputy Commissioner, again referring to the notification dated 14/2/1974, dismissed the revision petition, confirming the order of the Assistant Commissioner, and directed the Tahsildar to make the entries of the name of the Waqf in column number 9 and 11, while it is order dated 5/3/2024. It is challenging the same. The petitioner is before this court. The submission of Shri Ravi B. Patil, learned counsel for the petitioner, is that though the claim of the fourth respondent Waqf Board is that the property is a Waqf property in terms of notification issued in the year 1974, the Waqf has never been in possession of the property. It is the various persons referred to above who were in possession, cultivation, and occupation, and cultivation of the said property. The land tribunal as far back as on 21/8/1975, on a Form 7 having been filed that granted occupancy rights, and in pursuance thereof that various transactions have occurred. If at all the Waqf board were to claim any right, it is for the said Waqf board to establish its right in appropriate proceedings and not seek for a mutation entry to be made on the basis of an application filed by the Waqf board to the Tahsildar. And as such, he submits that the notification per se would not give any right to the Waqf board, but the same would have to be established in an appropriate proceedings. Shri Naresh Kulkarni, Learned Counsel for Respondent number 4, Waqf board, would submit that once a notification had been issued, it was required for any claimant to have challenged the said notification within a period of 1 year from the said notification. The same not having been done, the notification would continue to hold valid, and the petitioner or his predecessors could not have any right, title, or interest in the property.
And annexure F was produced by the board in page number 35.
Pursuant to this only, may not name.
And the fourth respondent had approached the Tahsildar on 11/11/2014 for updating the Waqf properties as per the notification, in persons of which the entry has been made. There being no dispute as regards the notification, no fault can be found with the orders passed by the Deputy Commissioner or the Assistant Commissioner. The entry is made in the name of fourth respondent, are proper and correct, and are required to be retained as such, and the above writ petition is required to be dismissed. Heard, Shri Vinayana Vidya.
For purpose of academical purpose, may not, similar issue may not dealt by principal bench. There may not, may pass. The old order may not be taken order. Para 16 may not would be released. Para 16 may not,
Idu baralva.
It is to
This
be
is a
noted.
different urban land ceiling. Idu.
apart from the act, several other acts, other provisions of different acts. But,
This is in a
Land
different
reform-
context. That's in a different context. Heard so and so peruse papers. In the present case,
My lord,
the fourth
my
respondent claims.
sound with regard to land tribunal order, a board is not a part.
ಅದಕ್ಕೆ ಕೇಳಿದೆ ಇನ್ನೇನಾರು ಇದೆಯಾ? His last submission is that the Waqf board was not a party in the proceedings before the land tribunal, and as such, the order of the land tribunal would not be binding on the Waqf board, and on that ground, so and so. Heard so and so peruse papers. The claim of the Waqf board as regard the subject properties is on the basis of a notification of the year 1974. Despite the said notification having been issued, neither the name of the Waqf nor the Waqf board was entered into in the revenue records post the said notification. A occupant claiming occupancy rights had filed Form 7 under the Land Reforms Act, which came to be considered by the Land Tribunal, and occupancy rights were granted to the said person, namely Shri Yesudas, son of Nanoba Nayak. Though the Waqf board or the Waqf were not parties to the proceeding before the Land Tribunal, the fact remains that occupancy rights have been confirmed in favor of Yesudas, son of Nanoba Nayak, whose name was found in the Pani from the year 1954. The Land Tribunal granted occupancy rights on 21/8/1975. Post the grant of occupancy rights, his name having been entered as an occupant in the revenue records, neither the Waqf nor the Waqf board took up any action as regards such entry from the year 1975 till the year 2007, when a request was made on the basis of the Gazette notification of the year 1974. Thus, from 1974 till the year 2007, the Waqf and the Waqf board
2013.
Sorry, 2007, 2014. 2014. Neither the Waqf nor the Waqf board took up any action as regards the said entry in the name of initially Yesudas, son of Gnanoba, from 1975 till 1983, in the names of Vittal Rao and Ashok from 1983-84 onwards, in the name of Mamaleshwar and Ashok from 28/5/1989, in the name of Anappa from the year 1998, and in the name of the petitioner from the year 2000 till the year 2014.
Are also converted.
That's for a period of 40 years. The Waqf and the Waqf board did not take any action and slept over rights, if any, existing in their favor. In that view of the matter, I am unable to accept the contention of Sri Naresh Kulkarni, learned counsel for the Waqf board, that the petitioners or their predecessors should have challenged the notification within 1 year of the notification. More so, when no entry of the name of the Waqf or the Waqf board had been made in the record of rights post the notification in the year 1974. The notification remained without being acted upon until the year 2014, when a request was made by the Waqf board for entry of the name of the Waqf in the revenue records, by which time several transactions had occurred between private parties in pursuance of an order passed by the Land Tribunal on 21/8/1975. None of these actions having been challenged in an appropriate forum by the Waqf board, the Waqf board cannot, on the basis of an application made to the Tahsildar, seek the entry of their name in the revenue records, nullifying the rights which have been created in favor of private parties over the last 40 years. In that view of the matter, I am the considered opinion that the Deputy Commissioner and the Assistant Commissioner fell into grave error in directing the name of the Waqf board merely on an application being filed without considering the rights, third-party rights which had been created as regards the property. It is for the Waqf board to establish its right over the property in appropriately instituted proceedings. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued. The order passed by the second respondent Assistant Commissioner dated 13/10/2023, so-and-so at Annexure L, as also the order passed by the first respondent Deputy Commissioner at so-and-so on 5/3/2024 at Annexure M are hereby quashed. The order passed by the Tahsildar dated
29/4/2022. 29/4.
29/4/2022 at Annexure H is confirmed. A mandamus is issued to the third respondent Tahsildar to restore the names of the petitioner in the petitioner and his predecessors in the record of rights by deleting the name of the fourth respondent Waqf board within a period of 30 days from the date of receipt of a copy of this order. Liberty is however reserved to the fourth respondent Waqf board to initiate appropriate proceedings.
Seal number 6, Sri Arun Kumar Amargundappa.
Needful is done, madam.
Counsel for the petitioner submits that amendment has been carried out and amended petition has been filed. Registry to verify.
Filed the statement, my lord, kindly dispose of the matter.
Hmm?
I have filed the statement, my lord, producing the document, what they are made allegation.
Preliminary hearing ಎಲ್ಲ ಜಾಸ್ತಿ ಇದಾವೆ. ಯಾವ್ದು ಸ್ವಲ್ಪ ತಗೊಂಡಿದ್ವು ಅದು ಮುಗಿಸೋಣ.
Objection.
We have not taken it up earlier. We
No.
have to hear you afresh. Let it come after vacation. There are a lot of other parted matters which we'll have to finish. We list on 25th October.
Seal number 7, Sri VK Naik, Sri Vinayak Hapte. Petition.
Notice to respond number 1 has been dispatched on 30/9/2024, awaiting service. Relist on 30th October.
Interim order.
Interim order idea. Interim order earlier granted is extended till next date of hearing.
Serial number 8, Sri Liaquat Farid Ustad, the Siddhalinga Basraj body.
Please to respond number 1 has been dispatched on 25/9/2024.
Yeah, we have filed yesterday only. They have filed wakalat. We have served the copy. Acknowledgement is also filed, but it seems it's not attached to the.
Sidram Basraj Wadi ಹಾಕಿದಾರಲ್ಲ.
So,
Where is he? ಯಾರು ಸಿದ್ದರಾಮ್ ಬಸವರಾಜ್ ವಾಡಿ
my lord,
ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾರೆ, ಅವ್ರು ಕಲೀಗ್ ಇದ್ದಾರೆ. ಫೇಲ್ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ನನಗೆ.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಪಾಸು.
ಇಲ್ಲ,
Serial number 9, Sri Santosh Hanumantrao, the Amarashes Roja.
Password. I'm filing the statement of objection with the documents.
ಪಾಸು.
Serial number 10, Sri Punit Markal.
Council submission with regard to office subjections, I have produced the mutation copy from the online website, my lord. And the last date of hearing, your lordship has directed me to produce the, how land is granted. I have produced a memo along with the document, my lord. It is. Land was granted in favor of the father-in-law of the petitioner. And I produced the RORs.
ಎಲ್ಲ ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್. All land tribunal order ಅಲ್ಲಿ Waqf, how can it be claiming?
That notification was taken into consideration. 73, 74 and as well as
ಈ land tribunal orders are not reflected in the RTCs.
It's reflected.
Land tribunal order dated so and so ಅಂತಿದ್ಯಾ? ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ.
Of the name of those. That is.
ಅದು seems to be
regarding
the
order is
problem.
not there.
Because land tribunal order ಯಾರಿಗೂ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
Only they reflect the mutation so and so, MR number.
ಅದ್ರಲ್ಲಿ ಅರ್ಲಿಯರ್ ಮ್ಯಾಟ್ರ್ ಅಲ್ಲಿ ಇದೆಲ್ಲ ಅವಾಗಲೇ ಇದು ಮಾಡಿದ್ದು. The Principal Secretary Revenue Department, one of the reasons why the aforesaid orders are being passed by the Tahsildar is that the Tahsildar has no reference or knowledge of the orders passed by a land tribunal. I am therefore of the considered opinion that there would be a requirement for entry of the details of a land tribunal order in the RTCs. With reference to the proceeding number and the date of the order, so that the authorities dealing with the said properties would be put on notice of such orders. Hence, the Principal Secretary Revenue Department, in association with the Principal Secretary E-Governance Department, are directed to cause entry of the orders passed by the Land Tribunal under various enactments with reference to the proceeding number and the date of order in all the RTCs as regards lands which have been granted by the Land Tribunal. A detailed a compliance report to be filed within a period of 6 weeks from now. Released on 27th November. Learned SCGP is directed to bring the above order to the notice of the Principal Secretary Revenue Department and the Principal Secretary E-Governance Department. Registry is direct print the name of learned, name ಹೆಸರು ಇದೆ ಅಲ್ಲ. Again, ಇದ್ರಲ್ಲೂ same problem. Sri Liaquat Farid
No,
Ustad.
my lord. Naresh, sir, is, lordship is directed to order notice.
ಆಗಿದೆಯಾ?
Please, my lord, on the last date of hearing.
ಇಲ್ಲ ಆಗಿಲ್ಲ. ಈಗ ನರೇಶ್ ಆಯ್ತು ಇವತ್ತಿನ ಕೋಟ ಬಳಿ ಅಂತ ಕೋಟ ಒಂದಾಯ್ತು. ನೆಕ್ಸ್ಟ್ ಲಿಯಾಕತ್ ಲೈನ್. Sri Liaquat Farid Ustad is directed to accept notice for respond number 6. Learned SCGP accepts notice for respond number 1 to 5. The petitioner is before this court seeking for the following reliefs. The petitioner claims that the land in survey number 328/2 measuring 5 acres, 5 guntas, situated at Gogi K village, Gogi Hobli, Shahpur Taluk, Yadgir district, had been granted in the name of, in favor of
Father-in-law of the petitioner, my lord.
Israel.
Sir,
Sayyid
Habibullah.
Ismail Hussaini, the father-in-law of the petitioner, on
on 30th 12/1981. I produced the memo along with
12/1981. In furtherance thereof, his name had been entered into in the revenue records.
in the year 1998-99.
In the year 1998-99 and continued on the records till 23-24. Yavaga Hussaini, when did he expire?
But yes, expired. The
Till the
petitioner's
year
name is entered in the-
2016-17.
Please, ma'am.
Subsequent to the death of the said father-in-law, the husband of the petitioner succeeded to the aforesaid property and his name was entered into the revenue records in the year 2016-17. The husband of the petitioner had also expired on 2/5/2023 and the petitioner is in the process of making necessary application.
No, my lord,
Oh.
petition name is also entered in the 2024-25. I have produced
ಇಲ್ಲಿ ಬರ್ದಿಲ್ವಲ್ಲ?
page number 25.
ಸರಿ, pleadings ಅಲ್ಲಿ ಬರಿಬೇಕಲ್ಲ
Please, madam, I
ನೀವು?
will-
And the name of the petitioner, Majahar Begum, was entered into in the revenue records on 15/6/2024. It is at that time the petitioner came to know of the entry of the name of respondent number 6 on a direction issued by respondent number 5 in column number 9 and 12(2), in column number 2 of the record of rights. The said entry having been made without issuance of any notice to the petitioner or her husband or even her father-in-law. Please. So also allowed.
Lord, on submission, serial number 8 ನಲ್ಲಿ ಅವರು, the council is serial
Huh?
number 8. Password.
Sidram Basraj Wadi.
Yes, ma'am.
On behalf of Sidram Hasan.
Huh. Ready?
I have filed wakalat yesterday only, my lord.
So 15th ಗೆ ಇದು ಇದೆ ಸ್ವಾಮಿ. The auction is there on 15th.
But nenne wakalat andre how will he get ready? We can only reserve liberty to move the vacation court. ಇರ್ತೀರಾ vacation ಅಲ್ಲಿ? ಇಲ್ಲ ಮಧ್ಯಾಹ್ನದೊಳಗೆ ನೋಡ್ತೀರಾ? CPC matter, ಏನ್ application ಏನು?
No, my lord, it is, we have taken loan of amount 15 lakhs.
ಹಾ.
Now they have filed a execution before the trial court. Their my lord proceedings are pending. During pendency of that, they are also simultaneously taking up the auction sale, which I have produced along with them.
They can always do. ಎಷ್ಟು ಕೊಡ್ತೀರಾ ದುಡ್ಡು ಹೇಳಿ?
Now we are seeking for stay of that, my lord, because
You owe the money, they are entitled to take surface action. 15 lakhs is the amount due.
my
How
lord,
much are you willing
we
to
are
pay?
ready, 5 lakhs with,
Get the instructions from your client. 5 lakhs within what time?
within 4 weeks.
And balance?
Balance, my lord, as far as their. we will talk
Yearly
to
joint
them.
memo haki, we will take it up. We have no jurisdiction unless you agree.
Whatever lordship suggest, I mean.
You verify from your client, not for us to suggest. You get instructions from your client. Password by afternoon you. get it.
230, my lord. 230.
2:30.
Case number 11, Sri Arja Bhusre.
Appearing for petition. For the office objection is that, my lord, page number 22,
Hmm.
in the impugned order, my lord, the particular date has not been mentioned, my lord. The name of Karnataka government has been entered in the revenue records, my lord.
In 95,
Yes, my lord. Yesterday, 2 writ petitions and the arising out of same impugned order.
And SCGP accepts notice for respond number 1 to 5. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the name of the petitioner was deleted from column number 9 and 12 as regards the land owned by him in survey number 103/4, measuring 30 guntas, situated at Rajola village, Basvakalyan Taluk, Bidar district, without issuance of any notice on the ground that there is that the said property has been used for non-agricultural purposes by omnibus order, undated order at Annexure D passed as regards 44 other properties. Submission Shri R.J. Busre, learned counsel for the petitioner, is that no notice had been served to the petitioner or the other 43 persons named in the said order. There is complete non-application of mind and violation of the principles of national justice. A perusal of the impugned order does not indicate any notice having been issued to the petitioner and or providing an opportunity to the petitioner to respond thereto. In that view of the matter, I pass the following order. Writ petitions are allowed. A certiorari is issued. The order dated so-and-so at Annexure D is hereby quashed. A mandamus is issued directing respond number 4 to restore the name of the petitioner in respect of property bearing number so-and-so within 60 days of the receipt of a copy of this order. Liberty is reserved to respond number 3 to initiate such proceedings after issuance of necessary notice to the petitioner. Please.
Serial number 12, Sri J.J. Chakshetty.
Appearing for the petition, my lordship.
In-
My lordship, with the
Petitioner
liberty
is
to.
before this court seeking for the following reliefs. Memo dated 1/10/2024 has been filed signed by the counsel for the petitioner, which reads as under. Accepting the memo and the submission of the counsel for the petitioner is dismissed as withdrawn, reserving liberty to the petitioner to avail of the alternate remedy provided in Rule 19 of Order 41 of the Code of Civil Procedure.
Serial number 13, Sri D.P. Ambekar.
Challenging the entire tender filed by the.
Certified copy of Annexure E.
Yes, ma'am.
What is Annexure E?
Annexure is not the online print,
Online print.
online tender print.
Counsel for the petitioner submits that Annexure E, which has been produced, is a printout from the website and there is no certified copy available. Accepting his submission, office objection CL number 19 is overruled.
Yes.
Yes.
On merits, my lord.
Hmm.
The respond number 3, my lord, he called for a tender
Hmm.
for supply of security force to the university,
Hmm.
manpower agencies.
Yes.
Kindly page number 9, my lords.
Hmm.
I have a tabular formal kottidini. In the first tender, my lords, the audit reports of 2022-23 minimum of 15 lakh turnover, I put it in bold for easy this thing,
Hmm.
was required, and income tax assessment for 22-23 was required. And second point number 10 of this thing, it is found on page number 28, that a bidder should have for 3 years in any government department, that was the requirement.
Hmm.
And minimum 40 lakh in respect of single work tender, it was mandatory. In spite of the respond number 4 not being qualified, even because that firm was floated just 1 year prior to the tender, they selected respond number 4 illegally. I filed a detailed objection before the respond number 3 registrar of the university, highlighting the illegality committed by him. What they do, they promptly scrap the first tender. They issue a fresh tender,
Hmm.
tweaking the conditions so as to accommodate the respond number 4 illegally. Just like that Augusta Westland scam, just to it, this thing, it is reduced from 22-23 onwards, 2 years ಅಂತ ಮಾಡಿದ್ರು. And income tax, this thing was removed.
And 15 lakhs ಮಾಡಿದ್ದಾರೆ.
Yeah, 15 lakh ಮಾಡಿದ್ದಾರೆ, just to tailor made for the this thing, respond number 4.
See, they have reduced it. They have not increased it.
Hmm.
So by reduction, you are also eligible to participate.
True, madam.
By what has been held by the apex court in some of the decision is, if the condition is made in such a way
To
that
exclude
it will
others.
deprive
Ah.
or some others,
Yes.
then that condition can be challenged. Here is a condition which has been reduced, which will enable more number of people to participate.
True.
That cannot be a ground.
And again, they select him only. That also is challenge.
You also had an opportunity to participate and give a better tender. It does not oust you.
Huh.
If it ousted you, yes, that's a ground.
Yes.
It does not oust you. It is, in fact, allowing you and several others.
My contention is, my lord, it was a predetermined this thing, just going through the motions.
So long as the bid submitted is proper on the lowest or highest, then services for
So manpower agency,
lowest
lowest.
qualification is there, then this cannot be a ground.
Right, just I want to highlight this thing, what is going on in universities. I'll hand someone sir madidre next date it will immediately after vacation it can be taken.
If
Just
you are
at least
able
let
to
them just,
establish bias, we'll deal with them.
Yes, not. That also I'll
uh,
file additional pleading highlighting the bias.
Learned SCGP accepts notice for respond number 1. Raichu University ಯಾರು?
Yeah, I'll take hand summons to 2, 3 and 4.
ಯಾರ ಇರ್ಬೇಕಲ್ಲ?
ಯಾರಿದ್ದಾರೆ?
ಯಾರಪ್ಪ?
Mantesh Patel for
Mantesh
2 and
Patel.
3.
ನೀವು ಪೆಟಿಷನ್ 2 ತಿಂಗಳಿಂದ ಅಷ್ಟು ಟ್ರೈನಿಂಗ್ ಆಗಿರ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಬ್ಯಾಚ್ ಬಂದಾಗ ಇವ್ರು ಅಂತ ಹೇಳ್ಬಿಡ್ಬೇಕು ನೀವು.
Please.
Sri Mantesh Patil accepts notice for respond number 2 and 3. Issue emergent notice to respond number 4 returnable by
Raichur Raichur. Idhar hai.
28th October.
Raichur
Counsel
University
for the petitioner is also permitted to take out
Fine.
hand summons on respond number 4.
Please. Well, sir.
ಎಲ್ಲ ಇಲ್ಲೇ ಇದ್ದಾರೆ.
Serial number 14, Sri Ravi B. Patil.
ರಾಯಚೂರ್ ಬಾಳ ಇದಕ್ಕೆ ಅವರೇ ಅಪಿಯರ್ ಆಗೋದು.
Please.
ರಾಯಚೂರ್ ಅಂದ್ರೆ ಅವ್ರ ಹೆಸರು ಬರುತ್ತೆ. ಬಿಜಾಪುರ್ ಅಂದ್ರೆ ರತ್ನಾಶಿವೋಗಿ ಮಠ ಅಂತ ಬರುತ್ತೆ. ಬೀದರ್ ಅಂದ್ರೆ ರವಿ ಪಾಟೀಲ್. ನೋಡಿ ಹೆಂಗ್ ಈ ಕಡೆ ಬನ್ರಿ, ಯಾಕ್ರಿ ಅಲ್ಲಿಂದ ಹೋಗ್ತೀರಾ?
Serial number 14.
What is 19?
My lord, the petitioner, my lord, is the owner of,
What is 19?
my lord, now, my lord, notice,
Issue
my
of
lord,
annexure F. What
Yes,
is annexure F?
office objection, my lord, page number 125, my lord, annexure F. This is a public notice, my lord, affixed on the premises of the petitioner.
ಅದಕ್ಕೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ.
Other premises,
Registry
my
is
lord,
raised.
together. It doesn't even bear the.
Objection as
My lord,
regards certified copy at annexure F, which is a photograph. Accepting the submission of the learned counsel for the petitioner that there is no certified copy available. Office objection at serial number 19 is overruled. Yes.
my lord, the petitioner being the owner of, my lord, the plots, my lord, the open space, my lord, 6, 7, 8 and 9.
Hmm.
Not having purchased the property under registered sale deeds, he is in possession and enjoyment of the same. My lord, here the entire issue, my lord, started because of, my lord, the railway department name is being entered in the revenue records in the year 1966 without any acquisition, without any authority.
66.
1966 nalli.
How can you
Same
say
was-
now?
Same was dealt with, my lord, by this court, my lord, in writ petition number 40038 at annexure D, page number 102, where, my lord, railway department had initiated the proceedings challenging the order of the land tribunal in favor of one of the beneficiary.
Hmm.
May I take your lordship to page number 108, my lord?
Yes.
My lord, the various persons' name which are being reflected, entire survey number 31, my lord, measuring 32 acres, were standing in the name of different persons. May I take your lordship to page number 108. First, my lord, 15-acre 12 guntas, my lord, in the name of, my lord, railways, 4-acre in the name of one Asha Begum, then, my lord, 5-acre 20 guntas in the name of another Asha Begum, 1-acre 20 guntas in the name of Ismail. My lord, several persons are being entered in the name of, my lord, in the revenue records. Then, my lord, the authority started claiming, my lord, the right over the property, my lord, by contending that it is a railway property. May I take, my lord, your lordship to, my lord, the specific observation made by this court, my lord, at page number 112.
Yes.
The present writ petition, second line, my lord, the present writ petition is filed on so and so on perusal of the pleadings in the writ petition. It is quite unfortunate to note that there is absolutely no material placed on record to demonstrate how the petitioner Union of India has acquired title over the petition land measuring 15-acre 12 guntas. Even till today, the petitioner has not placed any clinching evidence indicating that the petitioner has got a subsisting right over the petition land. The only document on which the petitioner is laying a claim over the petition land is based on the entry in the revenue records. Such a stray entry in the revenue records would not confer any right to the petitioner. However, this court cannot go into the question of title of the petitioner Union of India insofar as 15-acre 12 guntas is concerned. Here, my lord, though my lord observed that there is no material, the court said it will not go into the title. Then, my lord, specifically, my lord, in RSA 409, where a specific issue between, my
You are
lord,
claiming right over which land?
my lord, entire 15-acre 12 guntas, suddenly, my lord, in the year 66, the name of railways has been entered. I am claiming,
You
my
are
lord,
part
right-
of the 15 acres.
I am claiming under, my lord, survey number 31. My vendor, my lord, has executed, my lord, sale deed.
You are claiming right on 15 acres, 12 guntas.
No, my lord, I am not claiming under 15
Then
acre.
under which land
My
are
lord,
you claiming?
my land is beyond, my lord, 15-acre 12 guntas, my lord, which is been sold in my favor pursuant to, my lord, the sale deeds.
How
which
do
are
you say that?
My lord, the sale deeds, my lord, at annexure,
They
B,
won't obviously refer to 15 acres, 12 guntas.
they have
So
referred
how
to.
do
my
you
lord,
say, is there a sketch of the property?
My lord,
thing
sketch
which you
of
have
the,
produced?
my lord, the total extent is more than 30 acres. Total extent is more than 30 acres.
ಈ 15 acres ಅದ್ರ ಹೊರಗಡೆನಾ ಅಂತ
ಇಲ್ಲ, ಅದ್ರ ಒಳಗಡೆ ಇಲ್ಲ.
ಹೆಂಗ್ ಹೇಳಕ್ಕಾಗತ್ತೆ?
My lord, it is
ಇಲ್ಲ,
only,
ನೀವ್ ಹೇಳ್ಬಿಟ್ರೆ
my lord, they have conducted a survey, they have done a survey in other matters.
ಇದು ಸರ್ವೆ
also.
ರಿಪೋರ್ಟ್.
They are not ready to produce those survey reports. That is what been observed in the next matter, my lord. That is the reason, my lord, I am. In this case, my lord, they have not issued any notice, my lord, nor there is any inquiry.
The writ petition that you are reading did not deal with 15 acres, 12 guntas, but dealt with 1 acre, 20
Oh,
guntas
only 1 acre.
outside it.
Yes,
So
yes,
this order
yes.
will not help you in
Yes.
any manner.
but 15 acre, 12 guntas was the claim made by the
There's
railway
no,
department.
there's no finding,
Please,
Mr. Patil.
please,
There's no
please.
finding which can help you.
please.
So what
Fine.
will help you?
Then specific finding in RSA 409,
Where is that order?
my lord, annexure C,
Page,
page number 87 onwards.
relevant portion.
Again, there, my lord, the order of, my lord,
ಯಾವ್ದು
repetition
ಸರ್ವೆ
was,
ನಂಬರ್ ಯಾವ್ದಿದು?
uh,
31D.
Same, sir.
31D, 17 acres, 12
ಹೌದು.
guntas. Yes.
My lord, there also, my lord, para 11, my lord. The dispute was again, my lord, with respect to 1 acre 20 guntas, and the claim is in excess of 15 acre 12 guntas, what been considered by the court. Para 12 on the railway department claimed, my lord, 17 acre 12 guntas.
You are not challenging the order in writ petition.
No.
RSA, at this stage, no instruction, my lord. Like secure instruction, I submit. my lord.
So now what has happened?
Now, my lord, this public notice has been affixed to my property.
By whom?
By, my lord, it refers to, my lord, land belong to South Central Railway, page number 125, my lord. Land belongs to South Central Railway, vacate, remove unauthorized structures within 15 days.
How are you doing this after suffering 2 orders, Mr. Sudhir Singh? How can you post this after suffering 2 orders? Vacate, remove without any notice to them also.
There is a alternative remedies before the district tribunal, my lord.
What alternative remedy that you have? You have to initiate proceeding and Public Premises Act. You cannot go and fix maybe the railways.
A secure instruction, my lordship.
Ride roughshod and then ride your engine on their property and their rights. You will stay at your file.
Please.
Shri Sudhir Singh Vijaypur accepts notice for respond number 1 to 3. The operation of the notice by affixture dated 27/9/2024 at annexure F is stayed till the next date of hearing. The response are restrained from any manner dispossessing the petitioner from the petition scheduled properties till the next date of hearing. Released on 7th November.
Cell number 15, Sri Ravi B. Patil.
Here is the case, my lord, here they have invoked the provisions of Public Premises Act.
Yaru.
Very same,
Notice is issued, my
South
lord.
Central.
Then you have to reply to it.
My lord, it is not the notice, it is the order.
FF1.
My lord, there was a dispute since 1991 with regard to, my lord, the location and, my lord,
If they have done it
title.
rightly, they have issued a notice, you reply.
My lord, it is not the notice, my lord, it is an order, 5-1. Order to evict. If it would have been a notice, I would have replied, my lord, denying their title and, my lord, relying on all the.
Public Premises Act.
Tribunal is there once.
If you don't, then only it becomes an order.
My lord, tribunal is there.
This is not an order.
It's on 5-1. Public premises eviction of unauthorized occupant act
Or-
1971.
Yes.
Not section 5 subclause 1 not
Oh, ಇದು 5 ಅಲ್ಲಿ ಮಾಡಿದೆ, 4 ಅಲ್ಲ.
final one.
We'll treat it as a notice under 4.
Let it be treated as a notice, we will reply to this.
There's no notice issued under 4.
But 2015, when we had preferred a suit seeking relief of
And then-
declaration and injunction,
Yes.
they had issued a notice, to which we had replied. Relying on 2015 notice, now they passes this order.
Where's the notice?
The order impugned, may I request,
They've issued a notice under 4.
Personal hearing on
2015,
12/8.
page number
2005.
191, page number 191.
That is annexure F.
Yes, my lord.
That is order number
paragraph.
5-1.
First paragraph, may I request, notice. You are in unauthorized occupation of a railway land measuring so and so, railway premises in survey number 31, show cause notice in form A was issued bearing so and so dated
You attended the hearing.
27/2015.
Yes. You
Though which
attended
were
and you have
given an
submitted.
opportunity to produce the documentary evidence on 12/8/2015. You have attended the personal hearing on 12/8/2015 before the estate officer and failed to produce any documentary proof evidence as proof so and so. Then they referred to RA 58 of 2015. These proceedings were pending before the civil court, where relief of declaration and perpetual injunction was filed by these petitioners before the competent authority court. That was decreed where injunction was granted against the authority. And the RA 58 of 2015 also I have produced the copy of the order.
Yes.
Page number 166 annexure E.
Page number?
166 Insofar as relief of declaration sought by us is rejected, however, injunction is been allowed. Holding that we are in possession since past more than 40 years, having constructed houses.
Where is injunction granted?
Injunction, may I take first your lordship to the order of trial court at page number 1.
Where is
60?
injunction granted by the first appellate court? First appellate court has
also.
dismissed your suit.
Confirming the order of trial court. Trial court only had granted the injunction. Page number
The
160.
suit of the plaintiff in OS number 85 is hereby dismissed with costs. 79 of 97 is dismissed with cost. 81 of 97 is dismissed with costs. The suit is dismissed. Appeal is dismissed. Where is the injunction order?
Original decree, common sense.
RA is also dismissed with costs.
RA dismissed.
ಅದೇ ಹೇಳಿರೋದು ಅವರು. Dismissed RA 58 with cost declaring that you are in encroachment of the railway property. So you have an appeal under section 7, you can go on appeal under 7 if you want. Not a writ petition.
I am on the point that the act provision of this act cannot be invoked for evicting the persons, because may I
Right.
take your lordship to section 2 of the act.
Yes.
What the definition of public premises provided under the act, my lord? Yes. Two subclause E, public premises.
Yes.
Number 1, any premises belonging to or taken on lease or requisitioned by or on behalf of the central government, and includes any such premises which have been placed by that government, whether before or after the commencement of the public premises eviction of unauthorized occupant amendment act 1981. 80, under the control and secretary of the either house of
Have you
parliament for
challenged the violence of
providing-
the act?
for providing residential accommodation to any member of the staff or the secretary. Any premises belonging to or taken on lease by on behalf of the property should belong to the department, and which should have been let out on either on lease or on authorized occupation should have been done. Then if I stay beyond the period which was authorized to, then they can invoke. May I take subclause 2, any corporation, then
Railways is included, Mr. Patil.
railways has been included, but this is not a case where we
Is
are
the
saying this
railway
is the
claiming
property
right?
of a railway. My lord, may I take
Whose
lordship's,
property are they claiming?
for that, my lord, may I take lordship's minute time, my lord, page number 97.
You made railway only a party, nobody else.
My lord,
You made only railways a party.
because they were interfering in the, my lord, our portion of the
They have
property.
issued the notice under the public premise. Please don't make these kind of submissions.
My lord, I may make the, why, my lord, this issue, my lord,
Now,
has.
you have already suffered cost twice. Those are all reasonable costs.
I'm sorry, my lord.
Here you will suffer costs in 4 or 5 numbers if you persist in these kind of arguments.
My lord, may I take only 1 minute?
ನೀವು
of the
ಹೇಳ್ತಾ ರೈಲ್ವೆ ಇದೆ ಅಕ್ವಿಸಿಷನ್ ಇದೆ ಸೂಟ್ ಹಾಕಿರಿ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಅಪೀಲ್ ಹಾಕಿರಿ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಇವಾಗ ನೀವು ಯು ಆರ್ ಸೇಯಿಂಗ್ ಇಸ್ ನಾಟ್ ಎ ರೈಲ್ವೆ ಪ್ರಾಪರ್ಟಿ
ಏನ್ dispute ಇದೆ?
ಯು ಓನ್ಲಿ ಫೈಲ್ಡ್ ಇಟ್ ಅಗೇನ್ಸ್ಟ್ ರೈಲ್ವೆ ಸೂಟ್ ಅಲ್ಲಿ
ಹೌದು.
ಹಾ ಮತ್ತೆ
Because they were interfering ಅಂತ ಹಾಕಿದ್ದು.
ಆಯ್ತು
May I take only 1 minute of the court, my lord, for my satisfaction,
not your
I have not, my
there's an
lord.
order passed under 5(1) after issuance of a notice under 4. Your remedy is under 7, not by way of a writ petition.
My lord,
This is
the fine,
unnecessary litigation.
the fine, I have lost, my lord, my right, my lord, the relief of declaration is been rejected. Yes, my lord, I do admit.
This court has no jurisdiction on a 5(1) order.
My lord, my ground in the present writ petition is, my lord, the authority cannot invoke 5(1) or, my lord, the provisions of the act against.
You can take it up there on appeal.
My lord, may make.
That is reserved to you to take it up
The
there.
reason why I have suffered, my lord, the order by, my lord, first appellate court is very, my lord, technical aspect, my lord. That is the reason I am making, my lord, this
It's
submission.
not technical. Your
I'll-
suit has been dismissed with cost, your appeal has been dismissed. It's not technical.
I request, my lord, a minute time, my lord, my lord.
Yearly minute.
My lord, this is the layout where, my lord, we have purchased the property, which is approved by, my lord.
We are not concerned with that. We are concerned with the railways saying that they are it's their property. They have exercise powers under Public Premises
My
Act.
lord, the court itself.
You have
has-
filed a suit which has been dismissed, holding the railways property.
My lord,
There's a
it's not-
finding.
No, my lord, they are not, that is the reason I was drawing attention of the court to, my lord, page number 97. Para 24, my lord. 97 may request, my lord. 97. As per the case of a defendant number 1 and 2, they have got measured the railway property in 1997 and found that the suit plot and other plots are part and parcel of land bearing survey number 31 belonging to it. In order to substantiate same, the
Please
defendant.
come to page 125 where the trial court has observed. It is necessary to mention here that if really there was an encroachment as alleged by the defendants, that is railways, the course open to them was to inquire in 94 and invoke the provision of Unauthorized Public Premises Act.
That observation itself.
That
has been
observation
taken in
is there.
advantage of, my lord, the authority.
And that is why that is the contention that you took up there.
My lord, that is the same contention which is recorded here, my lord. May I
You
request.
took up the contention there that Public Premises Act ಅಲ್ಲಿ ಅವ್ರು ತಗೊಂಡ್ಬೇಕು ಅಂತ. ಇವಾಗ ಇಲ್ಲ
No,
ಅಂತ.
ಮಾಡಿಲ್ಲ, sir. It is the observation of the court. That is the reason I was showing. I request your lordship to bear me for, my lord, a minute, my lord.
ಹೇಳಿ.
My lord, this I would like to, my lord, draw, my lord, 24, page number 97, my lord.
97.
As per the case of defendant number 1 and 2, they got measured the railway property in the year 1997 and found that the suit plot and other plots are part and parcel of the land bearing survey number 31 belonged to it. In order to substantiate the same, the defendant not at all produced the said joint survey map. During the course of cross-examination DW1, to the question put by the court, it is stated that he has produced the same in another suit in OS number 18 of 97. It is undisputed that there are 2 more suits before from the defendant side and several other connected suits are pending in respect of the matter in dispute between the land in survey number 30 and 31. As per the settled principle of law, in case of a boundary dispute as now raised by the defendant number 1 and 2, the position of parties are that of a counterclaim, and it is duty of the defendant that of the plaintiff to aid the court in ascertaining the true boundary of the railway property, and so also land bearing survey number 30. But unfortunately, both plaintiff and defendants are failed to produce the best evidence available with them about the joint surveys admittedly conducted by the railway department and state government or layout of survey number 30. In the absence of such metal document evidence, I am unable to give any opinion about such alleged measurement of a defendant or location of the disputed plots either in survey number 30 or 31. It is necessary to mention here that if really there was an encroachment as alleged by the defendants, the course left open to them to inquire under section 94 of the Land Revenue Act or invoking the provisions of unauthorized occupancy. This observation, they are taking advantage of the.
They have to take action in accordance with law.
But if
That
they-
is why the order has been passed.
Now, my lord,
Dispossession from the suit properties without due process of law.
yes, my lord.
That is what due process they are following.
My lord, but that is the reason, my lord, I am challenging the order, saying that, my lord, this
You
act
cannot
is-
challenge here. You have to file section 7.
It would be under section 9, my lord, not under 7.
7 and 9.
9, but. My lord, again, my lord, it will be again before the very same district. judge
9,
where, my
9.
lord,
Appeal is under 9.
It will be again before the very same district judge.
Who is the same district judge?
My lord, where,
ಏನ್
my lord,
ನೀವು
I have
ಯಾಕೆ
suffered an
ಇವತ್ತು
order.
ಏನೇನೋ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
I have suffered an order under RA.
Yes, we
Again,
understand
it
you
will be
suffer
for the
an
very-
order, but you will have to take recourse in accordance with law.
That process, my lord, I have, my lord, these people, my lord, have failed to prefer appeal within time, my lord, there is a limited.
We'll extend that
They are,
time
my lord,
for you. You
uh,
file an appeal.
What I would request, my lord, since forceful action is, my lord, is sought, my lord, to be taken. If
By when will you file an appeal?
appeal, my lord, I have prepared, my lord, already yesterday night, my lord, today I am preparing, but
Appeal
for
ಬದಲು
some
ಇದು
reason-
ಎರಡೂನು ಪ್ರಿಪೇರ್.
for some reason, since yesterday I have no.
ಯಾಕೆ ರವಿ ಇದೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
I tried to, my lord, file it tomorrow, today morning and ಇವತ್ತು
So
ತಗೊಂಡು
ಇವಾಗ ಯಾವಾಗಪ್ಪ ಫೈಲ್ ಮಾಡಿ? ನಿಮ್ಗೂ ಗೊತ್ತಿರೋದೆ. ಯಾವಾಗ ಫೈಲ್
My
ಮಾಡ್ತಾರೆ?
lord, immediately, 10 days, my lord, immediately after reopening, my lord.
10 days ವರೆಗೂ don't take any action.
After reopening, my lord, ಮತ್ತೆ vacation ಅಲ್ಲಿ ಮಾಡ್ಬಿಟ್ರೆ
See-
ಕಷ್ಟ ಆಗುತ್ತೆ. ಇಲ್ಲ, within 8 days.
Shri Sudhir Singh Vijaypur accepts notice for respondent 1 to 3. The petitioner is before this court seeking for the following leaves. The petitioner as an alternative efficacious remedy in terms of appeal under section 9 of the Public Premises Eviction of Unauthorized Occupants Act 1971 as regards the impugned order passed under subsection 1 of section 5 of the said act, reserving such liberty, the petition stands disposed of. Respondents are however restrained from taking possession of the property for a period of 15 days from today. Liberty is also reserved to the petitioner to move an application for interim orders in the appeal as and when filed.
Vacation till 13th.
15 days, appa. ಇವತ್ತಿಂದ 16th
Vacation
ವರೆಗೂ
till
ಬಂತು.
13th. Vacation till 13th.
20 days.
Please. Highly okay.
Bill number 16, Sri Sachine Mahajan, Sri MS Devraju.
Annexure G, my lord, is downloaded from the official website. Lord,
Registry
page number
is-
125 onwards, my lord, the Kannada manuscript.
Objection as regards legibility of annexure G.
Annexure G, my lord, is at page number 95.
May I make one submission? I appear for the response.
For the respondents in cell number
2.
16, Mr. Ravi Varma Kumar,
Yes, yes.
Dr. Kumar?
Yes, I'm appearing in 16.
Yes. One
This
minute,
is
we'll take-
challenging a tender notification.
Just one moment, please, just one moment.
Yes,
The registry has raised an objection as regards the legibility of annexure G. The counsel for the petitioner submit that the same is a printout. ಇದೇನಪ್ಪ ಇದು 125 ಅಲ್ಲೆಲ್ಲ ಏನು ಇಲ್ಲ, ಕನ್ನಡ ಇರ್ಬೇಕಿದು.
Kannada is
ಹಾ,
I'll, my lord,
ಮತ್ತೆ?
supplement, my lord, a proper copy.
You should install Kannada fonts in your computer before taking a printout.
My lord, it was supplied by the client, my lord, in a hurry. My lord, I am not relying on
Presence
that
of-
portion, my lord, nevertheless, my lord, I'll make a.
Page 125 onwards indicates that nothing can be seen except boxes.
My lord,
Hence,
I will, my lord.
The counsel for the
At this stage,
petitioner
Lord, I'm not relying on that.
is granted 2 weeks' time to produce a proper readable copy of annexure G. Yes, Dr. Kumar?
My lord.
ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ಹೇಳ್ತೀರಾ, ನೀವು ಫಸ್ಟ್ ಹೇಳ್ತೀರಾ?
Yeah, I'll just show one. Kindly come to the impugned tender notification. Page 95, my kindly see.
99,
25.
95,
95.
95, 95.
Yes. Yes.
Kindly permit me to show the date. Last date and
Hmm.
time for submission of the tender is 18/10. Before that,
Yes.
pre-bid meeting is on 39.
Yes.
It was scheduled to
Yes.
be held yesterday, but it has been postponed to 3rd. The object of inviting the pre-bid meeting is whatever grievances the intending tenderers have, they are entitled to come and tell us what are their grievances. Now,
Yes.
kindly permit me to show that the notification pre-tender meeting details are given at page 105. 105.
Hmm. Yes.
What we propose to do in the pre-bid meeting that is going to be held on 3rd October.
Yes.
The tenderer or his authorized representative is invited to attend a pre-tender meeting, which will take place at Bangalore headquarters. The purpose of the meeting will be to clarify issues and to answer questions on any matter that may be raised at that stage. The tenderer
Yes.
is requested to submit, etc., etc. So we are, the whole thing is being done transparently. So if they have any grievance, they can raise it in the pre-bid meeting.
What is their
Thereafter,
grievance? We still don't know what their grievance.
What happens,
Let
percent?
Dr.
The
Kumar,
grievance
let
is this. The grievance, no, the
let
grievance
the
is this.
petitioner make his submission.
No,
Let us see what his
no, no, all
submission
that-
is.
No, all that I am saying is, I will file my objections. The last date is 18. Before that, I will file my objections. Matter may be taken up immediately after revoke. Actually, it
Yeah,
is
what is your-
premature.
Your Lordship, my Lord, may kindly turn to page number 98.
Yes.
My Lord, Annexure G, it starts at page number 95. The
What
11th
is your
portion, my Lord.
grievance, Mr. Mahajan?
Page number 98, my Lord. Point
eight.
number 5, my Lord. The borewells to be drigged under Ganga Kalyana for the year 2023-24 and 24-25. 23-24, your Lordship may kindly, my Lord, mark that portion. Then kindly turn to, my Lord, page number 102. In that, my Lord, clause 3.2.
Yes.
To qualify for award of the contract, each tenderer in its name should have the last 5 financial years, that is 2019-20, 2021, 21-22, 22-23, and 23-24. My respectful submission, my Lord, the first leg of the submission, my Lord, is that 2023-24 cannot be included because page number 98 says, my Lord, it is the tender is issued for 2023-24 also. And the standard tender document, my Lord, which is
23-24 is the financial year, right?
for the preceding financial year, my Lord, for which the work is issued. They cannot include, my Lord, 2023-24.
Work is already done for 23-24.
No, my Lord, 23-24, my Lord, the tender is now issued.
How can that be?
My Lord, that's what, my Lord, I was submitting, page number 98. Borewell to be drilled under Ganga Kalyana for the year 2023-24 and 24-25.
We'll ask him. Okay.
Then your Lordship, my Lord, will find, my Lord, the clarification with regard to this. Page 26, your Lordship kindly turns, my Lord. The standard tender document, my Lord, gives clarification with respect to each and every aspect.
Yes.
In that, my Lord, A anta heli, my Lord, there is a general scope of the tender, Kelagade Swami. The fine prints, tender inviting authority, then there is, my Lord, clause 3. For tenders invited during FY 2005-2006, my Lord, here.
Yes.
For other years, they should be to those 5 years preceding the financial year in which the tender is to be invited.
Yes.
Now, tender is now invited for 2023.
It's only a clarification.
That is a clarification. Nevertheless, my Lord, they cannot, my Lord, include 2023-24 because my Lord, that will have a cascading effect.
That is the only grievance you have.
That is not the only grievance. This is first grievance.
What
The second
else
grievance, your Lordship may kindly see. My Lord, achieved. I'm reading, my Lord, 3.2 clause A. Achieved in the last 2 financial years, minimum financial turnover of 1270 lakhs, usually not less than 2 times of the estimated amount of the package.
Yes.
Now, my Lord, the standard tender document, my Lord, again, I have to refer to, my Lord, page 26. This clause, 3.2, my Lord, in page number 26. To qualify for the award, the contractor each tenderer in its name should have in the last financial years 2000 so and so. A. Achieved in at least last 2 financial years, minimum financial turnover. My Lord, this is important, my Lord. In all in all classes of civil engineering and construction work only, my Lord, this is important. Usually not less than 2 times of the estimated annual payments. Now, this 2 times of the estimated payments, my Lord, it has to be only for the purpose of, my Lord, civil work. Here is the tender, my Lord, for, my Lord, rigging, my Lord, drilling the borewell, my Lord, civil contract is not required.
Next,
my Lord, your Lordship, my Lord, clause C, my Lord. The tenderer should have drilled in only in 1 or, my Lord, clause C, my Lord, if I am permitted to read.
Yes.
tenderer should have
324
drilled
was not
in
less than
any 1
80.
year or at least 5 years, that is 2019, 20, 2021, 21, 22, 23, 24 and 23, 24. Now this has a cascading effect, my lord. First of all, I am required to, my lord, furnish financial details, my lord, for the year 2023, 24 when the work is
Your
not done.
basic argument is 23, 24 on
23,
which basis.
24. Apart from that, my lord,
Hmm.
the civil works, my lord, 2 times of the amount.
Yes.
Then, my lord, another, the point that is, my lord, try to be, my lord, urged before your lordship is,
Hmm.
the amount of work, my lord, has been exponentially raised. If your lordship kindly turns again, my lord, to page number 98, the proposal is, my lord, for 402 borewells and the approximate value of the work is 635 lakh rupees.
Yes.
The estimated cost is 635 lakh rupees. Per borewell, it will come to 1,50,000.
Yes.
This, my lord, if the previous 10 years tender is to be seen, my lord, annexure H at page number 153, the relevant portion, my lord, is at page number 159. To cite an example, my lord, this is
That cannot be a
furnished.
ground.
My lord, I will, my lord, I will refer to the standard tender document, my lord.
You are taking a risk of your petition getting dismissed now.
My lord,
You are taking a risk of the petition being dismissed now.
my lord, that
To
will
go
have,
by Mr. Dr. Kumar's
that
submission
will have a
he'll file
cascading effect, my lord.
only 23, 24.
Yes, my lord.
That is a issue
Lord,
that will have to be
my lord, to show
clarified
the
in the
malafides,
pre-bid.
my lord, I am urging these grounds also.
The other grounds are
But-
not
but-
available.
My lord,
in a
attributing
text.
malafides, my lord, I am, my lord, compelled to make these submissions before.
Malafides Torsi, that somebody is being favored.
I have,
This,
I have said so, my lord. I have urged in the writ
with
petition.
who have you identified?
My lord, a particular cartel, my lord, they want to favor.
ಹೆಸರು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೆಸರು ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ
My respectful
somebody to
submission,
favor ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ ನೀವು. You have to
my respectful submission, this 23, 24 will have a cascading effect. I'll, my
23,
lord,
24 they will clarify in the pre-bid meeting. Dr. Kumar, how can it be for 23, 24? It's already over.
I'll answer that question. Before that, may I draw the attention? No, I may draw the attention to page 65 for a minute. Submissions are being made contrary to the facts. I have to point out.
Yes.
We liberalize the tender qualifications so that more
ಅದು ಬಿಡಿ
people will
qualification ಅಲ್ಲ. Only basic submission is as regards
23,
you're called for a tender for a year which is already over. FY 23-24 is over.
the 23-24, 23-24, we had floated the tender. That was also challenged by the petitioners. We have floated the tender. They have withdrawn. That is not placed before the court. 24 June 2024, those writ petitions were withdrawn. My learned friend used the word cartel, which I did not want to use it. It is this cartel which is challenging every notification. We liberalize the qualifications, they challenge it. We impose the qualifications as required under the Act, they challenging it. Now, 2023-24, why we have included is they did not complete the work. These very borewell contractors who had taken the contract, they have not completed the work. For whatever remainder of the borewells to be dug, that is only included. But there, where they had failed to execute the contract fully. These are clarifications we are going to give
the clarification.
Attend the meeting. This is premature. Kindly dismiss
previous
it.
writ petitions were allowed, my lord.
Liberty.
SCGP accepts notice for respond number 1
And 4, my lord.
and 4. Shri MS Devraj, who has filed caveat for respond
2 and
number
3, my lord, Mr. Devraj.
accepts notice for respond number 3 also. Registry is direct print their names as such. Counsel for the petitioner is direct furnish 2 sets of the petition along with annexures on the
Copies are
aforesaid
served, my lord.
counsels. The grievance of the petitioner is threefold. One, that in terms of clause 5 at page 98, the borewells to be dug for 23-24, which is already a past year, is contained in the said tender notification.
My submission, my lord, is apart from that, my lord, once they issue notification for 2023-24, my lord, the effect, my lord,
They'll
of
give
clause
you a
13
clarification in the pre-bid meeting. That is what Professor
They
Kumar
cannot,
is
my lord,
saying.
include financial year 2023.
Your
24, my lord, that is-
We will
interpretation
consider
is only
everything.
to delay. it doesn't seem to be a valid, one. They'll explain what Professor Kumar's explanation is. 23-24 ಅಲ್ಲಿ ಏನ್ ಮಾಡಬೇಕಾಗಿತ್ತೋ that is included in this package, not for what
Correct.
is going to be
Correct.
done. That is a very, very valid explanation. That's why we are telling you, you are running the risk of your petition being dismissed. Because this is a frivolous contention,
My lord, my
only to
previous,
delay.
my lord, my
everything.
previous writ petition was allowed, my lord.
Understood, all tender notification, you will, everybody has a problem, but the work has to go on. The second contention is that in view of 23-24 being included in the tender, there could not have been a qualifying financial requirement for the year 23-24. Lastly, it is contended that the number of minimum borewells have been increased in terms of clause C of clause 3.2. Professor Ravi Varma Kumar, learned senior counsel, appearing for respondent 2 and 3, submits that all these issues raised by the petitioner now and any issues that may be raised by the petitioner will be considered in the pre-bid meeting on 3/10/2024, scheduled on 3/10/2024, and proper explanation afforded to the petitioner if the petitioner were to be present in the meeting and raise these issues. The said submission of Professor Kumar is reasonable. The petitioner is granted liberty to raise all issues that the petitioner intends to raise in the pre-bid meeting. Relist on yavattu tender opening 18th ala, relist on 16th.
18th.
For a dismissal matter, serial number 17,
Apply.
आगे Kailash C.
Lord, I applied on 13/9 itself is for obtaining annexure A. Even then also, they have not issued annexure A copy.
ಯಾರಿಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ?
Tahsildar or authorized the respond number 3 Tahsildar Surpur.
ಯಾವಾಗ ಅಪ್ಲೈ ಮಾಡಿದ್ರಿ?
13/9 ಮೇಲೆ.
Learned SCGP accepts notice for respond number 1 to 3. Learned counsel for the petitioner submit that is unable to comply with the office objection since the application for certified copy filed by the petitioner with respond number 3 has not been acted upon and certified copy not issued, though the application is pending from 13/9/2024. Learned SCGP is directed to cause inquiry and issue necessary instruction to the Tahsildar to issue the certified copy. Else the original file would have to be secured. Relist on 28th October.
For orders, serial number 18, Shri Chaitanya Kumar Chandriki.
For the petitioners in this matter, my lord.
Hmm.
There is a delay in my lord filing the review petition.
What is the review that you want?
My lord, only time frame is not fixed in the my lord order.
Oh, yeah, the court fee.
ಹೌದು.
Kotra. Clarification. Accepting the reasons stated in support of IA 1 of 24, the delay of 395 days is condoned. IA 1 of 24 is allowed. Learned SCGP accepts notice for respond number 1,
1 and 4, my lord.
1 and 4.
AM Nagaral appear for.
AM
my lord,
Nagral
respond
for
number
2 and 3. 5 yarapa.
ಅಲ್ಲ, AM Nagaral for respond number 5, BB Patil for respond number 2 and 3.
ಇವಾಗ ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ. Shri AM Nagral is directed to accept notice for respond number 5. But KDB ಇದೆಲ್ಲ, how can he accept?
BB Patil appear for my lord KIDB and land, special land acquisition.
ಅದು ಆವಾಗ. ಇವಾಗ Nagral is on the panel of.
In this matter, my lord, he has appeared for my lord beneficiary. R5.
ಮಾಡ್ಬೋದು ಅವರು. ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಬರೋದು.
When KDB is a party, he can't. ಇನ್ಯಾರಿದ್ದಾರೆ KDB council ಇಲ್ಲಿ? Anybody else? Shri Shanabasappa M. Patil is directed to accept notice for respond number 2 and 3. Issue notice to respond number 5, returnable by 12th November.
Much.
Number 19, Shri VG Brother, Shri Chaitanya Kumar.
What is the amendment you are seeking for?
File an application for amendment, Your Honor.
What is the amendment?
My lord, in para number 4 of the writ petitions. In place of petition.
Typographical error.
Typography.
IA 1/24 has been filed seeking for amendment of certain portion of the petition on the ground that there are some typographical error as regards the arraignment of the parties, both in terms of their rank and number. Having perused the proposed amendment, the submission made by the petitioner is accepted. IA 1/24 is allowed. Counsel for the petitioner is permitted to carry out necessary amendment, file amended petition within a period of 3 weeks from today. Pre-list on 7th November.
Serial number 20, Sri M.A. Jagirdar, DP Ambekar.
Lordship, documents, all the documents have been filed, Your Lordship. All the documents, required documents have been filed. So,
Filed.
yes, Your Lordship.
Copies.
Yes, Your Lordship.
Today,
Any objections?
no, objection.
Kindly,
Allow the IA, take it on record. IA 2/24 has been filed to bring certain additional documents on record. There being no particular objection on part of the respondent, the said IA 2/24 is allowed. The documents produced are taken on record.
then recalling, recalling of the order.
Recalling.
Yes.
Yav recalling.
It was dismissed for non-prosecution.
Dismissed for non-prosecution dated 28/3/24. It has to be allowed, Your Lordship.
None were present. Recalling application ಏನು ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದಾರೆ.
Yes.
They filed,
IA number?
I think 1/24.
Accepting the reasons stated in support of IA 1/24, the order dated 28/3/24, dismissing the above petition for non-prosecution on account of the absence of the counsel for the petitioner on that date is recalled, subject to payment of cost of rupees. ನೀವ್ ಹೇಳಿ.
Please, Your Lordship.
Please ಅಂದ್ರೆ ನಂಗ್ ಬಿಟ್ರೆ ಕಷ್ಟ, ನೀವ್ ಹೇಳಿ. 2,000 payable to the
Fine.
advocates.
Kindly.
ಏನ್ CPC ತಾನೆ? Suit for?
Suit ಇಲ್ಲ. It is a miscellaneous application to recall a compromise decree between father and sons. They want to summon the advocates.
1,000 rupees to the advocates library fund. Pre-list on 5th November.
Please.
Serial number 21, Sri Amir Amaj.
Password.
ಏನ್ correction ಏನಪ್ಪ?
Like council may not instructed to get password.
IA 2/24 has been filed for correcting a typographic error in para 2 of the order dated 13/6/2023. Dated 14th August 2024, wherein the subpara 2 of para 1 of the order dated 14th August 2024. Accepting the reasons stated therein, the date of the order is corrected from 13/6/2003 to 13/6/2023. Registry is directed to issue fresh certified copy.
Serial number 22, Srimati M.L. Kulkarni, CRJ Bhusre.
In this case,
Lords, I have sought for direction to appear for the examination to be scheduled from 5th October, my lords.
Lord, the practical is, my lord, exam scheduled from
5th October.
5th October to 18th October, my lord. Let, my lord, the petitioner appear for practical examination. Meanwhile, it may be posted on 15, my lord, I'll file a statement of objection. And theory will, exam starts from 23 October, my
22nd.
lord.
22nd.
Before that, it can be decided. I have received the
Piecemeal
para.
order.
Piecemeal bada.
Piecemeal.
Let them appear for both. You file your objection. Considering that the exams are scheduled from 5th October, for the practical exams are scheduled from 5th October, and the theory exams are scheduled from 23rd
22nd.
October. The petitioner is permitted to take up the said examination subject to the result of the above petition. In the meanwhile, objection statement to be filed by the respondents on or before 30th, relist on 7th November.
Grateful, my lords. I may be permitted to move the hand delivery
Bharate, madam, 5th time.
because fifth tomorrow is a holiday.
Today we'll sign and leave.
Please, grateful, my lords. Grateful.
For 23, Sri Naresh V. Kulkarni.
My Lord, I am filing a memo wherein discom matter wherein the BBC ad billing charges were charged at rupees 50 lakhs, which I have challenged.
For 80
I
months.
am
my lord,
ready
it
to
is
pay
covered.
50,000 additional to the bill that they are giving regularly.
This honorable court had directed within 8 weeks to deposit 50%. Now is asking for 80 months.
Allah,
He has a
do
separate.
admit, my Lord, but there is a
You want to run the industry, you don't want to run the industry.
my Lord, only for 6 months the party, I was asked to keep the party present, he is
So get
present.
reduced
Only-
yesterday
only-
to 66, sir.
My lord,
How much was the sanction load?
66, my lord. Now it is,
Reduce it to 66.
and my lord,
Allah,
against this order. my
What
lord,
had happened is, orally I am submitting, it's not on records. When the BJP government was in power, they had told him orally, the JESCOM officials, that up till 200 LT charges you can extend it, get it extended up to 200 megawatts. That he got it done, and the rent was paid regularly.
Whoever has
and-
promised, let him take action against them. He has to do it as per the rules. You have been getting 200. If you don't want 200, you want it to be 66, they'll reduce it to 66.
Allah, it was a mistake by the JESCOM officials who had issued the bills, my lord. They had issued the bills, have been paying regularly as per annexure
You
C.
will
series.
reject your memo. That's all. Nothing more can be
And
done.
even alternate remedies, the my lord, writ petition is not maintainable as to approach the consumer grievance redressal form and ombudsman, my lord, for his grievances.
Your client doesn't want relief, we can't help him. The petitioner is before this court
My lord,
seeking for the following reliefs. The petitioner has
may
an
be permitted to approach the,
alternative efficacious remedy in terms of the proceedings being available under, before the
Before the
consumer-
consumer grievance redressal form and ombudsman
Consumer Redressal Forum -Ombudsman.
under
Preserving such
KERC
liberty.
regulations.
The petition stands dismissed.
my lord, 10 lakhs is deposited before this court.
That
The
has to-
amount in deposit is is permitted to be withdrawn
Please.
by the respondent and adjusted to
And,
the dues of the petition.
Within 15 days, I'll be preferring that till then they should not disconnect the power. I
Stay is
already
already
deposited 10
vacated,
lakhs.
my lord. Stay is
We've
already
given you
vacated.
enough time to be reasonable. You have been unreasonable.
Serial number 24, Sri Puneet Markal.
Instead of 2 acre 2 guntas, 3 acres ಆಗಬೇಕಾಗಿತ್ತು my lord.
Huh?
Instead of 2 acre 2 guntas,
Yelli.
my lord, kindly see the page number 24, my lord, of the petition. Petition is,
Oh, petition amend ಆಗ್ಬೇಕಾ?
no, my lord, I have pleaded in the petition, I have pleaded.
Petition page number?
Page number 4, my lord, petition is para number 2.
Ah.
Petitioner here is owner of 3 acres out of 20 acre 21 guntas ಅಂತ plead ಮಾಡಿದ್ದೀನಿ. 24 ಅಲ್ಲಿ is forthcoming in the-
ಇಲ್ಲಿ ಏನಾಗಿದೆ?
2 acre 2 guntas ಅಂತ ಬಂದಿದೆ my lord. Order. Instead of 2 acre 2 guntas, only 3 acres ಅಂತ ಆಗ್ಬೇಕಷ್ಟೇ.
Counsel for the petitioner submits that there is a typographical error. Issa 3 ನಪ್ಪ ಅದು.
Please, my lord, joint.
2 acres 2 guntas ಅಂತ para 1 ಅಲ್ಲಿ ಇದೆಯಲ್ಲ.
No, my lord.
Para 1 of your petition is 2 acres 2 guntas.
No, my lord,
ನೋಡಿ.
land was measuring total 20 acre 21 guntas, my lord.
The petitioner and other family members are the absolute owner measuring in survey number 98 Issa 3 measuring 2 acres 2 guntas.
It's 21 acre 20. It is-
That's your contention in
Please,
the petition.
I will
You have to
file the
carry out
necessary
amendment
application.
there.
I will, please. my lord.
IA 1 of 24 has been filed for correction of the order dated 28/8/24. The perusal of the order and the application does not indicate any such correction required to be made. Hence, IA 1 of 24 is dismissed. Liberty is reserved to the petitioner to file an application for amendment of the petition.
Please.
if deemed fit. Please.
For preparing matter, cell number 25, Sri H.M. Patel.
Kindly have after vacation.
Records have been received. Nodidra records?
Notably, sir, I will keep present the Mallappa.
Huh?
And it is said that Jattappa and Shivappa were present. And this Mallappa,
Inobrilla. One of them is not there.
ಇಲ್ಲ ಸರ್ ಇಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, ಜಟ್ಟಪ್ಪ ಮತ್ತೆ ಶಿವಪ್ಪ
Huh?
ಇಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ಬಟ್ ಆ ಆರ್ಡರ್ ನಲ್ಲಿ ಜಟ್ಟಪ್ಪ ಶಿವಪ್ಪ ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿಕೆನೆ ದೇರ್ ಇಸ್ ಎ ಆರ್ಡರ್. ಈ ಮಲ್ಲಪ್ಪ ಅನ್ನೋರು ಶಿವಪ್ಪನ ಮಗ.
ಅದಕ್ಕೆ ಹಿಂದೆನೆ ತೀರ್ಕೊಂಡಿದ್ರಾ?
ಅದನ್ನೇ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊ ಅಸರ್ಟೈನ್ ಮಾಡ್ತೀನಿ ಸರ್, ಮಲ್ಲಪ್ಪಗೆ ಕರೆದ.
Counsel for the petitioner seeks for and is granted 3 weeks time to obtain and furnish the death certificate of Mallappa and Jeddappa, released on 6th November.
Number 26, Sri Sanjay A. Patil.
My lord, mandamus directing to the fifth respondent to register FIR by considering the written
And what is the complaint?
complaint on public function. Newly elected MP Bidar constituency, wherein Dr. Chandrasekhar had addressed in the public function in the said function hall. He has abused in a filthy language to the petitioner as a pocket MLA. And also he has given life threat to the petitioner by stating that I will cut your tongue up to the petitioner.
ಇದಕ್ಕೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಬೇಕೇನ್ರಿ?
But public
There is
function.
absolutely nothing which can make out a cognizable offense.
Cognizable offense, but a duty to bond and.
It's only a statement made. Learned SCGP accepts notice for respond number 1 to 5. The grievance of the petitioner is that the complaint submitted by the petitioner on 8/9/2024 to the fifth respondent has not been registered. And as such, the aforesaid reliefs are sought for. The only allegation made in the complaint is that the person against whom the complaint has been made has abused the petitioner by calling him a pocket MLA, and that he will cut the tongue of the complainant. The same is not a cognizable offense requiring registration of a criminal complaint in terms of the decision of the Honorable Apex Court in Lalita Kumari so-and-so. In that view of the matter, there is no vested right for a mandamus to be issued, as such the petition stands dismissed at the admission stage itself.
Number 27, Sri Jayanandaya.
My lord, I am given the representation of the annexure B and C, my lord. Sub-registration that there is in RFA that maybe honorable court is order passed by the compromise petition is order 23 rule 2, my lord. So judgment is passed by that and compromise petition decree is passed already decree passed, my lord. As per the 17
Sale deed has to be cancelled.
please.
Where is the RFA?
Page number
order?
13, my lord. Page number 13, pair number 5. In terms of that's compromise petition, this is the respondent has admitted that the plots belongs to the appellants who are the owners of and is the peaceful portions of the enjoyments of the same. That he is also admits that he has not any legal right that is he is the title of these kinds of those plots. However, he has admitted that the sale deeds is more fully that's mentioned in the compromise petition. And paragraph is the 4 that or the had been bad in law. That is the respondent was the victim of fraud. Therefore, the sale deed of the cancelled as per the law. That
Learned
sending
SCGP accepts notice for respondent. The petitioner is before this court seeking for the following reliefs. The contention of the learned counsel for the petitioner is that in RFA number 20020 of 2017, the parties had entered into a settlement and a compromise petition filed, in furtherance of which a compromise decree was drawn. As in terms of said compromise, the sale deeds bearing number 7384 of 2013, 7381 of 2013-14, 738081 838486 of 2013-14 were required to be cancelled, despite the representation having been submitted by the petitioner to the respondent on 5/9/2024 and 24/9/2024, enclosing the said decree. The sub-registrar has not taken any action. Whenever any decree has been passed by a court of law and the same is presented before the sub-registrar for necessary action, it would be required for the sub-registrar to act on the said decree and carry out the necessary actions as required in the said decree. The same not having been done, I pass the following order. Writ petition is allowed. A mandamus is issued directing the respondent to consider the representation of the petitioner dated 5/9/24 and 24/9/2024 at Annexure B and C respectively in terms of the decree passed in RFA number 20020 of 2017 within 30 days of the receipt of a copy of this order.
Please, Oblak. Seal number 28, Sri Arun Kumar Amargundappa.
Appear for petition. Appear for petition. Unilateral decision of shifting MSIL from the scheduled premises owned and possessed by petitioner is called in question, my lord.
Yes, Mr.
Way back in the
3 and 5, I will take notice.
Lord, SCGP accepts notice for respond number 1 and 2, 1, 2 and 4. Shri M. Sudarshan accepts notice for respond number 3 and 5. Counsel for the petitioner to furnish 2 sets of the petition along with annexes on the said counsel. Any shift ಆಗಿದೆಯಾ?
communication not admit.
Relist on 21st October.
Till then, my lord.
We are not asking him to vacate, my lord. It is for him to, my lord, who has not turned up to, my lord, sign the agreement. If any, my lord, such is observation.
I
we will
offered
protect his-
consent, my lord, with regard to, I have produced.
Coercive
Not to
step.
precipitate ಅಂತ ಮಾಡಿದ್ರೆ ಆಯ್ತು.
The respondents are restrained from taking any precipitative steps
Please.
requiring the petitioner to shift from the location from which he is now operating till the next date.
Please.
Great.
Seal number 29, Srimati Email Kulkarni.
The respondents are forming the road, my lord, encroaching upon my land. Petitioners are the joint owners of the land survey number 89/2, my lords. ZP Bijapur, my lords,
Without acquiring.
without acquiring, without compensating. I have already served the copy upon the CEO ZP.
CGP accepts notice for respond number 1, 2, 4. Ms. Ratna Shogimat accepts notice for respond number
3,
3. KRIDL yaru.
emergent notice.
Issue emergent notice to respond number 5 to 7, returnable by 7th November. The jurisdictional ADLR is directed to cause a survey of the land in survey number 89/1 of Kalakeri village, Talikoti Taluk, Vijaypura district to ascertain the existence of a road on the said survey number with reference to the village map, the width and length of the said road in the said survey number, mark the same in the survey sketch, as also demarcate the road now being laid on the said in the said survey number.
Great.
Survey to be carried out commencing from 10:30 AM on 23rd October 2024 without requirement of issuance of any fresh notice to the petitioners or the respondents.
Grateful, let's start.
Seal number 30, Sri Ganesh Subhash Chandra Kalburgi.
I appear, my lord. On behalf of Ganesh Kalaburagi.
Hmm.
The matter pertinent to board matter, lordship.
Shri
Column
P.S.
number-
Valli Patil accepts notice for respond number 6 and
Yes,
HCGP
my
for
lord,
1 to 5.
My lord, kind submission.
Hmm.
The petitioner have already prepared the assistant commissioner in appeal, my lord, respond number 4, my lord. Can I withdraw the assistant commissioner order, my lord? Appeal, my lord.
You already filed.
Yes, filed, my lord. Anneger D, my lord, Anneger C, page number 42. But is not any past the order, lords, to be assistant commissioner. Assistant commissioner of appeal is withdrawal, my lord. Column number 9 and 12 is Karnataka board name is there.
Petitioner is, ಅದು withdraw ಮಾಡಿದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ?
Can I give the liberty, my lord? I withdraw, my lord, is Assistant Commissioner Appeal. My lord.
Now, we can give you liberty to withdraw this.
Because the manager C is
Counsel
already
for the
filed.
petitioner seeks fund is granted 3 weeks' time. Released on 30th October.
Please.
For admission matter, cell number 31, Srivira Shetty.
The typical error, my lord, the submission become a matter to be become infectious, my lord. At the time I am feeling at the time I am not affirming, my lord. The matter, the mistake, the typical error, my lord,
ಅದೇಂಗಪ್ಪ ನಿಮ್ಮ ಪ್ರೆಸೆನ್ಸ್ ನೋಟ್ ಆಗಿದೆ.
ಎಲ್ಲ ನಾ ಅವತ್ತು ಆ ಟೈಮ್ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಇದು ಬಿಕಮ್
Appear ಆಗದೆ ನಿಮ್ಮ ಹೆಸರು ಬರಲ್ಲಪ್ಪ. We would not have passed such an order ever.
at the time I am not appear this honorable court, my lord. That's
ನಿಮ್ ನೀವ್ ಇಲ್ದೆ ನಮ್ ಸಬ್ಮಿಷನ್ ಅಂತೂ ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ ನಾವು.
ನಾ ಅಪಿಯರ್ ಆಗಿಲ್ಲ at the time 13/5/2024 the process.
Respondent infructuous ಅಂತ ಹೇಳಿದ್ರೇನು we'll pass over to wait for you.
That is my.
We won't pass such an order, never.
I not give the any memo, my lord, give the become infectious, my lord.
ಇನ್ಮೇಲೆ ಮೆಮೊ ಕೇಳಬೇಕಾಗತ್ತೆ. ನಿಮ್ ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡಂಗಿಲ್ಲ. Don't make such submissions. Respond ಅವ್ರು ಹೇಳೋ infructuous ಆದ್ರೇನು ಕೇಳೋಣ ಅಂತ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ.
At the time of I am not present with this honorable court, my lord. At the time of order this honorable court, my lord.
ಎಲ್ಲ ಅಷ್ಟು ಜನ ಬಂದು everybody has appeared. Everybody has appeared. Cannot be accepted. What is this order?
Writ of certiorari, my lord, the board matter, my lord.
Twenty-two 8/2017 ಏನ್ ಆರ್ಡರ್ ಅದು?
Pardon?
ಏನ್ ಆರ್ಡರ್ 22 8/2017 which you are challenged?
What the challenge annexure H, my lord. Writ petition.
ವಕ್ಫ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಪಾರ್ಟಿನೇ ಇಲ್ಲ. ವಕ್ಫ್ ಬೋರ್ಡ್ is not a party.
Land reforms, my lord. Sorry, my lord. Respond number 2.
ಏನೇನೋ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
Respond number 2, my lord. Sorry. Respond number 2, my lord.
You made this submission. Cannot be on that ground. ಏನದು ಆರ್ಡರ್ ಅದು 22 8/17? ಇದೆಯಾ ಅದು ಆರ್ಡರ್ ಕಾಪಿ ಇದೆಯಾ?
ಇಲ್ಲ ಸರ್.
ಆರ್ಡರ್ ಕಾಪಿನೂ ಇಲ್ವಾ?
ಇಲ್ಲ ಸರ್. ಎಲ್ಲಿ ಪಾಸ್
ಬನ್ನಿ ಪಾಸ್.
For further argument, serial number 42.
Yes, madam. Shakti Vaini.
Malad,
Yes, Mr. Rao.
Malad, we are submitting, Malad already submitted with regard to the conversion of the English to Kannada language, Malad, with the Bhashantra department, it is submitted, Malad, your lordship consideration. And with regard to the training is going on, Malad. And we have complied the conditions of this honorable court, Malad, kindly they close the matter.
So translation copy has been sent to all the officers.
Yes, Malad.
Supreme Court judgment.
Yes, please, Malad, and we are also brought to the notice of the entire police, the concerned station also.
And training is going on.
Yeah, please.
Mr. Jadhav? Where is Mr. Jadhav? Prakash
Jadhav.
Let us see, let him come. Password. So translation agide, training nadita ide.
Please, my lord, the directions of this honorable court is complied, my lord. My prayer to be disposed the matter, my lord.
Let him come if he has anything else to say. We'll see what he has to say.
Please.
Serial number for further hearing, serial number 43, Sri Ulepa Error. Sri Amarashias Roger.
None appears for the petitioner today also. ಎಲ್ಲಿ ಎರೂರು ಬೇಕಂತ ಬರ್ತಾ ಇಲ್ಲ ಅವ್ರು. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
Serial number 44, Sri Ganesh Subhash Chandra Kalaburagi.
Sir.
Sri
I appear for the respondent, my lord. My lord, my official is there. We are filing the written argument, my lord.
Forward. Nimdu? Already filed, your lordship. Already filed. The counsel for respondent number 1 to 8 has filed his written submission. The same is taken on record, reserved for judgment.
Much obliged.
Serial number 45, Sri Ram.
With lordship permission, my lord, in this case, my lordship has directed us the previous date of hearing, my lord, to submit the 53 GST counseling meeting, my lord, with regard to the amendment proposed 168 of the GST Act to extension of the time for the assessing authority. My lord, in GST council meeting, it has been uploaded through my lord, e-filing, my lord. Because this more than 550 pages is there, Malad, and we have communicated to the respondent also, Malad, by way of the any comment on that, Malad, they can. Otherwise, we are good now.
Recommendation number kodi. What is the recommendation?
It is uploaded, Malad, by 3 e-filing, Malad. Our hard copy, Malad.
E-filing.
Minutes, can I make a submission?
So we need only the relevant para as regards the extension by that 3 months. What is the recommendation? There may be various recommendations in the meeting.
Please, Malad.
Only as regards this notification, what is the recommendation?
Malad, it's a recommendation with the main extension, Malad, the extension of the date of filing returns in form number 3B for the month of November 2023. Personal registration in Tamil Nadu and other state, Malad. So where they are particularly.
So now just give us a printout of the relevant pages.
The extension time for the other states. So therefore, they're not.
You give us only the printout of the relevant pages. 550 pages will consider various other tax input, the rate of tax, ella irata, adella bekagilla namge.
Minutes, I have handed over the council meeting minutes to my colleague, minutes. He is there, minutes. 40
your
minutes.
colleague is also not here.
Minutes, my learned friend is referring 53rd GST council meeting minutes. That is of 2024 June minutes. Whereas we are talking about 49 GST council minutes, which was held on 28th of December 2023. That's my only submission is that minutes, the minutes I have handed over minutes, as well as there are 2 cases also which I am relying upon. One of the Supreme Court minutes, the suo motu minutes extension in the COVID.
Yes.
Let's even in that minutes, if we read that order minutes of the Supreme Court extension minutes, that has also said that whatever will be the last period, only 3 months can be extended minutes. I have handed over that also to my colleague minutes.
This is also 3 months only, September to December.
That's what. Yeah.
This September to December, then it's written 3 months. That will go against you, Dr. Podar.
Lordship, I missed it, Lordship.
The earlier limitation was till September 23.
Please, my
It has
lords.
been extended to December 23, 3 months.
Please, my lords.
3 months only.
That's
So then
our,
that would be in
that's
accordance
our
with the Supreme
submission
Court
is-
order.
No, my lords, because the Supreme Court order was till March 22, my lords. Whatever time limits was lapsing in March 22, my lords, for that 3 months were being extended. And if there is any time limit which is not being extended, then that will be extended from March 22 for the remaining period, my lords. Even that is
That
lapsing, my
judgment
lords.
is as regards, that judgment is as regards the filing of proceedings. Here, the GST Council has recommended on which basis this extension has been made. So none of you have placed this, and none of you are willing to place this on record.
Lordship,
How
I
do
have
we
placed, my lords.
assess the validity
That's
of
my-
annexure?
That's my colleague. I have placed it. That's the extract is there in the petition, my lords. Even my colleague has placed on record, my lords, the council meeting, my lords. My lords have that
Your
49
colleague has
GST
now
council.
given us a judgment in civil appeal number 1390 of 2022, not
so,
the
my
GST
lords-
Council recommendation.
My lords, he has a minutes also, 49 GST council minutes, my lords.
Yes, what is the relevant page number?
Page 23, my lords. Lords, just to set the background, my lords, they have extended it for 2 times, my lords. In the 47 GST council meeting, they have extended by way of 33 of 2022. Thereafter, my lords, they have extended of 9 of 2023, which is the impugned notification, my lords. This is the relevant minutes, my lords.
This
Minutes
is
have that
time limit
page
under
23.
subsection 10 of section 73.
Please, my lords. May I read, my lords? Principal Commissioner,
168.
GST PW. Lords, nowhere they are mentioning, they are simply mentioning the administrative difficulties, my lords. And my lords, in Mohit Minerals, my lords, the Honorable Supreme Court has said that the recommendations of the councils are not binding.
Now, action is proposed to be taken against you under what provision?
My lords, 7310, my lords. They have to pass an order under section 7310.
7310.
Please, my lords. They have passed an order. Therefore, we are saying that the show cause as well as the order is time barred because the extension is not in accordance with 168A because there were no force majeure situations. That is our limited submission, my lords. And even in this minutes, my lords, they have only stated about the administrative difficulty of the officers, but nothing has been spelled about what was the force majeure circumstance, my lords. And therefore, we are relying on one of the Supreme Court judgments, my lords, in Mohit Minerals, my lords, which says that the recommendations of the council are not binding on the state and union. Even, my lords, para 5.7, my lords, last line, my lords. Fourth last line, my lords, after detailed deliberation, law committee recommended that such time limits may be extended for another 3 months for the period so and so, was discussed in detail in officers meeting, where one view was that extension of financial year 17-18 has already been given, and further extension may create a perception that it is not tax-friendly measure and against the interest of the taxpayers. My lords, it's not a 100% uniform decision, my lords. There were disputes pertaining to that also, my lords.
Finally, it is the decision of the council.
Finally, it is the decision of the council. Therefore, my lords,
There's
we are
no
relying on the
requirement of a unanimous decision, Dr. Poda. That would not be a submission.
certainly, my
which
lords.
is- would
My lords,
be
therefore,
legal
we are
in
relying
nature.
on Mohit Minerals, my lords. The decision of the apex court, my lords, in the
Yes, so the committee has, council has considered it in a, now let us see your judgment.
Please, my lords.
Which judgment, what page number?
My lords, the first judgment which I am relying upon is the suo motu order, my lords. 665 of 2021. My lords have that. 21 of 2022. If my lords are having
Yes.
that judgment of Mohit Minerals, my lords,
Yes.
that also may be referred, my lords. Suo motu
Which
judgment,
one
my
do you
lords.
want us?
My lords, suo motu judgment, my lords, para 5.
5. Yes.
Taking into consideration the argument advanced by learned counsel and the impact of the search of the virus on public health and adversities faced by the litigants in the prevailing conditions, we deem it appropriate to dispose of the MSO and so with the following directions. Second is relevant, my lords. Next page, my lords. Consequently, the balance period of limitation remaining as on 3rd October 2021, if any, shall become available with effect from 1st March 2022. So, my lords, may note couple of dates, my lords. Originally, my lords, the date of filing, due date of filing of for 1718 was 5th February 2020.
Dr. Podar,
Please,
this is a judgment of the Honorable Apex Court as regards filing before courts and tribunals, from what we are aware of.
Lordship.
Does this deal with the income tax or GST or any tax authorities?
Lordship, yes, it deals with the judgments or the time limits wherein the time limits are expiring.
Where does that deal with that? Could you show it to us? This deals with the tax authorities.
I'll have to produce the another judgment, but in that case,
this won't apply to this situation. This
then
is only as regards courts.
My request would be to please refer to the another judgment which is cited by me, Mohit Minerals.
Yes, page number?
Page number 150, minutes, the conclusion.
150.
150, minutes, para 148.
Yes.
Based on the above discussion, we have reached the following conclusion. Clause 1. The recommendations of the GST Council are not binding on the Union and state for the following reasons. So therefore, my submission is not, this is the only a recommendation, not. They need to place on record that what are the force majeure circumstances which were there on 31st March 2023 when the notification was issued.
No, that is for the government to say that we won't accept the council's recommendation or not. That's not for you to say don't accept.
No, but it's, therefore, we are challenging the virus of that particular notification that it is the horse 168 minutes.
That you could argue, but not on this basis. That you could argue not on this basis. There is not a basis for that argument.
No, but what I'm trying to submit is that the notification which has been issued by the government on the recommendation of the council is ultra virus 168 capital A minutes, because there are no force majeure situations at that point in time. That is the submission notes. And why I am submitting this judgment is minutes
to make my submission as consider. The council has considered that in the year 2019-20, 2021, due to COVID-19 restrictions, several of the returns could not be finalized, several actions could not be taken. They are all pending. Therefore, they have extended by a period of 3 months, even after taking into consideration other view expressed that it could not be held to be tax friendly. The council has recommended, state the union has accepted it. There is consideration, there is application of mind. That won't be a ground for you to assail Annexure A.
My submission is that we do not disagree that the council has not recommended. Council has recommended notes. The notification has been issued, but we submit that notification has to be in line with section 168 capital A minutes.
Yes.
Section
that
168.
Is what you had said, that there is no recommendation. That is why we asked them. And we saw here that there is a council recommendation.
That was for the subsequent period. It was 56 of 2023. We are not challenging that notification.
Yes,
it's 9
we'll deal with your submission. We'll deal with your submission. The petitioner is before this court seeking for the following reliefs. A show cause notice came to be issued to the petitioner under subsection 10 of section 73 of the GST Act on when was the show cause notice issued?
Lordship, just a moment. Lordship.
On 21/12/2023.
No, Lord, that was the date of entry. The show cause has been issued on 4th of September, for a moment. 29th of September 2023. Annexure B.
Then 29th of September is within time.
No, Milords. 30th September, it has to be issued 3 months prior, Milords. 30th September was the date for filing, for passing the order, Milords. The show cause notice as per 73(2) has to be issued 3 months prior. So they have to issue that by 30th June.
Even that delayed, this one has not been taken. It was issued on Where is the reference? Which annexure?
My lord, annexure B.
B, page number
59.
59.
Was issued on 29/9/2023 under subsection 1 of section 73 of the KGST and CGST Acts 2017. The contention of the petitioner is that orders on the same in terms of subsection 10 of section 73 being required to be passed by 30th of September. It is by virtue of notification number 9 of 2023 dated 31/3/2023 that the time limit under section 168 capital A of the CGST Act has been extended in an arbitrary manner. If the said notification number 9 of 2023 is eschewed, no orders could be passed on the show cause notice issued under subsection 1 of section 73 by 30/9/2023, and the extension of time till 31/12/2023 for passing such orders is without any basis. In this regard, Dr. Poddar, learned counsel for the petitioner, would further submit that in terms of the decision of the Honorable Apex Court in miscellaneous application number 21 of 2022, in miscellaneous application number 665 of 2021, in suo motu writ petition number C number 3 of 2020, the Honorable Apex Court, while it's order dated 10th January 2022, at para 5 of the said order, has held that the period from 15/3/2022 till 28/2/2022 would stand excluded for the purpose of limitation, and the balance period of limitation as available on 3/10/2021 would be available with effect from 1/3/2022. In the present case, the limitation having expired on 30/9/2023, the extension of time granted by the Honorable Apex Court would not be available to the authorities, and as such, the reliance placed by the authorities on COVID pandemic would not be applicable. Secondly, he relies upon the decision of the Honorable Apex Court in Civil Appeal number 1390 of 2022, more particularly para 148 thereof, which is reproduced hereunder for easy reference. By relying on the above paragraph, he submits that the recommendation of the GST Council is not binding on the Union. The Union of India could either accept or reject the recommendation of the GST Council. Thus, any recommendation, if at all made by the GST Council, would not be binding on the Union. Insofar as the recommendation of GST Council, by referring to para 5.7 of the minutes of the 49th meeting of the GST Council held on 19th February 2023, he submits that the said recommendation made was not unanimous. There was certain dissent expressed as regards the recommendation, inasmuch as certain members of the council were of the opinion that the extension of time could be regarded to create a perception that it is not tax-friendly measure and is against the interest of taxpayers. The said para 5.7, 5.7.1 and 5.7.2 is reproduced hereunder for easy reference. On the basis of all the above submission, he submits that the extension of time of 3 months made wide notification number 9 of 2023 dated 31st March 2023 as annexure A to the petition is without any basis, the same is required to be quashed, and consequently, the notice issued under subsection 1 of section 73 not capable of being complied by passing necessary orders under subsection 10 of section 73, the proceedings initiated by 30th September 2023, the proceedings initiated against the petitioner are required to be quashed. Sri Mallar Rao Ranad, Additional Advocate General, would submit that the notification number 9 of 2023 has been issued on 31st March 2023 on the basis of the recommendation made by the GST Council, which has been accepted by the Ministry of Finance, Government of India. The Ministry of Finance, the Government of India, having accepted the said recommendation, it cannot be contended by the petitioner that the GST Council recommendation is not mandatory. Once the same has been accepted by the Union of India and a notification issued, the notification would be binding on all concerned. His further submission is that there is no requirement of any recommendation of the GST Council to be unanimous. The majority having recommended the extension of the limitation period, the same has been accepted by the Government of India and no fault can be found therewith. And in that background, he submits that the above writ petition is required to be dismissed. Heard so-and-so peruse papers. The short question that would arise for consideration is whether the Government of India, the notification number 9 of 2023, issued by the Government of India on 31st March 2023 at Annexure A, can be said to be without any basis or without application of mind. Section 168 capital A is reproduced hereunder for easy reference. The explanation to section 168 capital A indicates that the time limit which has been fixed that notwithstanding anything contained in the Act, the government may, on the recommendation of council, by notification, extend the time limit specified in or prescribed or notified under the Act. The explanation to the said section indicates that the expression force majeure would include case of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature otherwise affecting the implementation of any of the provision of the Act. A perusal of the discussion made in the GST Council in the meeting in the 49th meeting held on 18th February 2023, which has been extracted here and above, indicates that the law committee had considered the representation of various officers, the delay in the scrutiny and audit because of COVID-19 pandemic, the workload having been increased, and that it not be capable that the proceedings be closed in terms of subsection 10 of section 173 by 30th September 2023, and therefore recommended an extension of a period of 3 months. This extension has been made after taking into account a dissenting opinion by certain of the members that the said extension could create a perception that is not a tax-friendly measure and against the interest of taxpayers. The fact, however, remains that the GST Council has recommended the extension of the limitation from September 23 to December 23, which has been accepted by the Government of India, wide notification number 9 dated 31st March 2023. The submission of the Learned Counsel for the petitioner that the recommendation of the GST Council is not binding by relying upon the decision in Mohit Minerals Private Limited is one which should not be applicable in the present case, since the acceptance or otherwise of the recommendation is left to the Government of India, and it is for the Government of India to decide whether to accept the recommendation or not. In this particular matter, the Government of India having accepted the recommendation, it would not be available for the assessee to now contend that the recommendation of the Council is not binding on the Government of India. Insofar as the decision of the Honorable Apex Court in miscellaneous application number 21 of 22 relied upon by the Counsel for the petitioner, para 2 of the said judgment reads as under. A period of the said above paragraph would indicate that the extension of the period of limitation in all proceedings before courts and tribunals is what was considered by the Honorable Apex Court in the said decision, and not matters pertaining to assessment, reassessment, show cause notice, or the like issued by tax authorities. Thus, I am of the considered opinion that the decision of the Honorable Apex Court in suo motu proceedings referred to supra would also not be applicable to the present facts and circumstances. In view of my above reasoning, the notification dated 9 of 23, dated 31st March 23 at Annexure A cannot be found fault with on the basis of the submission made by the counsel for the petitioner. The GST Council, having considered all material aspects, having recommended the extension of period of limitation from September 23 to December 23, the same having been accepted by the Government of India, the assessee cannot challenge the same on the basis of the submissions made herein. In that view of the matter, there are no grounds which have been made out in the present petition. The petition is dismissed.
Notes, can I make a request?
Yes.
Malad,
Notes,
Malad,
since the
with a
order
fair
has been
submission,
passed-
Malad. With a fair
Let Mr.
submission,
Poddar
Malad.
make his submission, Mr. Rao, first. Yes, Mr. Poddar.
Milords, there are two things, Milords. One, Milords, the order has been passed, Milords, the limitation is expired for filing appeal, Milords. If this period can be
That's what I
considered as
want
bona
to
fide,
say. So
that we
leave
can
to the
file an
court,
appeal.
Malad, for continuation of the delay.
You want
First
extension of
appeal is
limitation?
provides.
Please, Milords.
provides
And if courts permit, Milords, if court permit at 2:30, if I take instruction for withdrawal, Milords, if it is permitted. So I'll seek instruction with the
No, not
permission.
after dictating the, not at all
Please,
after
Milords.
dictating. You have argued this on 4 days. We made Mr. Malarao run around and get the papers on the basis of your submission, not.
Milords, just a condemnation
If
may
you
be
want to
given.
file your appeal, by when will you file the appeal?
Milords, in 2 to 3 weeks, Milords. 3 weeks may be given.
Yes,
Because
Mr.
the
Rao?
Please, Malad, I leave to the court, Malad, with regard to the condemnation.
After the pronouncement of the order, after the dictation of the order, learned counsel for the petitioner seeks permission to file an appeal. However, submits that the appeal would be barred by limitation. Considering that the petitioner was under a misconception, the petitioner is granted 3 weeks, 21 days time from today to file an appeal. If the appeal is filed within 21 days from today, the appellate authority shall consider the same without adverting to the appeal being barred by limitation.
Grateful.
Obliged,
The
Milords.
above order is
Grateful.
passed in the present peculiar facts and circumstances of this case and shall not be treated as a precedent.
Obliged, Milords. Grateful. Grateful.
Serial number 20, serial number 31, madam, candidate taken after vacation, madam.
31.
31, madam.
Yaudappa?
RP, madam.
R. Just
I
madam.
don't have writ petition, madam. After vacation, madam.
Petition ಇದೆಯಾ ನೋಡಿ ತರಿಸಿ ಇಲ್ಲೇ ತರಿಸಿ ಬಿಡಿ ನೋಡಿ.
Number 15, which is disposed.
My lord,
I seek
with
for return
permission,
of,
my lord, serial number 35, my lord. Serial number
ಹೇಳಿ
35, my lord.
ಹೇಳಿ
35, my lord, list
35
number
ಏನು?
1. I filed this, secured after vacation, my lord.
At the request of counsel for the petitioner
I
released
want
on
to secure
6
the order state of the,
Yes, 6 November.
Please
Malad,
oblige, my lord.
impugned order annexure F, Malad, which are produced. Serial number 15, which is disposed of Public Premises Act, Malad. Original orders may be kindly permitted to.
CL number 15, registry is directed to return the original and or certified copies produced in the above petition after following the due formalities.
Serial number 46, Malad.
Huh?
230.
ಬರ್ತೀವಲ್ಲ full day sitting. 21. ಏನ್ ಮಾಡ್ಬೇಕು? ಅಲೋ ಆಗಿದೆ.
I am petitioner serial number 41 after the serial number 41 after the vacation.
41. 41 at the request of counsel for the petitioner released on 11th November.
Serial number 34, months.
34.
Yes. That's it may be taken after vacation.
34 at the request of counsel for the petitioner released on 10th November.
Yes. No. No.
Tenure completed your honor.
Petitioner ಹೇಳ್ಬೇಕು infractions and ನೀವು respondent ಅಲ್ಲ ಹೇಳು.
Tenure completed on 18 August 2024.
We heard.
Continue, why reason? There is
There
no reason.
There is interim madam, sir.
ಇದೊಂದು ರಿಟ್ಮೆಂಟಿಗೆ ಫೋನ್ ಮಾಡ್ರಿ ಒಂಚೂರು.
Bench matter then, then.
ಮೂರಿದೆ ಇದನ್ನ ರಿಪಿಟೇಷನ್ ಬೈತಾರೆ ಇಕ್ರಿಗಿರುತ್ತಲ್ಲ ಪೆಂಡಿಂಗ್ ಮಾಡಿರೋ ತರಿಸ್ತಾರೆ.
Sir, court officer. Sir,
ಹೇಳಿ ಮೇಡಮ್.
court officer.
ಹೇಳಿ ಮೇಡಮ್.
Sir, ಈಗ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ರಲ್ವಾ ಇದು ಲೆಂತಿ ಆರ್ಡರ್, ಆ ಫೈಲ್ ನ ಫೋಟೋ ಕಳಿಸ್ಬೇಡಿ, ಫೈಲ್ ನನೇ ಬ್ಯಾಂಗ್ಳೂರ್ ಕಳಿಸ್ಬಿಡಿ ಸರ್ ವಿತ್ ಜಜ್ಮೆಂಟ್ಸ್.
ಆಮೇಲೆ ಫೋಟೋ ಹೊಡಿತೀನಿ ಮೇಡಮ್.
ಫೋಟೋ ಬೇಡ, ಫೈಲ್ ಕಳಿಸ್ಬಿಡಿ ಸರ್.
ಆಯ್ತು ಮೇಡಮ್.
ನಮ್ ಗನ್ಮನ್ ಹೇಳ್ತೇನೆ ತಗೊಳಕ್ಕೆ, ಫೈಲ್ ತಂದ್ಬಿಡಿ. ಹಾ ಸರ್, ಚೇಂಬರ್ ಕಳಿಸ್ಬಿಡಿ, ಬ್ಯಾಂಗ್ಳೂರ್ ಕಳ್ಸಕ್ ಹೇಳಿ. ಓಕೆ ಸರ್.
ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ್ ಮೂರಿದೆ, ಧಾರವಾಡ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ ಅಷ್ಟೇ. ಬೆಂಗಳೂರ್ದು ಒಂದಿದೆ. ಇಲ್ಲ ಸರ್, ಬೆಂಗಳೂರ್ದು ಧಾರವಾಡದ ಮುಗಿಯುತ್ತೆ, ಆಮೇಲೆ ಇಲ್ಲೇದು ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ, ಆಮೇಲೆ ಇವ್ರು ತಗೊಂತಾರೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಯಾರಿಗಾಯ್ತು?
ಮೇಡಮ್ 15 SR ಆಗಿದೆ, ಅದೊಂದು ಲೈನ್ ಆಡ್
ನಾ
ಮಾಡಬೇಕು.
ಇಲ್ಲೇ ಹೇಳ್ತೇನೆ ಸರ್. ಆಯ್ತು.
ಓಕೆ ಓಕೆ. $39 ತಗೊಂತಾರೆ ಸರ್, ತಗೊಳಲ್ಲ ಅಂತ ನಂಗೆ ಹೇಳಿ. ಇನ್ನು ಫುಲ್ ಸೆಟ್ಟಿಂಗ್ ಇದೆ. ಇಲ್ಲ ಆಮೇಲೆ ಹೇಳ್ತೀವಿ.
Sir Mahesh. Sir 2:30 ಬರ್ತಾರಾ ಸರ್ ಸಾಹೇಬ್ರು?
ಇದೆಯಾ ಬೆಂಚ್ ನೀಟಾಗಿ ಡಿವೈಡ್ ಮಾಡಿ ಧಾರವಾಡ ಕಲಬುರಗಿ ಬೆಂಗಳೂರು 3 ಫೋಲ್ಡರ್ ಅಲ್ಲ 1 ಫೋಲ್ಡರ್ ಒಳಗಡೆ ಹಾಕಿದ್ದೀನಿ ಆಯ್ತು ಐ ವಿಲ್ ಚೆಕ್ ಹೇಳಿ ಸರ್ ಇದೊಂದು ಫೈಲ್ ನಂಬರ್ ಗೊತ್ತಾ WP 207754 ಹೌದಾ ಅಲ್ಲ August 24 ಅಲ್ಲಿ ಆಗಿತ್ತು 19/8/24 207754 of 17.
ಸರ್ ಆಯ್ತು ಸರ್ ಊಟ ಹಾಂ ಸರ್ ಅಷ್ಟು
ಬೆಂಗಳೂರು ತಗೊಂಡು ಬೆಂಗಳೂರ್ದ ಬೆಂಗಳೂರ್ದು ಮೂರಿದೆ. ಇಲ್ಲ ಮೇಡಮ್, ಫರ್ದರ್ ಏನು ತೊಗೊಂಡಿಲ್ಲ. ಅದು ಮುಗಿದ ಮೇಲೆ ಬಿ ಗ್ರೂಪ್ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು ಲಾಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು ಲಾಸ್ಟ್.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಆದ್ಮೇಲೆ 232
ಬೆಂಗಳೂರು, ಧಾರವಾಡ, ಆಮೇಲೆ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟು, ಆಮೇಲೆ ಫರ್ದರ್ ರಿಂಗ್ ಕಂಟಿನ್ಯೂ, ಅಲ್ಲ ಇಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್, ಫರ್ದರ್ ರಿಂಗ್, ಆಮೇಲೆ ಬಿ ಗ್ರೂಪ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ರೆಡಿ
ಸರ್ ಇದು ಬೆಂಗಳೂರು ಸಿಟಿಂಗ್ದು ಫಸ್ಟ್ ಕರಿತೀರಾ ಸರ್ ತಮ್ಮ ಕೋರ್ಟ್ ಫಸ್ಟ್ ಕರಿತೀರಾ ಸರ್
ಬೆಂಗಳೂರು ಸರ್
ಬೆಂಗಳೂರು ಓಕೆ ಸರ್ ಥ್ಯಾಂಕ್ ಯು ಸರ್
ಇದು ಕರೆಕ್ಟ್ ಐತಿ
Good morning.
No, sorry.
43 na? 43 DNP ಆಗಿದೆ. DNP.
39, ಸರ್. ಏನಂದ್ರಿ ಸರ್?
ಗಿರಿ ಸರ್.
DNP.
ನಮಸ್ತೆ ಹೇಳಿ ಸರ್. ಹಾ. ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ ಸರ್ ನಮಗೆ.
ಮಾಡಲ್ಲ ನಾರ್ಮಲಿ ಸರ್. ಮಾಡಲ್ಲ.
ಇಲ್ಲಿಲ್ಲ ಇದುವರೆಗೆ ಯಾರು ಬಂದ್ಮೇಲೆ ಬರ್ತಾರೆ.
ಇಲ್ಲ ಮಾಡಲ್ಲ ಸರ್, ಯಾರ್ದು ಮಾಡಲ್ಲ ಪಾಪ.
ಯಾವ್ದು ಹೇಳ್ರಿ ಇದಲ್ವಾ? ಇರ್ಲಿಲ್ವಾ ಬೆಳಿಗ್ಗೆ?
DNP ಕನ್ಫರ್ಮ್ ಮಾಡಪ್ಪ.
145 ಆಗಿದ್ರು. ಬಿಸ್ನೆಸ್ ಆಗಿದೆ ಬೆಂಗಳೂರಿಂದ AGFR ಆಗಿದೆ. ಬಿಸ್ನೆಸ್ ಆಗಿದೆ ಅವರಿಗೆ. ಅಪೀಲ್ ಹಾಕ್ಲಿಕ್ಕೆ ಇಟ್ಕೊಟ್ಟಿದ್ದಾರೆ. 21 days. ಅದೆಲ್ಲ 45. ಓಕೆ. ಬಿಸ್ನೆಸ್ ಆಗಿದೆ ಅಪೀಲ್ ಹಾಕಕ್ಕೆ 21 days.
ಸರ್ 39 ಇತ್ತು.
39 ಬಿ ಗ್ರೂಪ್.
ಹಾ
ಇದೆ
ಇನ್ನ ಅಲ್ಲ 45 ಬಂದದಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿ. 45 ಬಂದಿದೆ.
ಬರ್ದಾರೆ ಹೆಂಗಿತ್ತಲ್ಲ ಫಸ್ಟ್ ಹತ್ತು. ನಮ್ಮಿಂದ 9 ಅದ್ ನಿನ್ನೆ ರಿಪೋರ್ಟ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಬೆಂಗಳೂರು ಮೆಟ್ರಲ್ಲಿ. ಅದ್ ಬಂದಿದ್ರೆ ತರ್ಲಿಕ್ಕೆ ಹೇಳಿ. ಅಫಿಡವಿಟ್ ಫುಲ್ ಇರ್ಲಿಲ್ಲ. ಮೆಟ್ರಲ್
Court officer, sir? Sir? Court officer, sir?
Huh? ಹನುಮಂತ ನಾ ಹೊಲೆಪಿದ್ದೀನಿ ಎಲ್ಲಿದ್ದಿ ಕೋರ್ಟ್ನಾಗಿಲ್ಲ ಅವ್ರ ಮೇಡಮ್ ಹೋದ್ರು ಬೆಂಗಳೂರ್ಕ ಇವತ್ತು ಯಾರ ಹೊಸಪ್ಪ ಸಾಬ್ರಿಗೆ ಒಂದು ಸಬ್ಮಿಟ್ ಮಾಡವಿದ್ದೀನಿ ಕರಿಬಾರ್ದು ಆ ಸಬ್ಮಿಟ್ ಮಾಡೋಳಕ್ಕೆ ಕರಿಬಾರ್ದು ಏನಾಯ್ತು 16 ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಏನಾಯ್ತು ಕನೆಕ್ಟಿವಿಟಿ ಬರಲ್ದಲ್ಲ ನಿಮ್ದು ಕನೆಕ್ಟ್ ಇನ್ನೂ ಮಾಡಿಲ್ಲ 16 ಏನಾಯ್ತು ಸೀರಿಯಲ್ ನಂಬರ್ 1000 ಬೆಲೆಗೆ ಹಾಕ್ಬೋದು ಅಲ್ಲೇ ಕೋರ್ಟ್ ಮೇಲೆ ಇರ್ಬೋದು ನೋಡು ಟೇಬಲ್ ಮೇಲೆ ಲೀಸ್ಟ್ ನೋಡು ಹಾ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಯದಂತ ಸ್ಟೇ ಆಗ್ಯದ ಹೈಕೋರ್ಟ್ನಾಗ ಹಾ ಆಯ್ತು ನಾ ಕೊಟ್ರಲ್ಲ ಡೇಟ್ ಓಕೆ 1410 नमस्ते KT का 1410 है जी इससे पहले हमने ऑर्डर दिया तो फोन पे नहीं करे
ಐತಿನಾ ಐಯಾಲ್ ಹೋಗಿದೆ ಐಯಾಲ್ ಹೋಗಿ ಡೇಟ್ ಹೋಗಿದೆ ಡೇಟ್ ಇಲ್ಲ ಐಯಾಲ್ ಆಗಿದೆ ಅಷ್ಟೇ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ RP ಅಂದ್ರೆ ಅದು RP ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ 395 ಡೇಸ್ ಡೇಟಾಗಿ ಫೈಲ್ ಮಾಡೋದಾರ ಅಲ್ಲೋಗಿದೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ ಅದು ಇದು ಮೆಟೀರಿಯಲ್ ಕೂಡ ಸಾಯಂಕಾಲ ಬಂದು ನೋಡ್ತೀವಿ
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್
ಈಗ ಕೋರ್ಟ್ ನಂಬರ್ 4 ಅಲ್ವಾ ಇದು
ಹೌದು
ಸಾಹೇಬ್ರು ಸೂರಜ್ ಗೋದ್ರೆ ಸಾಹೇಬ್ರಲ್ವಾ
ಹೌದು ಸರ್
ಅದೇ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಡರ್ಸ್ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ
ಹೌದು ಬರ್ತಾರೆ ಸರ್ ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ್ ಫಸ್ಟ್ ತಗೊಂತಾರೆ ನಿಮ್ ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರ
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಸರ್
ಆಯ್ತು ಸರ್ ವೆಯ್ಟ್ ಮಾಡ್ರಿ ಸಾಹೇಬ್ರು ಬಂದ ತಕ್ಷಣ ತಗೊಂತೀವಿ ಬರ್ಬೇಕಲ್ಲ ಸರ್ ಬರ್ಬೇಕಲ್ಲ ಹೇಳಿದ್ವಿ ಲೈವ್ ಇದೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ.
ಸರ್ ಬೆಂಗಳೂರ್ದು ಎಷ್ಟಿದೆ ಇವು ಕೇಸಸ್ಸು?
ಬೆಂಗಳೂರು ಮೂರಿದೆ ಸರ್.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು. ನಮ್ದು ಒಂದೇ ಇದೆ ಧಾರವಾಡದ್ದು.
ಬೆಂಗಳೂರು ಆದ್ಮೇಲೆ ನಿಮ್ದು ಧಾರವಾಡ.
ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು.
ಯಾವಾಗ ಹಾಕ್ತಾನ ನೋಡ್ರಿ ನೀವು ಮೆಸೇಜ್ ನೋಡ್ರಿ. ಹಾಕದ ಮೆಸೇಜ್ ಬಂದು ಹೋದ್ರೇನು?
ಯಾವ್ದು ಕಳ್ಸಿದ್ರು? ಇವತ್ತು ಕಳ್ಸಿದ್ರ? ಮುಂಚೆ ಕಳ್ಸಿದ್ರು? ಸೆಪ್ಟೆಂಬರ್ 18. ಅಲ್ಲ, ನೀವು ಪೂರ್ತಿ ತೆಗ್ದು ಹಾಕ್ಬೇಕು ತಾನೆ. ಈಗ ಸಾಹೇಬ್ರು ಕೇಳಿದ್ರೆ ಏನ್ ಹೇಳ್ಬೇಕು? ಇನ್ನೆಲ್ಲ ಅವತ್ತೆ ಹಾಕಿದ್ದಾರೆ, ಇವ್ರು ಒಂದ್ ಪೇಜ್ ಮಾತ್ರ. ಸಾಹೇಬ್ರು ಕರೆದ್ರೆ ಕರೆಸ್ಲಾ? ಕೇಸ್ ವರ್ಕರ್ ನೀವಲ್ವಾ? ಇಡ್ತೀನಿ. ಬೆಂಗಳೂರ್ದಿದೆ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್.
37 ಆದಪ್ಪ ನಮ್ಮ ಒಂದು 2 3
ಇನ್ನೂ ಇದೆ, ಕಾಲೌಟ್ ಮಾಡಿಲ್ಲ.
ಮುಗಿಸ್ಬಿಡಿ.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇದೆಯಲ್ಲ, ಅದನ್ನ ಮುಗಿಸೋಣ ಅಂತ ಹೇಳಿದ್ರು.
ನಾವ ಫರ್ದರ್ ಇನ್ನಾವ ನಾವ ಫರ್ದರ್ ಇನ್ನಾವ ಅನ್ನು ಫರ್ದರ್ ನಿನ್ನೆ ಆಗಿದ್ದು ಇಲ್ಲಿ ಕೇಳಾರ ಸಾಹೇಬ್ರು. ನಮ್ದು ಫರ್ದರ್
ಏಕೆ ಚಾನ್ಸ್ ಅಂತ ಹೇಳ, ಏಕೆ ಚಾನ್ಸ್ ಅಂತ ಹೇಳಾರ ಇಲ್ಲಿ. ಅದು
ಲಿಸ್ಟ್ ಇತ್ತು ಬಂತು.
ಬಂದಿದೆ.
ತಕ್ಷಣ ಏನು ಪುಟ್ಟಪ್ಪಗೆ
ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಇದೆ.
ಸರ್
ಮೇಡಮ್ ಹೇಳಿ.
ಸರ್ ಇವತ್ತು ಡಿಸ್ಪೋಸಲ್ಸ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ಕಳ್ಸ್ಕೊಟ್ರೆ ಅದನ್ನೇ ಎಲ್ಲ ಕಳ್ಸ್ಬಿಡ್ತೀವಿ ಸರ್. ಇಲ್ಲಿ ಫೈಲ್ ತರ್ಸ್ಕೊಳಕ್ ತಪ್ಪತ್ತೆ.
ಮೇಡಮ್
ಡಿಸ್ಪೋಸಲ್ಸ್ ಆಯ್ತಲ್ಲ ಇವತ್ತು ಸರ್,
ಹೌದು.
ಅದೆಲ್ಲ ಸ್ವಲ್ಪ ಫೋಟೋ ಕಳ್ಸ್ಬಿಟ್ಟಿದ್ರೆ ನಾವು ಫೈಲ್ ಅಲ್ಲಿಂದ ತರ್ಸ್ಕೊಳ್ಳೋದು ಅವಶ್ಯಕತೆ ಇರ್ಲಿಲ್ಲ.
ಲೈಕ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್, ಈಗ ಒಂದು ಸಾಹೇಬ್ರು ಎದ್ದಿದ ತಕ್ಷಣ ಮಾಡ್ತೀನಿ.
ಸರಿ ಸರ್, ಓಕೆ ಸರ್.
ಪೆಂಡಿಂಗ್ ಇದೆ ಪೆಂಡಿಂಗ್ ಸರ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಬಿಟ್ಟು ಬಂದ್ರು ಮೇಲೆ ಅದಕ್ಕೆ ಬೇಕು. ತಟ್ಟೆ ಸಲ ಇನ್ನೇ ನೀವು ಇದ್ರಲ್ಲ. ಸರ್ ಸರಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 2. Just one late. One ಜಾಸ್ತಿ ಆಗಿದೆ. ಮೊನ್ನೆ ಇದ್ದಲ್ಲ.
The constitutional law book. Constitution law.
ನಾನಾ ಏನ್ ಬೇಕಾ? Appearance is as before. Appearance is as before.
Item number 43. I am withdrawing with liberty to challenge the endorsement. I have served the copy other side.
We had dismissed it for non.
My lord has dismissed it for non-prosecution.
Last 3 days in the avoid ಮಾಡ್ತಾ ಇದೀರಾ. ಇದಾರಾ?
Madam. Sir.
List 1, serial number 43. Petitioner is before this court seeking for the following reliefs. A memo dated 26/9/24 has been filed by the petitioner which reads as under. Accepting the said memo, the petition is dismissed, reserving liberty to challenge the endorsement dated 7/1/02/2012.
My lord, formally recall the DNP.
ಅದನ್ನ ಸೈನ್ ಮಾಡಿಲ್ಲ.
Grateful.
Matters pertain to Principal Bench, Bangalore, for pronouncement of order, serial number 1, Sri Gurudev Prasad KT, Sri K. Vijay Kumar.
No grounds having been made out, the above appeal stands dismissed at the stage of admission itself. Pronouncement ಇಲ್ಲಿಂದ. Kalaburagi. First pronouncement.
Matter pertains to Dharwad Bench for pronouncement of order.
Please, my
Serial
lord.
number 1, Sri Sadiq N. Gudwala.
I appear for respondent. I appear for respondent, my lord.
Yes, Mr. Reddy. The writ petition in WP number 101231 of 2025 is allowed. A certiorari is issued quashing the impugned order passed by so and so at Annexure B. The order passed by respondent number 3, Deputy Commissioner at Annexure D is confirmed.
Please, my lord, highly obliged.
Kalaburagi bench pronouncement. Kalaburagi.
Pronouncement of order, Kalaburagi Bench, serial number 50, Sri Naresh Kulkarni.
Where's Mr. Sudhir Kulkarni?
Sri Sudhir Kulkarni.
Arilva. Writ petitions allowed, there being no compromise which has been recorded, no settlement being placed on record. The letter bearing number 146 of 2014 dated 21/4/2014 issued by respondent number 1 to 4 wide Annexure F is hereby quashed. A mandamus is issued directing respondent number 4 to take appropriate action to delete the name of respondent number 5 from the revenue records and reinstate the name of the petitioner in the said revenue records within a period of 30 days from the date of receipt of a copy of this order. The same shall however be subject to the final decision rendered in miscellaneous appeal number 15 of 2009 by the fast track court 1 in Raichur. Respondent number 5 has abused the process of Lok Adalat. The member secretary is directed to file necessary complaint with jurisdiction police since as on the date the matter was taken up before the Lok Adalat. Respondent number 5, late Bankat Lal, son of Sonu Lal, had already expired, but someone had claimed to be him before the District Legal Service Authority. Raichur has also taken such action against such person for abuse of process of Lok Adalat and such offences as may have been committed by him.
Miscellaneous appeal is already disposed of, my lord. That was challenged before this court, my lord. I had given the judgment.
That was
In
challenged in
Karnataka-
WP number 1044.
That was
That has
allowed
been
and
remitted back.
before in Karnataka Public Premises Act, that proceedings is.
ಹೌದು ಅದು ರೆಮಿಟ್ ಆಯ್ತಲ್ಲ.
Yes.
Your eviction was ordered.
That was set aside, man.
That was set aside
Set
by
aside and
the,
it was remitted to the before the tribunal, wherein proceedings are going on under Karnataka Public Premises Act. Only evidence.
by one order was challenged
Yes.
before the fast track court. Fast track court set aside the 5-1 order. That came up on appeal in a writ petition.
Yes.
Writ petition came to be allowed, remitting it back to the fast track court. Fast track court dispose ಆಗಿದೆಯಾ? ನಿಮಗೆ ಗೊತ್ತಿರಲ್ಲ ಬಿಡಿ, ಇವ್ರು ಕೇಳ್ಬೋದು.
Allah, the miscellaneous appeal was preferred, against which the writ petition was filed. And during pendency of writ petition, that proceedings took place. That
Writ
mutation.
petition dispose ಆಗಿದೆ Mr.
Yes,
Kulkarni.
yes, that has been.
Remitting back.
Yes, it is remitted back to the Waqf tribunal wherein the proceedings are going on under Karnataka.
Tribunal fast
ಹೌದು.
track court remit ಆಗಿದೆ. ನೋಡಿ
Public Premises Act ಕೆಳಗೆ ಆಗಿದೆ.
ಪಬ್ಲಿಕ್ ಪ್ರೊಮೈಸಸ್ ವರ್ಕ್ ಟ್ರಿಬ್ಯುನಲ್ ಗಲ್ಲ. ನೀವೆಲ್ಲ ಟ್ರೈಬ್ಯುನಲ್
Premises Act
ಟ್ರೈಬ್ಯುನಲ್ ಅಂತ
before the-
ಹೇಳ್ತೀರಾ. Not to the tribunal, it is to the, so it's subject to that order.
Cell number
You will have to take action by filing a complaint against that person who appeared. We have directed you to file a complaint with the jurisdiction police because somebody has impersonated.
Cell number 51, Sri Chaitanya Kumar Chandriki, Sri Sudhir Singh, Ajur Vijapur.
The petition is dismissed.
Cell number 52, Sri Ravi B. Patil.
The writ petition is allowed, a certiorari is issued, the order dated 30/11/22 passed by respondent number 2 in file number so and so. And order dated 16/11/23 passed by respondent number 1 and appeal so and so at annex G are set aside. Respondent number 2 is directed to evict respondent number 4 from the property subject matter of this petition and over the physical possession to the petitioner, as also to register a criminal complaint against respondent number 3 for having executed an illegal agreement of sale in favor of respondent number 4 within 30 days from the date of receipt of copy of this order. Respondent number 4 is also at liberty to initiate such proceedings, being both civil and criminal in nature, against respondent number 3 for such relief as respondent number 4 intends to in the circumstance of this case.
Cell number 53, Sri Layakat Farid Ustad, Sri Harshvardhan Mali Patil.
Writ petition is allowed. The order dated 12/2/24 passed in RTS so and so by respondent number 8 is set aside. The matter is remitted to respondent number 10, Tahsildar, to conduct an inquiry as regard the persons who have succeeded to the estate of the deceased Dawal Saab and make entry of their name into the revenue records. Insofar as respondent number 1 is concerned, liberty is reserved to respondent number 1 to file such proceeding as may be advised and thereafter approach the concerned authorities for entry of his name in the event of him being successful in those proceedings.
Cell number 54, Srimati Preeti Patil, Sri Sanju Patil, Subhash Malapur.
No grounds having made out, all the above writ petitions stand dismissed.
Matters pertaining to Principal Bench, Bangalore, for orders, serial number 2, the Monica Patil, Pawan Kumar.
My lords, I appeal for the BBMP.
Yes.
My lords, I had not received the third page of the affidavit which I had filed last time. Your Lords.
Yes.
My lords, have the complete affidavit.
Please convey our compliments to the special commissioner.
We'll do that.
Very
Much
good.
obliged.
A compliance affidavit of respondent number 2 and 3 BBMP has been filed in the form of an affidavit of the Special Commissioner Revenue BBMP. The same reads as under. A perusal of the above affidavit indicates that 21 lakh property ownership records in Bangalore have been digitized and they are under the process of being verified, which will be completed in 45 days. And the e-Khata for digitized property records would be issued from 30/9/2024 and completed by 30/11/2024. As also several other steps have been undertaken, which would bring about transparency in the operation of the BBMP. The said affidavit is taken on record. Since the compliance is ongoing and 45 days is indicated for completion of verification, released on 12th December for reporting further compliance.
Great, Manoj.
For orders, seal number 3, Sri Manjunath SV, Sri Pawan
Lord,
Kumar.
I am appealing for the petitioner in this case, my lord. Lord, your lordship has given me to close down the commercial activities till to 25th of the September, my lord. My lord. My lord, I have produced the sale deed, my lord. Your lordship kindly see the sale deed which I have purchased on 23/7/2024, my lord. I am only requesting the end of this month, my lord, so that I can shift the entire commercial activities, my lord.
End of October, huh?
Yes, my lord.
IA 2 of 2024 has been filed seeking for extension of time granted by this court on 19th February 2024. Yavattu dated? Order date, no? Wrong with the
Lord, the order date is, my lord, your lordship was till
21st December 23
yes,
and subsequently extended. Considering that the petitioner has purchased a property and is in the process of shifting thereto, which would be completed by end of October 24. Application IA 2 of 2024 is allowed. The time granted is extended until 31st October 2024.
obliged, my lord. My humble request is, my lord, the order may be uploaded today itself, my lord, to serve to the BBMP officials, my lord.
If it is ready, it will be uploaded.
Please, my lord. Thank you, my lord.
End of the list. For orders, serial number 1, Sri Deepak P. Bharat, Sri Liaquat Farid Ustad.
Respondent number 2 has been wrongly mentioned in my petition, my lords, instead of
Correction.
correction.
You filed amendment application.
Yes, ma'am. Amendment as well as correction of order as a. Instead of Tahsildar Bidar, it has been mentioned as Balki, my lord.
IA 1 of 24 has been filed for amendment of the cost title in the above petition. That counsel for the petitioner submits that inadvertently the second respondent has been arraigned as a Tahsildar Balki, District Bidar, when in fact the Tahsildar Bidar Taluk, Bidar District was to be arraigned. They said submission of the counsel for the petitioner is accepted. IA 1 of 24 is allowed. He is permitted to carry out amendment and file amended cost title. IA 2 of 24 has been filed for amendment of a judgment. It is not permissible for a party to seek for amendment of a judgment. Hence, IA 2 of 24 stands dismissed. In view of the amendment to the petition being allowed, registry is directed to carry out necessary correction in the order dated 5th September 2024 and issue fresh copy of the order. That's only that one.
For preliminary matter, sale number 2, Srimati Rajeshwari Malinath.
Yes. calendar of events has already been issued.
Issue.
And SCGP accepts notice for respond number 1, 2, 5. Shri Amresh Roja accepts notice for respond number 3. Yadgiri Yaro, PMC. ನೀವ್ ಹೇಳ್ಬೇಕು ಆ ಕಡೆ ಈ ಕಡೆ ನೋಡಿದ್ರೆ ಏನಾಗಲ್ಲ. ಯಾರು ಮೇಡಮ್ TMC ಯಾದಗಿರಿ?
Gaurish Kashampur. Gaurish Kashampur.
Gaurish Kashampur for respond number 4. Issue notice to respond number 6 and 7. Returnable by 13th November. Elections, if any held, will be subject to result of the above petition.
My only submission was that, my lord, the question which I have raised, the challenge which I have made is electoral roll. That is not a subject matter of the election petition to be challenged. Therefore, I will be left with no other remedy except to approach
Once
this.
there is a calendar of events issued, no order. Supreme Court has said that. There can't be any injunction against election.
It is in furtherance. I am not seeking for quashing or declare that election is null and void. I am not seeking or coming in the furtherance of the elections. My only request is that electoral roll, the member of legislative council who
Let
do
the
not,
respondents appear, madam. Can we allow your petition without them appearing?
not allowing. It could be postponed for some, and after the service, my lord, it could be disposed of.
That is why once there is a calendar of events issued, no interference by court. As simple as that. For the hearing.
For furthering matter, C number 46, Sri Sangana Basava B. Patil, AGA.
In this case, there was a order dated 2019.
Order with that.
It's at page number, ink page 129.
Have you furnished a copy?
Copies.
Yes, yes, I've got a copy. Though most of the documents are in Kannada, I have access to some of the documents which I've got translated.
29.
129.
129.
Yes.
I don't have a copy of this one.
Mr. Jaikar, you have received it now. You want to go through them?
I would, in fact, I'd like to get them translated also, some of them which I don't have. 129 is something which I don't have.
Because you should not be under handicap because
Yes,
of
Lord.
language.
Lord, may I just point out one thing? Would my lord kindly see the order which has been passed?
No. When we'll hear you, we'll hear you.
No, the order which my lord had passed on the last occasion. Learned SCGP is directed to place on record the government order dated so and so, referred to in subpara of the statement, as also the methodology of calculation of the value of land. Now, my lord, that methodology has not been given.
So now
They
the
have
government
indicated-
order of 21/1/2019 is placed on record.
It
Yes.
is there, no.
Which is at 130 apparently. my lord.
120,
129 is that order. Dated 21/1/2009.
please.
Yes, madam. Methodology of calculation.
And the
Methodology is being-
methodology, my lord, has not been given.
That
I'm
I
sorry,
explained.
I'm sorry, my lord, I'm sorry.
It has been enclosed, my lord. It runs in page number 51,
51.
25.
51 ಅಲ್ಲಿ ಏನಿಲ್ಲಲ್ಲ.
There is a valuation of bund ಅಂತ ಒಂದು. Shankarrao Shivlingarao Deshmukh of Almel. Valuation of bund ಅಂತ. That is folded papers.
ಅದು page 2.
Yes.
ಏನಿಲ್ಲ. Page numbering ಸರಿ ಇಲ್ಲ madam.
Actually, those, all the papers were paginated as 1, 2, 3 in ink page 25. That is to be corrected. Pagination is to be
Because it comes to 25.
25.
Then
There
it
are,
goes again to 11.
yes, that. I'll make
So this
correction.
is the valuation of the bund.
Bunds.
Value that there's no dispute.
There's no dispute.
It
Valuation
is
of the
not-
rest of the property.
there is no dispute, and as far as interest is also concerned, there was a mediation referred by in the contempt court proceedings, my lords. They appeared to the mediator in ink page 129. The proceedings have been incorporated and it was taken note of while awarding 75 lakhs, my lords. Kindly
What was
peruse
this 75 lakhs arrived at?
129, ink page 129. It was referred to mediation in the contempt proceedings, and it was offer given by the petitioner itself. 129, relevant portion is what's, in page number 2 of the said order, my lords, the government order. The second para. ನಂತರ ಸದರಿ ಅರ್ಜಿದಾರರು ಓದಲಾದ 6 ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಇಲ್ಲಿ ನ್ಯಾಯಾಂಗ ನಿಂದನಾ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋನ್ಸು ದಾಖಲಿಸಿದ್ದು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 7/12/18 ಆದೇಶದಂತೆ ದಿನಾಂಕ 12/12/18 ಬೆಳಗಾವಿಯಲ್ಲಿ ಜರುಗಿದ ಸಂಧಾನ ಸಭೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ರೂಪಾಯಿ 75 ಲಕ್ಷಗಳ ಬಡ್ಡಿ ಮೊತ್ತವನ್ನು ನೀಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. That was considered by the authorities, my lords. Even that was paid to the petitioner.
But then you have given 59 lakhs 85,690.
That was the principal amount. That is for the damages. And it, they claimed the interest.
Really the 75 lakhs with buddy.
With,
75 lakhs with
75 is the interest.
See, if you had given whatever they had asked for,
Please.
then you could have said it is what they have asked for, we have given, there's no need of a calculation. You did not give what they asked for.
That
They
was
asked for 75 lakhs with interest. You gave 59 lakh 85,691 and interest on that.
interest is 75 lakhs. The 59 is the damages.
Correct. They asked for 75 lakhs.
That is interest, not the damages, because they have considered.
No, may I just-
Contempt was
May I
for
just make it a
the
little simple, my lord?
calculation of interest.
59 lakhs was the value of the bunds. Then, my lord, they did not give me interest, so I came to the High Court. High Court said, no, they are entitled to interest in view of Arish's judgment of the Supreme Court. That amount was computed at 1 crore and odd. Then, my lord, I was called, and then there was some mediation, and they said, don't take 1 crore and odd by way of interest for the bunds, take 75. At that time, my lord, my father agreed, and we took 75. Lord, all that is now history. I'm
That's for
not
the
talking
bund.
of the bunds, and I'm not talking of the interest on bunds. I'm talking, if my bunds could fetch me 59 lakhs, how can my land, which is 3,000 acres, fetch me 4,31,000? That is my small issue.
So
And
this does
they-
not deal with it at all.
They don't deal with it all. And what they say is 4,31,000 we could pay. We can't pay you anything more because 72(5) says nothing more than 2 lakhs. But 72(5) says both bunds and lands cannot exceed 2 lakhs. They have paid me 59 plus
They
75.
exceeded, why not the land? There's no reference
was-
to the land.
So what was the proposal that was considered by the authorities, and even in the mediation, your lordship may peruse 123 ink page. There is a signature of the petitioner in the mediation record. No?
This is as regard the bunds, madam.
Yes.
Yes,
The present dispute is not as regard the bunds.
even in that proceedings, they could have sought for the valuation of the land.
They've been
That
asking you for decades.
is,
Decades
this
they've
is
been
highly
asking, you have
related
been
claim.
releasing it bits and
this
pieces.
is highly belated claim, my lords. They have considered regarding
The
59
duty,
lakhs
the
also
duty
and-
was on you to make payment for the bunds and the land.
lands.
For the bunds, which extent is probably not even 3% of the total land. You are given 59 lakhs. Let us accept your calculation. They
Consider.
are also accepting your calculation. The rest of 3,000 acres which you took, which admittedly you took. For the bunds, you give 59 lakhs plus interest of 75 lakhs. Let's take the principal of 59 lakhs. For the land, you are giving 4 lakhs.
That is the provision of law 72(4), they referred that.
That
as-
provision of law, it did not apply for this 59 lakhs. Even 4 lakhs will not apply because highest is
That 2 lakhs, that again, I'll have to refer the Tahsildar's order where 1,54,000 was the amount which was given initially. And additional amount, that was below 2 lakhs.
ನೀವು bunds ನೋಡಿ,
Out.
see
Bund,
bunds valuation.
valuation.
Why do you want a citizen to be running, coming to court so many times? For what he is entitled? Now, total bund area, what is the total bund area, Mr. Jaikar?
No, the total bunds were, it's not the area of the bunds, it's how many wells were there, on this thing, my lord, that has been given in that
Is
statement.
there a calculation made of the length and width of the bunds?
Funds.
Yes,
It
my lord.
is- it
My lord,
is
that has
made.
been, if my lord sees, my lord, that abstract, which is that final document,
2,914 square meters, or what is this?
no, it is 2,914.13, I don't know, my lord. Because it has to be acres. It has to be acres, my lord. Because 3,118 acres
See,
were
this
taken over.
is length meters, section square meters is what they have given in page 5. So square meters is what has been taken into calculation. So this obviously seems to be 2,914 square meters.
No, but it can't be.
Effective verification.
Because if it is 3,000 acres, the total lands can't be this, my lord.
The
We're talking of
bunds.
village area. We're talking, my lord, if my lord sees in that chart, somewhere down wells, 59 wells, 13 wells, that has been computed at, so my lord, this 57 lakhs 75,000, how that has been arrived at, I couldn't follow, my lord. In that abstract chart.
See, water well, WW is water well. we
Yes,
presume,
yes, my lord.
at the rate of 2,000 per well.
Yes,
They have
and these
calculated
appears to be
separate.
bunds, and I think those are the areas of the bunds.
Bunds.
My lord is right.
So this bund area here is section square meters.
Yes,
There's not been subtotaling has not been made. You could
so
probably
there is a
verify.
subtotal. There's a subtotal on the last page. my lord.
Pages, in the last.
There is an abstract.
Abstract we have,
Yes,
but on each page it is not there.
in each
Probably,
page it is not there.
probably if there's we can't do an assumption.
No.
You will have to look into it
No,
and make
but
that.
I am not on these bunds. These are all bunds. Yes.
You will have to look into for the purpose of arriving at the valuation of your land.
Lands. No, my lord, lands are to be valued under 70-1.
Correct.
And that does not talk of this. 70-1 gives a particular formula.
But if 2,914 square meters
Yes, my lord.
are valued at 57,75,000.
Those are the bunds. Yes. And then what would 3,000 odd acres multiplied by how many does it come in square meters? And what is the rate? I agree, my lord. In fact, my lord, if my lord sees, it is not just that. If my lord sees kindly for a moment, 70-1, the section.
The numbers are mind-boggling.
And my lord, it's not only me. There are a whole lot of these landowners, their lands have been taken and they have been paid.
How much has been paid?
No, they have been running in crores. That's what my client tells me. No, but my lord sees 70-1. Save is otherwise provided in this act. The amount payable in respect of land to be taken over by the state government under so-and-so sections shall be determined with reference to the net annual income derivable from the land in accordance with the following scale. For the first sum of rupees 5,000, 50 times. 15 times. For the next sum of rupees 5,000, 12 times. And for the balance, 10 times. So, my lord, you have to first find out what is the
There's a
net
statement
annual
of
income.
calculation insofar as you are concerned. Have you prepared a statement of calculation?
I'm sorry, my lord.
Have you prepared a statement of calculation? Memo of
But I have, but I don't know what the net annual income would be. My determination wouldn't be, my lord. They may have a different determination. I would, my lord.
According to you, what is it?
I will. In fact, that is what I wanted to point out to them at the hearing to be given to me. They said, sorry, beyond 2 lakhs, you can't go home. This is how, my lord, this is to be computed. Now, my lord, may I only say, as I told my lord on the last occasion on BC, you can't render a section have no meaning. My lord, the section talks of, this first thing talks of the land. What is land, my lord? If you go and see under six, because this all falls under section 63. I mean, from 63 onwards. And no, that is a separate chapter. And under this, my lord, it falls, there are units. So, my lord, this value is per acre. That unit has been defined. Ceiling on land holding. Has my lord got that, my lord?
Yes.
63. No person who has not a family, etc. The ceiling area for a person who is a tenant under clause so and so shall be 40 units. Now, what are units, my lord? Units are defined in section 36. 236.
That may not be relevant.
No, it would be, my lord, because then if that land, word land, it's not lands, land, and it is unit. Unit, my lord, is defined under under section 236, and it talks of 1 acre. So what is a person who has a family entitled to keep? 20 acres. Above 20 acres, it will be taken over. I have to declare it.
Yes.
So, my lord, today this thing is the land. So if you have to see land and 1 unit, then per acre you can't pay me more than 2 lakhs. Is how I would interpret 72(5).
This issue has not come up for
Nowhere.
consideration in any matter.
Unfortunately, it has not. All that they said was you cannot hold somebody's money under 72 is the 2 judgments that we've got. That's all, but not 5.
Last 50 years it's not come up for consideration.
Apparently, I probably am the path breaker to go down into.
After half a century.
No, that is, and today, my lord, all has gone by the book. Now we are talking of lands. Please tell me how we have computed even 4,31,000. Have you followed 72(1)? No.
That argument will not lie for them to take up
now it
now
cannot
after
be.
giving
Maybe
59 lakhs for the bunds and even valued it at 4 lakhs.
If the order pursuant to my lord's order, if they had considered this and not shut me out on the guy, 72(5) says nothing beyond 2.
Madam, please get proper instruction. If you need the additional advocate general to appear, please let him
Yes.
appear. Please request him to appear or her to appear. This is, if we go by what Mr. Jaikar is saying, even if we take this 2 lakhs into 3,000 acres is concerned,
That's
we-
what it was referred to mediation in order to arrive at a final conclusion regarding the compensation, including all the matters. That was.
the numbers are huge.
Staggering.
And I don't think Mr. Jaikar's client is also expecting that kind of numbers. Because firstly, it is that number plus interest. They also will not be expecting that
But
kind
the
of
only thing is,
number.
but others have been paid. Others have been paid.
You want to bankrupt the state of
No, no.
Karnataka, Mr. Jaikar?
Certainly not. Certainly not.
Speaking of 3,000 acres into 2 lakhs.
I appreciate. All
Not a
of
small
these lands
sum.
have not been alienated up to now. Give me my lands back.
Fair enough, but that kind of money.
I agree, my lord. It is staggering.
We'll be only looking at the principles, but
Yes, but my lord,
like in any other matter, it comes up before us as a partition or a specific performance, we would probably say sit across and sort it out.
I am in fact ready, my lord, if somebody even indicates to me. The Tahsildar said, I don't have any powers. Deputy Commissioner says.
That is why
yes.
we are asking the
Yes.
SCP, number 1. Get
Please.
the order that you relied upon, obviously, which you have now pointed out, does not even refer to this. And that is in the settlement of the bunds, where you gave them 59 lakhs plus 75 lakhs. That was calculated in 63. 59 lakhs. For 2,914 square meters.
Since my lord's.
2,914 square meters, to put it in perspective, is 3/4 of an acre.
That was not based on calculation on the proposal of the petitioner was
Sorry,
taken to mediation.
6 acres or 7 acres were at that. 29,000 into 10 is 2,90,000 square feet, roughly around 7 acres, 6 acres, or 7 acres. 7 acres, if you are given 59 lakhs, that is much more than this 2 lakhs what
No, it would, the amount is not.
Jaikar is also asking.
No, the amount is not so staggering. It's 62 crores. It's not, will not bankrupt the economy or the government, my lord. 62 crores.
3,000 acres.
Yes.
3,118 acres.
3,118.
118 ಬೇರೆ ತಗೊಂಡ್ಬನ್ನಿ. In the kind of areas 118 is too inconsequential.
Peanuts.
Let them
Yeah,
file
60
the memo of
crores, 60.
calculation, my lords, let them file the memo of
Without
calculation.
600 crores ಬರುತ್ತೆ ಅಂತ 60 crores. 60 crores plus interest. From 63 to now.
My submission is that mediation was done in the presence of Secretary of Revenue.
That is the only
that may be
submission
for
that you have to
bund
make
and
your submission, allow their petition. That is the only submission.
He is the
Please get
signatory.
Proper instructions.
That's
Who would have to take decision on this? Principal Secretary, no?
revenue.
Please get instructions in writing.
Please.
Please file an affidavit.
Please.
So this will have other repercussion in other lands also. So please take it with seriousness and deal with it with.
If they come up with some of the figure that could be, because they are went on filing one or the other. At one juncture, they say that for the land, the
ನಿಮ್ಮ
calculation of the
valuation
land.
ಪ್ರಕಾರನೇ 29,000 square meters. That is roughly around 3 lakh square feet. You're paid 59 lakhs. 3 lakh square feet will be divided by 44,540. It will be roughly around 7 and odd acres. So for 7 acres, if you say 59, simple mathematics, class 7 acres ge 59 lakhs andre, adella side alira numbers bitbidi.
That how much for?
3,118 ge, how much? 3,118 into 59 lakh by the other calculation that Mr. Jaikar is giving is the maximum is 2 lakhs per acre. That's a very straight and simple calculation. 3,118 into 2 lakhs plus interest for both the accounts.
That would be a reasonable way of looking at it, Millard, is how I'd feel.
Both ways, we are not bothered about the numbers. For us to pass an order, it doesn't matter. But for the state to make a representation, you will have to think about it.
Yes.
Your submission that because that 129 order it is taken care of will not stand. That was only relating to bunds, not anything else. And there is no order that has been placed on record as how you valued 3,000 acres at 4 lakh of rupees. You will never be able to place it.
That is way back in the year 1970 it was.
74.
74 it was passed.
Adam, it is contradictory. 74, if you have valued 7 acres at 59 lakhs. Same date valuation. You can't value 3,000 acres at 4 lakhs. Manifestly arbitrary. On the face of it, it does not make sense. So please,
Yes.
if you make that submission, we'll have to deal with it in a way that may not be palatable.
I'll take the instruction.
Is
Please
it
get
possible, Millard,
instruction.
for Millard to suggest that it should go to the secretary or whatever, Millard? For it to be taken up at the highest level?
We'll record.
Millard, I've just prepared for this convenience of the court, a chronology of dates and events and what is found where. Just if my lord just keeps it on record.
But better would be for your instructing counsel to make a memo of calculation, give it to the SCG.
Okay, very well.
As per whether, not that what you say will be, is right or acceptable,
No problem.
but at least that will be something that she can get instructions on.
Definitely.
The government order dated 21/1/2000, learned SCGP has filed a memo. Memo illa.
Memo.
No, this is one.
Memo enclosing the letter dated 26/9/2024 received by her along with the documents stated therein. Copy thereof has been furnished to the counsel for the petitioner. At page 129, the government order dated 21/1/2019 is found. Perusal thereof indicates that the said order relates to the valuation of the bunds and the interest, and more so, the interest to be paid on the belated payment for the compensation on account of the bunds. The said government order does not deal with the land, which is subject matter of the present writ petition, which is stated to be 3,118.
3118.
That is for Sharanabasava only to say. 3,118 acres, which has been valued at rupees 4, which in all has been valued at rupees
4,31,000.
31,000.
To be precise, 4,31,100.
421
4,31,100.
431,100. Hello. On the face of the calculation made, to put it very simply, the calculation does not make any sense. The bunds which have been taken over are stated to in all measure 2,914.13 square meters, for which an amount of rupees 57,75,691 has been awarded as compensation. And and as regards the wells, a sum of rupees 2,000 per well has been made payment or has been valued. Totally for the bunds and the wells, the amount paid was amount valued was rupees 59,85,691. Due to delay in the payment when the matter was taken, mediation was resorted to as regards the interest amount, which was mediated and settled at rupees 75,00,00,000, as reflected in the order dated 21/1/2019. The said government order, as afore observed, does not deal with the land, nor is any valuation, report or calculation relating to the said land placed on record before this court. If the valuation for 29,000 2,000, not 29,000.
2,914.
We are thinking 29,000. 2,914.13 is taken into consideration, for which 57,75,691 has been agreed to be made payment of as compensation. The question of compensation at the rate of 431,100 as in respect of 3,118 acres is concerned does not make any sense. Learned SCGP is directed to secure necessary instructions from the Principal Secretary Revenue Department and file an affidavit of the Principal Secretary Revenue Department or such concerned officer as he designates, placing on record the mode and methodology of calculation which is required to be adopted. Learned counsel for the petitioner is also permitted to file a memo of calculation as regards the amount which the petitioner claims to be due on the file of this court, as also to furnish a copy thereof for the learned SCGP to take up the matter further. Yes, then agate, madam.
4 weeks.
Relist on 4th November,
4th November.
Monday at 2:30 PM.
Much obliged.
Number 47, Sri Mantesh Patil, AGA.
Yes, madam, water.
On the last date of hearing, Lordship directed to respondent to be present before your Lordship and submit the submission.
Submitted the photographs, everything is done.
I have not.
Yesterday, Mr. Patil was to say whether he wants to continue or not.
Please, my lord.
That's the earlier story.
I will kindly pass on, my lord.
Pass over.
Please, my lord.
Seal number 48 for report compliance, Sri Shivananda Patil.
Compliance. Report has been filed. Memo enclosing the circular is issued by the secretary.
Hopefully you'll start getting instructions now.
The authorities comes under the municipal administration has been specified in below par.
ಎಲ್ಲರಿಗೂ ಕಳ್ಸಿದಾರ?
ಎಲ್ಲರಿಗೂ.
A memo dated 28/9/2024 has been filed, enclosing a circular dated 27/9/2024, issued by the Undersecretary, Urban Development Department to all the urban development authorities. The same is taken on record. Compliance is held complete. Petition is closed.
Seal number 49 for orders, Sri Mantesh Patil.
In this case, it has been instructed that there is a 20 feet road which was laid by the ZP authorities. ZP had laid 20 feet wide road and it was given to the PWD for purpose of improvement. And they have not made any widening of the road. The existing road was being improved by the PWD authorities.
So how did a 8 feet road become 20 feet?
It was in existence of 20 feet road, not the 8 feet road.
ಅಲ್ಲ
Because
ನೀವ್
what
ಹೇಳ್ತಾ
they
ಇರೋದು
have-
ZP has made 20 feet ಅಂತ.
ZP.
ಅಲ್ಲಿ ಇರೋದು ಬರೀ
Whatever the
contract.
PWD authorities, when they have taken for the purpose of carrying out the improvement, it was existing 20 feet road. 20 to 25 feet. And as far as the petitioner's land is concerned, since they opposed for the purpose of laying the improvement work, my lords, that portion of the land was not been improved, where the petitioner's land is in existence.
Now you are now blaming it on the ZP.
ZP. It has been
ZPS.
instructed.
Yeah, sir, we
They have
should
to
not
arrange.
aware about all these things because they will internally the departments. will-
ZP may make them a party ಅಷ್ಟೇ.
If they give not any copy that it was the ZP who was handed over.
When was it handed over?
But even in the village map, there is no road.
Contract ಇದೆ ಅಲ್ಲ.
Katraku ಇಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಏನಾಗಿತ್ತು? It was in the year 1979 lords, due to the drought in this area, in this part of area. The farmers were given lords for laying the road for connectivity purpose and the government has paid the amount for that. And they continue to utilize the road. There is no even road under the map also. There is no court pay.
ಏನಂತಿದೆ ಇದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ. Nothing is there in this.
Like 2 months ago, that road was being improved by these authorities and it was given by the ZP.
There's an admission that you
That
are
will-
making the road. There's no doubt about you making the road. The question is, have you acquired the land before making the road?
The acquisition proceeding in respect of these lands are not there.
You have not said anywhere that Zilla Panchayat has handed it over to you in this letter.
It is
If the Zilla
three-
Panchayat has handed over, when was it handed over?
2 months ago, they will place.
2 months ago.
2 months. ಈ ರಸ್ತೆ ಸುಧಾರಣೆ ಮುಂಚೆ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಇರುತ್ತದೆ. So the improvement was being made by the ZP and those roads were
ZP
handled.
Kalaburagi.
Kalburgi
ಸೊ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
ಮಾಡ್ಬೇಕು.
ಯಾರಪ್ಪ ZP Kalaburagi?
ಉಪಸಾಗರ್.
Finally, respond number 2. So and so is present before this court.
Respondent 2 is Assistant Commissioner.
Huh?
He is,
who is
Respondent 5.
Who is present now?
Respondent 5 is present and Respondent 3 is present. Tahsildar Afzal.
Respond number 3 and 5 are so and so are personally present and have instructed and given instructions to learn SCGP. On the basis of said instructions, learned SCGP submits that 2 months ago, the Zilla Panchayat Kalaburagi had handed over the subject road to respond number 4. Who was it given to?
Respondent 4 and 5.
Respond number 4,
PWD.
who have in turn engaged KKRD, who have engaged in the development of the road under the KKRDB projects. A submission on instructions is that respond number 4 has not widened the road, but has only improved the road as handed over by the Zilla Panchayat. On inquiry as to how the Zilla Panchayat came about to be in possession of this land, more so when there's no road shown in the village map, she submits that she has no instructions on the same and it's for the ZP, Zilla Panchayat, to make the submission. In that view of the matter, I am of the considered opinion that the state of Karnataka, represented by the Principal Secretary, Rural Development and Panchayat Raj Department, as also the Zilla Panchayat Kalaburagi, represented by its Chief Executive Officer, are required to be brought on record as party respondents. They are so brought on record as respond number 6 and 7. Learned SCGP accepts notice for respond number 6. Shri Krupa Sagar Patil is directed to accept notice for respond number 7. Counsel for the petitioner to carry out necessary amendment and file amended cause title. Has also furnished 2 sets of the above petition to Shri Krupa Sagar Patil. Shri Krupa Sagar Patil is directed to obtain instructions and make his submissions, as also produce documents as to how the Zilla Panchayat came about in possession of a portion of the lands in the portion of the land of the petitioners, and on what basis a road was formed by the Zilla Panchayat, if there is any acquisition, to place the details of such acquisition on record. Released on 6th November. And why are not instructions being given on time? You're all on CCMS?
CCMS CCMS
ಇದಿರಲ್ಲ CCMS ಅಲ್ಲಿ. ಅದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡಕ್ಕೆ ಯಾಕೆ ಡಿಲೇ ಮಾಡ್ತೀರಾ? Our HCGP will get embarrassed before us when she keeps on taking time. Niman Kariyad, we don't want to call you. You have your other work. But if you don't give instructions, the matter will be languishing. Please give instructions on time.
47. 47.
47.
47, I inquired with my client. In fact, from the last 10 days, there is a water. But the difficulty what they are not facing is, there is an irrigation land. The water is used by the irrigated lands. That is why it will be dried up not within 2 months. That is what they are facing the difficulty to harvest. And last time they have 10 lakh rupees they lost because of that reason. When they graze the fish.
Now that water is there, they can't give you
But
back.
that is why I request Malords, it may be 15 days may be given. They will, Malords, if the water is survived, they are ready to go with the. ಒಂದು 15 ದಿವಸದಲ್ಲಿ ಅದು ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
15 days ಕೊಟ್ಟು ಏನು ಪ್ರಯೋಜನ? We'll record the statement and close it today.
But the difficulty there, what they are facing is, at least Malords now, because
You have executed the tender for 1 year. ಸ್ವಲ್ಪ ನೀರು ಬರೋದು ಹೋಗೋದು ಎಲ್ಲ ಆಗ್ತಾ ಇರತ್ತೆ. In this area, that's a risk you take in the business.
even work order is not issued till today.
They'll issue the work order, but without work order, you have been.
No, but we are not carried out any business. Zero, Malords. We are absolutely, there is nothing on.
Fisheries work is going on, Malords. They
Fishing
did not-
work ಏನು ಮಾಡಿಲ್ಲ.
And if they are doing any fishing work without work order,
The work order, because it
you
was
know
done,
what action is to be taken.
We have not carried Malords any.
it is due to their.
ಇಲ್ಲ ಸ್ವಾಮಿ, I will file the Malords even affidavit because my client specifically stated, even I verified with my client. ಹಂಗೇನೋ ಇದ್ರೆ ನಾವು ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೋ ಪ್ರಶ್ನೆ ಬರ್ತಿದ್ದಿಲ್ಲ. ಈಗ 23 ಇಂದ up to June 1st ಗೆ they have asked to deposit the another second year amount, though Malords, the tender was issued in the month of 1/1/2024.
And counsel for the petitioner seeks for 15 days time to obtain instruction from his client and make his submission. Released from parted, released on 4th November.
Interior order may kindly wait.
ಏನ್ interim order?
ಅದು ಅಮೌಂಟ್ ರಿಕವರಿ ಇತ್ತಲ್ಲ, ಅದು ಸೆಕೆಂಡ್ ಇಯರ್ ವಿ ಹಾವ್ ನಾಟ್ ಸ್ಟಾರ್ಟೆಡ್.
Now you're,
ಇಲ್ಲ 1/6/2023 ಗೆ period.
you want to carry out fishing activities or no?
Till now, Malords, we will take a decision within 10 to 15 days. If water remained, we will, Malords, harvest the fishes. I told my client, this is impermissible under law, and I explained what are the.
If you want to harvest, then you have to pay
ಇಲ್ಲ,
the money.
ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ 1/6/2023 ಇಂದ ಪೀರಿಯಡ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಟೆಂಡರ್ ಕಾಲ್ ಆಫ್ ಫಾರ್ ಮಾಡಿದ್ದೆ 1/1/2024 ಗೆ. ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ ಕೂಡ ನಮ್ಗೆ ವರ್ಕ್ ಆರ್ಡರ್ ಈಗೂ ಕೂಡ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. 10 lakh rupees we deposited on in the month of January, Malords.
Interim order earlier granted is extended till next date.
ಇಲ್ಲ, I will.
Kalaburagi ಎಲ್ಲ backdated tender ಎಲ್ಲ.
ಅದು 6 months backdated tender was allotted.
Not carrying out work on time ಅಷ್ಟೇ.
First door matter, serial number 8, Sri Liaquat Farid Ustad, Sri Siddharama Basaraj.
Hearing for petitioner, my lord.
Yes.
What challenged that the proceedings, EP proceedings, they have challenged that particularly that order. EP is filed in the year 2020. Till they have not deposited the amount.
Now they are willing to pay 15 lakh is the claim. 5 lakhs they are willing to give you in 3 weeks time.
19 lakh rupees is there, 19 lakh.
19.
19. And moreover, the respondent company has initiated the proceedings under surface.
ಆಯ್ತಪ್ಪ 19 ತಾನೇ ಬರ್ಬೇಕು ನಿಮ್ಗೆ.
ಅಲ್ಲ, even if it is stayed, ಆ proceedings ಚಾಲು ಇರ್ತದೆ. It is EP filed under the, please my lords.
19 ಎಷ್ಟು ದಿನದಲ್ಲಿ ಕೊಟ್ರೆ ಅವ್ರು ಒಪ್ತೀರಾ ನೀವು?
ಅವರು ಫುಲ್ ಅಂಡ್ ಫೈನಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಸಲುವಾಗಿ 16 lakh rupees ಆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಅಷ್ಟು ವೇವ್ ಅಪ್ ಮಾಡುವಾಗ ಐ ಹ್ಯಾವ್ ಟೇಕನ್ ದಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್, ಅಷ್ಟು ವೇವ್ ಅಪ್ ಮಾಡಾಗ
ಎಷ್ಟು ನಿಮ್ಮ ಆಫರ್ ಏನ್ ಹೇಳಿ?
ಅಲ್ಲ, ಒಂದ್ ಡೇಟ್ ಕೊಟ್ರೆ ನೆಕ್ಸ್ಟ್ 2 weeks
ಅದುವರೆಗೂ ಇಷ್ಟೇ ಮಾಡ್ತೀವಿ, ಇವತ್ತೇ ಮುಗಿಸಿ ಅಂತ.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಡಿಪಾಸಿಟ್ 50%. 50% of the award amount, my lords. Arbitration.
He wants 3 weeks to deposit 5 lakhs.
Yes, please.
To pay 5 lakhs.
EP proceedings 4 ವರ್ಷ ಆಯ್ತು, my lords.
ಅದಕ್ಕೆ ಇವಾಗ ಬಂದಿರೋದು
ಡಿಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ. ಈಗ ಅದು ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆಗಿದೆ ಕೋರ್ಟಿಗೆ.
ಅದಕ್ಕೆ ಇವಾಗ ಬಂದಿರೋದು. ಸೊ ಇವಾಗ ನೀವು ಬಂದವಾಗ ದುಡ್ಡು ಇಸ್ಕೊಂಡ್ರೆ you will get the money.
My lord, subject to deposit, stay may be granted. 50% of the award amount.
ಯಾವಾಗ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಪ್ಪ?
After 3 weeks, minutes.
Before 3 weeks ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
5 lakhs minutes.
5 lakhs ಯಾವತ್ತು ಮಾಡ್ತೀರಾ? Date ಹೇಳಿ.
After 1 week, minutes.
After 1 week. So you will deposit 5 lakhs by 7th October.
Yes, minutes.
Yes.
9th October. Learned counsel for the petitioner submit that due to financial stringency, the amounts could not be paid to the respondent.
Yes.
However, the petitioner is agreeable to settle the entire dues of the respondent by making payment of a sum of rupees 16,000,000, 0,000,000. Counsel for respondent seeks for a short accommodation to get instructions from his client, from the respondent, as to whether the respondent is willing to settle at that figure or any other figure. Counsel for the petitioner, in order to establish his bona fides, submit that a sum of rupees 5,00,000,000 would be deposited by 9th, would be paid to the respondent by 9th October 2024. In that view of the matter, the operation of the order dated 27/7/2024 passed by the District and Session Judge Raichur in execution number 39 of 2020 is stayed till the next date of hearing. Needless to say, if the aforesaid amount of rupees 5,00,000,000 is not paid to respondent by 9/10/2024, the interim order will stand automatically vacated.
Please.
Relist on
With permission, my lords.
21st October 24.
Permission, ಇದು stay ಕೊಟ್ರು surface act ನಾಗ one more proceedings is taken place.
ಅದು ಅವ್ರು ಬರ್ತಾರೆ, ನೀವ್ ಯಾಕೆ
ಅದೇ.
ಅವ್ರಿಗೆ ಹೇಳ್ತೀರ? ಬರ್ತಾರೆ ಅದಕ್ಕೆ.
Please,
ಅಲ್ಲೊಂದು 5 ಲಕ್ಷ ಬರುತ್ತೆ.
Please, please.
cell number 9, Sri Santosh Hanmantrao.
So on last date of hearing on 25/9/2024 minutes, the Honorable Court directed the government to verify whether the elections to the Gram Panchayats in the Hulsur Taluk have been completed or not.
Yes, madam.
In few panchayat elections were held, in the month of September it were held. And I'm filing statement of objection.
How many panchayats it's been completed?
That's as per my,
It's stated 3 to 4. They have not specified the names of the panchayat.
only
Details
4
ಕೊಡ್ಬೇಕಲ್ಲ.
elections to only 4 panchayats has been completed minutes. But the
4 out of
4 out of 7 minutes.
more than majority.
But in the respondent number 7, no, still till today, a calendar of events has been not issued. Already the petitioners have submitted the representation
Is
also.
that reservation is to be on taluka wise, district wise, state wise.
As per their say,
Panchayat
the
wise.
taluka wise, but there is repetition minutes. Kindly see page 6 minutes of the petition.
It will be subject to the result of the investor.
Otherwise,
And SCGP has filed a statement of objections,
in-
which is taken on
similar
record.
matter,
Copy thereof has been served on the counsel for the petitioner. Submission is that elections to 4 gram panchayats out of 7
still
panchayats.
calendar of events has been not issued. But
4 gram panchayats
in
out of
similar
7
matter
gram
minutes-
panchayats has already been held. And any order passed in the present matter would have a bearing on all the gram panchayats in the said taluka. In that view of the matter, making the election subject to the result of the writ petition, relist on
That's one submission minutes.
28th October for the petitioner to file rejoinder, if any, to the
At least
state.
them, at least consider the representation of the petitioner.
ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತಪ್ಪ? ಆಲ್ರೆಡಿ ಇದಾಗೋಗಿದೆ. ಅದಕ್ಕೆ ಯಾವ್ದಾದ್ರು ಒಂದು ಮ್ಯಾಟರ್ ಫುಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು. ಇದು ಎಲೆಕ್ಷನ್ ಆಗಿದೆ, ವಿಡ್ರಾ ಮಾಡಿ ಹೋಗ್ಬಿಡ್ತೀರಾ, ಅಲ್ಲೇ ಮುಗ್ದೋಗುತ್ತೆ. You have to address arguments, get a order which will be enforced for next election. You come late after elections, then nothing can be done. ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಅದು? ಸಸ್ಟೈನ್ ಮಾಡ್ಬೇಕಿದು.
Cell number 31, Sri Veerashetty B.
Annexure EML land reforms tribunal order challenge ಮಾಡಿದ್ರು.
Learned AGA is directed to accept notice for respond number 1 and 2. Shri VK Naik directed to accept notice for respond number 3. Shri RS Siddhapurkar is directed to accept notice for respond number 4 and 9. Shri Chaitanya Kumar Chandriki is directed to accept notice for respond number 5. Shri B. Veema Shankar is directed to accept notice for respond number 6 and 7. Shri Gaurish S. Kashimpur is directed to accept notice for respond number 11. Shri Shivasharana Reddy is directed to accept notice for respond number 12. Shri Arun Kumar Amargowda Gundappa is directed to accept notice for respond number 8. Counsel for the petitioner, he is permitted to serve copy of the above petition along with annexes on the said counsels. 1, 2, 3, 4, 5, 6, 7, 8, 9. 10 no served. Notice to respond number 10 is dispensed with since respond number 10 had not appeared in WP number 207754 of 2017 despite service of notice. Relist on 28th October at 2:30 PM. There seems to be substance. It could not have been infructuous.
Yes, yes.
In this order cannot be infructuous.
ಹೌದು
No mistake agide.
ಹೌದೌದು.
Like that service admiral will have to allow it.
Seal number 42. See, Prakash Jadhav.
So Jadhav. None appears for the petitioner. Learned Additional Advocate General submits that the translation of the judgment of the Honorable Apex Court in Shakti Vahini's case has been forwarded to all the concerned officers and training is being provided to the police personnel as also the revenue officers, which will be completed in 2 months' time. His submission is placed on record. Relist on 17th December for reporting further progress insofar as the training is concerned.
Yes.
For B group matter. Seal number 32, Arjun. Seal number 33, Sri Manvendra Reddy.
Petitioner is challenging the endorsement issued by the Assistant Commissioner, my lords, quite annexure N, my lords, at page number 80, my lords, wherein the Assistant Commissioner has issued endorsement stating that it's a Waqf property, my lords. Though, my lords, as per annexure A, my lords, earlier the land was vested with the state, my lords. Subsequently, my lords, the writ petition was filed, my lords, challenging the order of the.
Yes, Mr. Malli Patil, ready?
Yes, ma'am.
Yes. Here's the idea.
Yes, ma'am. Yes, ma'am. It's ordered.
Good.
As per the subsequently, my lords, a writ petition was filed by one Harun Syed Baban Saab, my lords, challenging the order of the annexure A, my lords, dated 1981, my lords, 18th October 1981, my lords. That writ petition was allowed and matter was remitted back for fresh consideration, my lords. Thereafter, my lords, notices were issued, my lords, and annexure A1 was passed, my lords. It is annexed along with the amended petition, my lords. Annexure A1 is the grant order issued in favor of the father of the petitioner, my lords, dated 5/12/1988, my lords. This honorable court, my lords, had raised a query as to what was the order of the writ petition, my lords, and records were called for, my lords. And the records are also available before this honorable court. The endorsement issued by the Assistant Commissioner only when, my lords, when the petitioner gave an application to change the entries in column number 7 state from Inam to the Patta land, my lords. At that time, Tashildar Muskie, my lords, have given a report that this is a suitable case wherein the endorsement can be issued, my lords. When the file was transferred to Assistant Commissioner, my lords, Assistant Commissioner, my lords, without looking into the records, my lords, had passed this particular order at annexure N, my lords, page number 80.
The land tribunal had granted it under which act?
Lords, the order is not reflecting in there, my lord, because it is in the order sheet which has been mentioned as per annexure A1.
A1 ellide.
My lords, along with the amended petition, amendment
petition
application, my lords, the annexure A1 is enclosed.
Amendment application idea.
Yes, my lords. Because that order was reflected in the order sheet.
When was the amended application filed?
25th May 2023, my lords, application is filed.
May 23.
Typed copy is at page number 12, my lords.
Certified copy. Like this under the form 7.
Yes, my lords. Yes, my lords.
Illa. Is occupant Karnataka Certain Inams Abolition Act. KCIA. Page 10.
Please.
Yes, Mr. Mali Patil.
In submission, my lord, before reasonable the English writ petition, my lord, only in the respect of survey number 22 is concerned, my lord. My lord, the annexure A is concerned, my lord, kindly see, my lord, annexure A. The land tribunal has passed order on 18/10/2081, my lord. Kindly see page number 19. Annexure
19
A.
of the petition.
Yes, my lord. Page number 19. Typed copy, my lord.
Yes.
Out this, it is a scene survey number here 226 is a Pata land survey number 207 of the same extent is Inam land. Hence, if we admitted has been decided in a 1997 in favor of the tenant. Hence, the application of the survey number is rejected. As for survey number 22, the case was decided against the board, with the decided the case as per the High Court order. There is no any reference, my lord, in this order. The claim of the Waqf board has rejected at the writ petition is not mentioned, my lord. And moreover, my lord, the High Court order, herein is already decided the case can be coupled and other order passed. The applicant's name does not appear in the ROR and his father, brother and Syed Kotwal appear, and said Syed Kotwal is died and has not filed the application. Muhammad Beg is present and they stated that the applicant stayed at Bijapur and does not cultivate that land. Hence, the application of this survey number is rejected and his land is vested the government. My lord, the father of the petitioner is application is already rejected by the land tribunal. My learned friend has taken the contention, my lord. This order was challenged before the High Court and High Court has allowed the writ petition. That order is not produced, my lord. This honorable court has called for the record. My learned friend, my lord, has taken the contention. He is also filed the writ petition before the High Court. Kindly see, my lord, on the basis of the after remanding the matter by the High Court to the land tribunal, annexure A1. Kindly see, my lord, annexure A1 produced by the my learned friend along with the amended plan. In this order, my lord, is passed 5/12/1998. Idರಲ್ಲಿ the land tribunal order was referred, my lord. In respect of survey number 8 of Mudugalli tenancy right is already been confirmed by land tribunal order dated 21/8/1976. My lord, there is no any reference the order passed by 18/10/2021 in annexure A1, my lord.
Why is that required? It is after remand it is being taken
No,
up.
no. My submission before this honorable court, my lord, before issuing the the land tribunal order, my lord, this property has already Waqf property in 1974, my lord. And moreover, my lord, in this in the land tribunal order, my lord, earlier, my lord, I am not a party before the land tribunal. Under section 18, under section 90 of the Waqf Act, my lord, kindly see, my lord, Waqf Act 1990, under section 90. Yeah?
No, the problem is that this
Yes.
is an order passed in the year 1988 and their names have been entered into in all the revenue records.
Kindly see, my lord.
Occupancy rights have been granted, certificate has been issued, they have been in possession,
That is
cultivating the land. You have been sitting quiet from that time.
No. And kindly see, my lord, the
ಮತ್ತೆ
application was.
20, 30, 40 ವರ್ಷ ಆದ್ಮೇಲೆ notification ತಗೊಂಡ್ ಬರ್ತೀರಾ.
Kindly see, my lord, annexure J, application was filed by the applicant before the Tahsildar. ಯಾವಾಗ 28/12/2021. Kindly see, my lord, annexure J.
21.
ಹೌದು.
Order passed in 1988.
But the report submitted by the revenue officer, kindly see annexure K, the reference made in the Tahsildar.
Didn't you know that it was? Didn't you know that it was your property for last 40 years? And you
Yes,
just kept quiet, allowed everybody to use the property, trade on the property, sell the property, purchase the property.
In submission, my lord, the entire record, kindly see, my lord, entire record produced by the rent. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, ಸೈಯದ್ ಕೊತ್ವಾಲ್ is the ಮುತವಲಿ of the said ದರ್ಗಾ.
ಇರಬಹುದು.
ಅಲ್ಲ,
What is
ಯಾಕಂದ್ರೆ
the limitation?
ಅಲ್ಲ,
There's a
ಒಂದು
limitation
submission
period even for the government, 30 years.
ಅಲ್ಲ, ಮುತವಲಿ cannot
ನಿಮ್ಗೆ
claim
12 years ಅಷ್ಟೇ.
My submission before this honorable court, my lord, entire record, I have seen the entire record, my lord. The Sayyid Kotwal is the Mutawali of the Dargah. Mutawali cannot claim as a occupancy right before the land tribunal. My lord, the Mutawali is appointed by the Waqf board on the only on the maintaining the property.
Really, where is Syed Kotwal?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್.
Syed Buban Saab idu.
ಅವ್ರ ಫಾದರ್
Syed
ಸೈಯದ್ ಕೊತ್ವಾಲ್. My lord, para number 2 of the petition, kindly see, my lord, para number 2 of the
Son of
petition.
Habib Saab.
Habib Saab,
Syed
kindly para.
Buban Saab, son of Habib Saab. Syed Kotwal Allah.
Hello, kindly see para number 2 of the petition. The contention of the petitioner. The land tribunal granted the occupancy right, survey number 22, 9 acres 34, so and so, in favor of the father of the petitioner by name Syed Babanna, son of Syed Habib Saab alias Syed Kotwal.
And where do you have any document to show Syed Kotwal was the Mutawali?
My lord, the land record, record ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಬಂದಿದೆ. Whatever this honorable court has called for the record.
ನಿಮ್ಮ notification ಇರ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, that I will verify and I will produce it, my lord. If the Syed Kotwal is the Mutawali, my lord, I will once again I will verify it. I will produce the next date of hearing whether it is a Mutawali or not.
You are making a categorical submission that is a Mutawali. You cannot claim.
Yes,
I'll verify ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
ಅಲ್ಲ, ಹಂಗಲ್ಲ, ನಾನು ಇದೆ, ಬಟ್ ಅದರಲ್ಲಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ನಾನು ನೋಡಿದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. ಮೈ ಲಾರ್ಡ್, ದಿ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಈಸ್ ಆಲ್ಸೋ ಸ್ಪೆಸಿಫಿಕಲಿ ಆಸ್ ಟೇಕನ್ ದಿ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸೈಯದ್ ಕೊತ್ವಾಲ್ ಇಸ್ ದಿ ಮುತವಲಿ ಆಫ್ ದಿ ದರ್ಗಾ ಅಂತ.
ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸಿ? ಡಾಕ್ಯುಮೆಂಟ್
ಅಲ್ಲ, ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ರೆಕಾರ್ಡ್ ತರಿಸಿದ್ರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇದೆ ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ. ಮೈ ಲಾರ್ಡ್, ದಟ್ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್, ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಲಾರ್ಡ್ ದಿ ರೆಕಾರ್ಡ್, ಮೈ ಲಾರ್ಡ್, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ. Otherwise, my lord, I will produce them.
ಈಸು ದಣ್ಣೆ ತಪ್ಪಿಸ್ಕೊಳ್ಬೇಕಷ್ಟೇ.
ಆ ತರ ಹೇಳಿಲ್ಲ.
You are sleeping over your rights, unfortunately. You had probably a right.
My lord, before issuing of
you go to the Tahsildar, show a notification, the Tahsildar directs your entry and your name gets entered.
Earlier, my lord,
who have been in possession, occupation, having purchased, their name is deleted. That's not the right way to do things. If you want to exercise rights over the property, you have to do it in the right way.
My lord,
go to the Tahsildar and get a administrative order. It's not even a quasi-judicial notice.
ಅಲ್ಲ, that is my lord subsequently in 2017 ಇಂದ ಆಗಿರೋದು ಅದು. But lord, this matter my lord, the
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ 2021
Even after remand also, my lords, the work board were already intimated.
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲಿದೆ, ಎಲ್ಲಿ ನೋಡ್ಬೇಕು ಹೇಳಿ.
ಅಲ್ಲ, 1 second my lord, one letter my lord.
Page number 43, 44 and 45, green page, green pen in the mention ಮಾಡಿದ right
not-
corner, my lords.
That is the final order.
No, it's 42, 42, 43, my lords.
That is not what he is speaking of. He is
Please.
speaking of some letter.
Please,
He is not here. He wants to produce it at a later point of time, so the matter will get adjourned today.
ಆ ತರ ಏನಿಲ್ಲ.
ಅಷ್ಟೇ.
Otherwise, my
ಮತ್ತೆ
lord,
ಹೇಳಿ, ಎಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ, ಏನಾದ್ರು ಹೇಳಿ ನೋಡಕ್ಕೆ. ಏನು ಹೇಳಲ್ಲ, ಬರೀ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಂದ್ರೆ.
ಅಲ್ಲ, my submission before this honorable court, my lord. In year 1981 order, my lord, the petitioner father, my lord, has not filed the application, my lord. But specifically, it is also taken the land tribunal order, my lord, is not filed the application. Therefore, the
Now
in
we
respect
are
of
concerned with 1988 order.
even after suffering of the order at 1981, my lords, they have not challenged in the writ petition, my lords. Even after remand of the writ petition, my lords, notices were issued to the work board, they have appeared in, my lords. Even then, they have not appeared before the land tribunal in the year 1988, my lords. Now, my lords, by virtue of the endorsement issued by annexure N, my lords, now they are taking advantage, my lords. And along with the memo also, my lords, I have submitted some documents, my lords.
There is an order passed that we see here. The Waqf committee does not personally cultivate land. It is not entitled to be registered as occupant. Therefore, the same is rejected.
Yes,
But the land being religious inam, land has vested in the state government as on 1/3/1974. As there are no genuine claims of tenancy or for occupancy right, the land is hereby taken into government supervision. And the same may be disposed under section 77 of the Karnataka Land Reforms Act 1974. Is the order which is passed.
my lord, one letter is there.
6/8/1981, when you are a party to it.
ಅಲ್ಲ, one letter, my lord, 2788, my lord, one letter was given to the assistant, to the request to Syed Baba, son of Syed Abib Saab Mutawali Majid, my lord, letter dated 27.
ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. Those are not relevant for the reason that
ಅಲ್ಲ,
your own application filed on 19/8/1981 has been rejected.
but ಅಲ್ಲ ಮಾಡಿ
Application reject ಆದ್ಮೇಲೆ how can you?
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಇನ್ ಆಫ್ ದಿ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಂತ there is no any reference in the order. Kindly see my lord, page number 20.
That's okay. You may be right. Okay, reference ಇಲ್ಲ ಅಂತ. But now ನೀವು ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ನೋಡಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ಈ ಆರ್ಡರ್ ನೀವು ನಮ್ಗೆ ಹೇಳಲಿಲ್ಲ.
ನಾನು ಅದನ್ನ ನೋಡಿದೀನಿ, ಬಟ್
ತಿರುಗಿಸಿದಕ್ಕೆ ಅದೇ ಸಿಕ್ತು ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ.
ಅಲ್ಲ, ಬಟ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೈಲಿ ಸಿಮಲ್ಲ 27/2008.
We are looking for anything 19/8/1981.
Yes, madam.
One application form 1 filed by the Secretary District Waqf Committee Raichur. He has appeared. He states that the land in survey number 922 of so and so is religious inam land attached to the Ashur Khana of Jakkarnadu. This is a property of the District Waqf Committee as per the Gazette notification of 75, but he admits the board does not personally cultivate the land. He is not in position to say as to who is actually cultivating at present. On perusal of the record, it is seen that one Sri Magya, son of Pirya Lambani, had filed Form 7 in respect of this land, and the same is rejected by the tribunal in its order dated 17/5/77. There are no other claims before the tribunal. As the Waqf committee does not personally cultivate the land, it is not entitled to be registered as occupant. Therefore, the same is rejected. But the land being religious inam land is vested in the state government as on 1/3/74. As there are no genuine claims of tenancy or for occupancy right, the land is hereby taken into government supervision, and the same may be disposed under section 77 of the Karnataka Land Reforms Act.
My submission, my
Your
lord.
claim is rejected.
ಅಲ್ಲ,
You don't bring any of these to the notice of the Tahsildar. You just go and show your notification.
kindly see my lord,
This is an abuse of the process of law.
but that notification was issued by the work board, my lord, on the basis of this under section 4 and 5 of the after conducting of the survey.
ಹೌದಪ್ಪ, ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ. It has been rejected by the tribunal. You don't challenge it. And then you show the notification.
ಈಗ now, my lord, whatever the petitioner has taken the contention, my lord, his possession is continued on the basis of the order of the land tribunal 1981 antane the revenue officer and the other officer has submitted the report annexure K and L, not on the land tribunal order 5/12/1988.
You show you were right.
But my submission, my lord, is now, my lord,
After your rejection of the claim, you establish you were right.
ಈಗ
ಅಷ್ಟು ತೋರಿಸಿ ಇದನ್ನೇನಾದ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ? Any
ಈಗ
order
now, my
passed
lord,
on this order?
but num gazette notification before grant, my lord, in 1974. Agreed party, my lord, first of all, my lord, state government has no right to grant the occupancy right in favor from the Waqf property, my lord. As per
That
the
is being considered an order passed which you are not, you know, or you are feigning ignorance, ಗೊತ್ತಿಲ್ಲ.
ಈಗ now, my lord, as per the
Rejected.
yes,
Don't trouble people who are in occupation, who have spent their hard-earned money in purchasing the property.
our purchase of family members is also, my lord, party said as per the document.
ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಬರ್ತಾ ಇದಾವೆ ಇಲ್ಲಿ.
Sir, correct. ಇಲ್ಲ ಬಟ್ one mistake, my lord, in you have the gazette notification, my lord, ನಾವು ಪಾಣಿ ಒಳಗೆ ಎಂಟ್ರಿ ಮಾಡಿಬಿಟ್ಟಿದ್ರೆ ಯಾವ್ದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇರ್ತಿಲ್ಲ. Therefore, my lord, I am not entering the record of the Waqf board, my lord, there is a problem, my lord. After issuing of gazette notification, I am entering the name in the Waqf board in the record of right, my lord, there is no any problem. ಈ ಎಂಟ್ರಿ ಮಾಡಲಾರದಕ್ಕೆ ಇವೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇರೋದು.
ಏನ್ ಮಾಡಿ 75 ಇಂದ ಇದುವರೆಗೂ?
That is a mere mistake, my lord. After issuing of gazette notification, I have entered the name of the Waqf board in the column number in the RTC, my lord. That is this problem that not arise.
Petitioner is before this court seeking for the following reliefs. The petitioner claims that the land tribunal Linksugar that their land in survey number 22, measuring 9 acres 34 guntas at Jakiramadu of Linksugar Taluk, Raichur district, was notified as Waqf property in the year 1974. However, while order dated 6/8/1981, a claim made by the Secretary District Waqf Committee for entry of the name of the Waqf Committee as in the record of rights was rejected on the ground that the Waqf Committee was not personally cultivating the land and that the land being religious Inam land was vested in the state government as on 1/3/1974 and taken under supervision of the government for disposal under Section 77 of the Karnataka Land Reforms Act 1974, in pursuance of which an application has been filed by the predecessors of the petitioner, namely Syed Buban Saab, son of Habib Saab, in respect of survey number 207. Syed Nazim Saab, son of Habib Saab, in respect of survey number 22. Hamida B, wife of Syed Hassan Kotwal, in respect of survey number 85, was taken up for consideration. And the Land Tribunal, while its orders dated 18/10/1981, 5/12/1988, and an earlier order dated 21/8/1976, respectively in respect to the above petitions, had granted the land to the said persons and thereafter issued Form 2 in favor of the above said persons. Accordingly, the names of the aforesaid persons were entered into in the revenue records. A family settlement having occurred between the family members in the year 1999-2000, the land in survey number 22 came to the share of Syed Ahmad Kotwal, son of Syed Buban Kotwal, who is the husband of petition number 2, in the year 2015-16, the names of
Registered partition deed was it?
Syed Ahmad Kotwal and the first petitioner was entered into in the record of rights. The said Razia Begum, the first petitioner Razia Begum being his sister, there was a partition which was entered into, and the land to an extent of 5 acres, 32 guntas was allotted to the first petitioner, and the balance land of 5 acres, 22 guntas continued with the husband of the second petitioner, who expired on 10/9/2020, and subsequently the name of the second petitioner was entered into in the revenue records. The entry in the revenue records having continued as Inam land, a representation was made for change of entry from Inam to Patta land on 29/12/2021. The revenue inspector conducted a Mazar and drew up a Panchanama and recommended and submitted the same to the Tahsildar, who accepted the said report and recommended the change of entry of Inam land to Patta land by submitting a report to the Assistant Commissioner on 5/5/2022. The Assistant Commissioner, respond number
Respond number 3, my lords.
while order dated 18/5/2022, taking into consideration that there was a notification issued notifying the aforesaid land as Waqf land, issued an endorsement directing the entry of the name of the Waqf on 18/5/2022, which is what is under challenge in the present proceedings. The submission of Shri Narendra Reddy, learned counsel for the petitioner, is that even though the land was notified as a Waqf land in the year 1974 by order dated 6/8/1981, the said land in survey number 22 was taken under government supervision and distributed in terms of section 77 of the Karnataka Land Reforms Act, the beneficiary thereof being the predecessors of the petitioner. Hence, once the government had taken the same under supervision, under its supervision, the question of the Waqf claiming any right under the notification would not arise. And on that ground, we submit that the writ petition is required to be allowed. The endorsement issued by the Assistant Commissioner on 18/5/2022 is required to be rejected. The recommendation made by the Tahsildar be accepted. Names of the petitioner be continued in the record of rights, and the nature of land be changed from Inam to Patta land. Shri P.S. Malipati, learned counsel for the Waqf board, would submit that once a notification has been issued in the year 1974, the land became that of the Waqf, and no person can claim any right in respect thereto, let alone by way of any of the transactions which have been entered into subsequently. His submission is that the gazette notification confers and confirms title on the Waqf board, which cannot be disturbed by anyone, much less the petitioner who has claimed a right on account of the order of the land tribunal. heard so and so, and on that basis submit that the above petition is required to be dismissed. Heard Shri Narendra M. Reddy, learned counsel for the petitioner, Shri P.S. Malipati, learned counsel for respondent number 7, peruse papers. In the present case, there is no dispute as regards the land being Waqf land, by being notified as a Waqf land in the year 1974. The perusal of the original record which have been secured by the learned SCGP would indicate that there is an order passed on 6/8/1981 rejecting the request of the secretary of the Waqf board, Waqf committee, to enter the name of the Waqf committee in the revenue records. And it has been further held in the said order that since the Waqf committee was not cultivating the land personally, and the land being a religious inam land, had stood vested with the state government on 1/3/1974. And it is in that background that the land was taken under the supervision of the government for allotment to be made in terms of Section 77 of the Karnataka Land Reforms Act. The claim of the Waqf board having been rejected in the year 1981, neither the Waqf committee, neither the Waqf committee or the Waqf board challenged the said order.
Waqf committee, my lord. Waqf board is not a party.
ನೀವು ಯಾವಾಗ ಬಂದ್ರೋ ಅವ್ರು ಯಾವಾಗಿದ್ರೋ has challenged the said order at any given point of time till now, the said order having attained finality. During an application was filed by the Waqf board only in the year 2021 to enter the name of the Waqf board in the revenue records. From the year 1974 till the year 2021, for nearly 50 years, neither the Waqf nor the Waqf committee or the Waqf board took any steps to cause the entry of the name of the Waqf committee or Waqf board in the revenue records. Furthermore, as held by the land tribunal, the Waqf or the Waqf committee was not in possession or personal cultivation of the land way back in the year 1981, when the land was taken under the government supervision. The land having been taken under government supervision, applications having been filed by the predecessors of the petitioner, the said application was considered and the land granted to the predecessor of the petitioner, which has subsequently flown to the petitioners by succession. Though there is no third-party rights which have been created, the fact remains that the petitioner and petitioner's family have enjoyed the said property from the year 1988. Their names are found in the record of rights from the year 1988. They have been making payment of taxes in relation thereto and have been enjoying all ownership rights relating thereto, albeit as a inam land. And it is only when they approach the jurisdiction authorities to change the character of land from inam land to patta land that this aspect opened up. And the Assistant Commissioner, by referring to the notification, had directed the entry of the name of the Waqf board in the revenue records. I am of the considered opinion that merely because there is a gazette notification issued in the year 1974, the Waqf board cannot claim, the Waqf committee or the Waqf board cannot claim a right in perpetuity against anyone without having preserved the rights in a manner known to law. For the last 50 years, no action having been taken by the Waqf committee or the Waqf board, and the said land having been granted to the predecessor of the petitioner in the year 1988, which has continued undisturbed, the Assistant Commissioner could not have, without considering the rights of the petitioners and their predecessors, caused the entry of the Waqf board in the revenue records in the year 2021 on the basis of an application filed by the Waqf board in the year 2021 after a gap of 50 years, nearly 50 years after the gazette notification. Rights having been crystallized and fructified in favor of the petitioners, no steps having been taken by the Waqf committee or Waqf board within the period of limitation as prescribed to assert the rights of the Waqf committee or Waqf board in respect of the property covered under survey number 22 Jakaremadu village, Maski Taluk, Raichur district. The reliance placed only on a notification to insert the name of the Waqf board is not permissible, and as such, the assistant commissioner fell into grave error by issuing the impugned endorsement. As such, I pass the following order. Writ petition is allowed. A certiorari is issued. The endorsement issued by respondent number 3, Assistant Commissioner White so and so on 18/5/2022 at Annexure N is hereby quashed. Respondent number 3 is directed to consider the report of respondent number 4, Tahsildar at Annexure M, and direct the change of entries in column number 6 from Inam to Patta land as recommended by the Tahsildar within a period of 30 days from the date of receipt of copy of this order. Respondent number 4 is also directed to delete the name of the Waqf board from the revenue entries.
Obliged.
Seal number 34, 35, Arjun. Seal number 36, Sri A.M. Biradar, Sri P.S. Mali Patil.
None appears the petitioner released on 5th
I'm
November.
appealing for the.
Petitioner illa.
I'll run the papers.
Interim order earlier granted is extended.
Seal number 36, Arjun. Seal number 37, Sri Ravi B. Patil.
Last day ella hard working ide. Yen you again.
ಕೇಳಿದ್ದೇದು ಏನಿಲ್ಲ ಬೆಳಗ್ಗೆ ಸಿವಿಲ್ ಸೂಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಪೆಂಡಿಂಗ್ ಇಟ್ ಇಸ್
ಇಲ್ಲ ಇಲ್ಲ ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡಕ್ಕೆ ಆಲ್ರೆಡಿ 23 ರೂಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಒಂದು ವರ್ಷ ಮೇಲಾಯ್ತು ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Both the councils have filed, each of the councils for the petition and respond have filed memo along with certain documents. The same are taken on record, released on.
Excess way has been blocked, my lord. ನಮ್ಮ ಶಾಪ್ಗೆ ಹೋಗಕ್ಕೆ ದಾರಿನೇ ಇಲ್ಲ.
21st October.
Seal number 38, Sri Gopalakrishna B. Yadav, Sri M. Tirumalesh.
Appearing for the petitioner.
Mr. Tirumalesh. Yes.
Yeah.
Yes, Mr. Tirumalesh.
Serial number 38.3 may be taken up first, my lord. Permission.
All of them have to be remanded ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ.
No, my lord. Serial number 38.3. The petitioner is a cooperative society. And
First thing is
proceedings are
that-
being.
My lords, the first thing is that 38.1 and 2 are different matters. 38.3 is different matter. That may kindly be clarified.
Now this has to be heard or remanded?
No,
It has to be heard.
It has to be heard.
Heard.
It has to be heard.
Then not today. No time now
Please,
at
my lord.
4:30.
Yes.
Now they are different, 38.1.
38.3
are connected, which is not
may
connected.
be delinked. 38.1 and 38.2 are one batch matters. And 38.3 is a different matter. 38.3 may be delinked.
Dealing 38.3 and release
Yes, my lord.
38.3 on 22nd, release 38 on 23rd. So that will let it come on
Obliged.
different dates.
Obliged, my lord.
Interim order. earlier
Interim
granted.
order may be
Yes, extended.
obliged. Obliged.
Seal number 39, Sri Mali Patil Avinash, Sri Arun Kumar Amargundappa.
Here for the petitioner.
Yes. In fact, in.
ಶುರು ಆಗಿಲ್ಲ ಅಲ್ಲ?
My lord, either this is
They not
relating-
heard you.
Yes, yes, ma'am. It is not.
It is relating to tender, my lord, your lordship is pleased, my lord, pass order on 6/8/2024.
6/8/2024, directed to obtain instruction and make his submission as to on what basis Mr. Sharp Watch Investigation Security Services Limited have been held to be eligible in the tender process. My lord, his technical bid was rejected by the my lord, committee.
System.
However, my lord, CEO allows my lord, his my lord, financial bids to be opened without any authority under law, my lord. Based on that direction, they open the financial bid and hold him as my lord, L1. And now, my lord, he has been declared as my lord, the lowest bidder.
My lord, it was
My lord,
prior to my lord, my impediment.
Technical bid, my lord, he has not
Government
qualified the
advocate was
technical-
directed to ascertain. However, my lord, after my impediment and I have instructions that a work order is already issued and agreement is also entered. And I have also checklist to show that, my lord, this
Appliances have been made.
yes.
Annexure C,
You
my lord,
filed
this
your
himself says,
objections?
my lord, the
No, my lord.
technical bid is
First
rejected.
time after impleading, it is coming.
They are
fact.
proceeding with, my lord, the issuance of all documents, my lord, pending consideration of this writ petition. Let them, my lord, at least hold the matter, my lord.
Work has to happen.
My lord,
if you
when
succeed.
he has not qualified the technical bid itself, he doesn't even hold the license for, my lord, running the.
It will be considered, let them file their objections. ನೀವ್ ಹೇಳಿದೆಲ್ಲ ಒಪ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು. ಬೇರೆ ಯಾರಿಗೂ ಟೈಮ್ ಕೊಡ್ಕೊಡ್ದು. ನೀವು ಕೇಳ್ದಾಗ ಟೈಮ್ ಕೊಡ್ಬೇಕು.
Immediately after reopening.
Arun Kumar Amargundappa, learned counsel for respond 2 and 5 seeks fund is granted 2 weeks time to file a statement of objection. Objections, if any, by
Immediately after reopening.
15th October, released on 21st October.
Oblash.
Great. ಬೇರೆ ಅವ್ರದ್ದು ಕೇಳ್ಬೇಕ್ರಿ.
40, that liquor shop matter, your lordship.
ಯಾವ್ದು?
License of liquor shop, serial number 40.
40.
The Sudarshan was directed that they said that they have issued notice as per the agreement to me, but my submission is that no, there is
Somebody
no.
has taken adjournment.
I have not.
AG ಎತ್ಕೊಂಡು.
No, it's no
ಇದಕ್ಕೇನ್
consent.
ಸಂಬಂಧ? MSI ಹೇಳ್ತಾನೆ.
Without notice, they have submitted.
Where is
My
Sudarshan?
apprehension is that they are ready to.
Where is Sudarshan? If Sudarshan
There,
is
your
we'll
lordship.
take
It was merely on the simple letter they want to shift my shop without any notice, without, as per the agreement, against the agreement, your lordship. And now there, if there is no any order of any coercive steps to be taken against that. That is the thing, your lordship.
Other side illalla, Mr. Jagirdar. And it's been adjourned in the morning.
Without notice, your lordship. They can.
1:30. We've been asking all of you, have you informed?
I
Have
was
you
there
informed?
because specifically by after mentioning 2 days before this matter was listed. So specifically date was given, your lordship.
7/11. And date change ಮಾಡಿ 14/10 ಗಾಕ. We'll have it on 14/10.
Meantime, they
11
may,
ಹೋಗಿತ್ತು.
meantime, if there is the interim order is not there, your lordship, for that
No
reason they
interim
will,
order.
no interim order that, for reason they may.
40. When the matter was not taken up in seriatim, learned counsel for the Sri Anantesh Jagidar, learned counsel for the petitioner submit that he was not informed about the mentioning of the matter for adjournment. His submission is that there is an urgent order required, interim order required, since there is a likelihood of the petitioner's outlet being shifted during the vacation. In that view of the matter, since petitioner had not been informed about the mentioning, the respondents are restrained from taking any precipitative steps to either stop the functioning of the petitioner's shop or shifting the petitioner's shop till the next date of hearing. Released on 14th October.
Much obliged.
Lord, in this case, my lord, it is disposed of on 24/4 for reporting compliance.
Yeah.
The daily order has not been uploaded. That is.
Upload once. Thank you, everybody.
Happy Dussehra.
Time.
ಬ್ಯಾಂಗ್ಳೂರ್ ಮ್ಯಾಟ್ರ್ ಬ್ಯಾಂಗ್ಳೂರ್ದಾಗ ಸಿಟ್ಟಿಂಗ್ ಇದ್ದಾಗ ನಮ್ದು ಒಂದು ಕಂಪ್ಲೈನ್ಸ್ ಇತ್ತು ಅಲ್ಲಿ ಯಾರಿಗೆ ಹೇಳ್ಬೇಕೇನಂತ ಸುಮ್ನೆ ಇಲ್ಲೇ ಹೇಳಿ ಅಂದ್ರೆ ಇಲ್ಲೇ ಸಿಟ್ಟಿಂಗ್ ಇದ್ದ ಕಂಪ್ಲೈನ್ಸ್ ಹೇಳಿದ್ರು VC ನಲ್ಲಿ ನಾನು 24/4 ಕಂಪ್ಲೈನ್ಸ್.
ಮೇಡಮ್ ಮೇಡಮ್
ಸರ್ ಹೇಳಿ.
ಇದು ಗೌರ್ಮೆಂಟ್
ಹೇಳಿ.
ಅಡ್ವೊಕೇಟರ್ ಒಂದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಇತ್ತಂತೆ,
ಹಾ,
ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಂತೆ. ಬೆಂಗಳೂರಲ್ಲಿ ಇಯರ್ ಆಗಿತ್ತಂತೆ ಮೇಡಮ್.
ನಂಬರ್
ಇದು
ಏನು ಸರ್?
ನಂಬರ್ WP 204862
ಕಲಬುರ್ಗಿ ಬೆಂಚ್
of 19
19 ಯಾವತ್ತ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಸರ್?
24/4/24 ಮೇಡಮ್.
24/4.
ಹಾ,
ಸರಿ ಸರ್, ಚೆಕ್
ಅದು
ಮಾಡಿ.
ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇಯರ್ ಆಗಿತ್ತಂತೆ ಮೇಡಮ್. ಡಿಸ್ಪೋಸಲ್
Okay,
ಆಗಿದೆ
okay.
ಅಂತೆ.
ಹಾ, ಸರಿ ಸರ್. ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ರಿಪೋರ್ಟಾ?
ಕಂಪ್ಲೇಂಟ್ಸ್ ಬಂದಿತ್ತಂತೆ, ಅದು ಅಪ್ಡೇಟ್ ಆಗಿಲ್ಲ ಅಂತ.
ಕಂಪ್ಲೇಂಟ್ಸ್
Okay,
ರಿಪೋರ್ಟ್ ಆಯ್ತು, ಕ್ಲೋಸ್
ಆಯ್ತು,
ಮಾಡಿದ್ದಾರೆ.
ಓಕೆ
ಓಕೆ ಓಕೆ,
ಓಕೆ.
ಚೆಕ್ ಮಾಡಿ. ಇಲ್ಲ, ಮೆನ್ಷನಿಂಗ್ ಅಂದ್ರೆ 230ಗೆ ತಗೊಂಡಿರ್ತಾರೆ. ಮೆನ್ಷನಿಂಗ್ 130ಗೆ
ಆಮೇಲೆ ಇದೊಂದು ಮ್ಯಾಟರ್ ಬರೀ ಏಜ್ ತೋರಿಸಿದ್ದಾರೆ. ಬರ್ಲೇ ಇಲ್ಲ.
ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಯಾರಿಗಾಗಿತ್ತು ಇವತ್ತು?
ಮೇಡಮ್
ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಯಾರಿಗಾಗಿತ್ತು?
SVH ಆಗಿತ್ತು ಮೇಡಮ್. ಶಿವಕುಮಾರ್ ಆಗಿದೆ.
ಶಿವಕುಮಾರ್ಗ? ಅವ್ರಿಗೆ ಹೇಳಿ ಟೈಪ್ ಮಾಡೋದು ಬೇಡ ಅಂತ, ನಾನು ಮಾಡ್ತೀನಿ.
ಆಯ್ತಾಯ್ತು, ಹೇಳಿದೀವಿ ಮೇಡಮ್.
ಹೇಳಿದೀರಾ? ಸರಿ ಸರ್,
ಹೇಳಿದೀವಿ.
ಆಯ್ತು. ಈಗಾಗಿರೋ ಡಿಸ್ಪೋಸಲ್ ಬೆಳಗ್ಗಿನ ಫೈಲ್ ಎರಡೂನು ಕಳಿಸ್ಕೊಟ್ಬಿಡಿ ಸರ್. ನಾನು ಅಲ್ಲಿ ಹೇಳ್ತೇನೆ ಅವ್ರಿಗೂನು.
10 ನಿಮಿಷ ಕಳಿಸ್ತೀವಿ.
ಬ್ಯಾಂಗ್ಳೂರ್ ಕಳಿಸ್ಬಿಡಿ. ಫೋಟೋ ಬೇಡ, ಬ್ಯಾಂಗ್ಳೂರ್ ಕಳಿಸ್ಬಿಡಿ. ಎರಡು
Okay, madam.
ಡಿಸ್ಪೋಸಲ್.
ಎಸ್ ಸರ್ ಮೇಡಮ್ ಕಳಿಸ್ಬೇಕಂತೆ ಮೇಡಮ್.
SR ಮೇಡಮ್ ನಿಂದು ಕಳಿಸ್ಬೇಕಾ? ಇಲ್ಲಿ ಬೇಡ, ನಂಗೆ ಫೋಟೋ ಕಳಿಸಿದ್ರೆ ಸಾಕು ಸರ್. ಎಲ್ಲೆಂದು ಬೆಳಗ್ಗೆದು ಇವಾಗ ಎರಡು ನನ್ಗೆ ಫೈಲ್ ಬೇಕು ಸರ್.
ಆಯ್ತು ಮೇಡಮ್.
ನಮ್ದು ಫೋಟೋ ಕಳಿಸ್ಬಿಡಿ ಸರ್.
ಆಯ್ತು ಮೇಡಮ್, ಕಳಿಸ್ತೀನಿ ಒಂದು 10 ನಿಮಿಷ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಇದು ಮೊನ್ನೆ ಆಗಿತ್ತಲ್ಲ ಮೇಡಮ್.
ಅಲಾಂಗ್ ವಿತ್ HCG ತೋರ್ಸ್ಬೇಕಲ್ಲ, ಬರೀ ಏಜ್ ಅಪಿಯರ್ ಆಗಕ್ ಬರಲ್ಲ. ನಾವು ಅಲಾಂಗ್ ವಿತ್ ಇದ್ರೆ ಅದು ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಹಾಕಿದ್ದೆ ನಾನು, ಕರೆಕ್ಷನ್ ಅಂತ ಬರ್ಲೇ ಇಲ್ಲ, ಅದು ಫೈಲೇ ಬರ್ಲಿ.
ತೋರಿಸಿರ್ತೀವಿ ಅವರು. ಮೊನ್ನೆ ಒಂದು ಇದ್ರಲ್ಲಿ 3 ತೋರಿಸಿದ್ವಿ. ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ ಇರ್ತದೆ 3. ಹೌದು, 2 ಸ್ವಲ್ಪ 2 2 ಇವರಿಗೆ ನಮ್ದು ನಿಮ್ದು ಆಮೇಲೆ ಕೊಟ್ಟಿಸ್ತೀವಿ. ತೋರಿಸ್ಲಿಲ್ಲ.
ಏನು ಇದು ಕರೆಕ್ಷನ್ ಆಗ್ಬೇಕಾ? ಏನ್ ಮತ್ತೆ ಕರೆಕ್ಷನ್ ಇದೇನ್ ಹಾಕ್ಬೇಕಾ? ಇಲ್ಲ ಮತ್ತೀಗ ಹೋಗ್ಬಿಡ್ತಾರಲ್ಲ. ಡಿಸ್ಪೋಸಲ್ ಎಷ್ಟಾಯ್ತು ಸರ್?
ಬೆಂಗಳೂರು ಬಿಟ್ಟು ಬೆಂಗಳೂರು ಏನು ಅಲ್ಲ 20 ಇಲ್ಲಪ್ಪ 19 33 ಹೇಳೆ ನೋಡ್ತೀನಿ ತಡಿ ನಾನು. ಹಾ 20 ಇದೆ.
ಆಫ್ ಮಾಡ್ಬೋದಾ?